Well, it's actually open to the public.
Morning. Thanks for being here.
Come on.
You're always welcome. All right, good morning, everyone. We are ready to get started from the panel side of things. We have Ms. Johnston back as our court reporter for today. Glad to have her back. Mr. Boring, when we stopped yesterday, Mr. Lane was on the stand. I see him back here. Before he comes up, is there anything procedurally you need to work through from your side?
I just didn't wanted to produce the hard copies of those memos we talked about, so I have those.
Please do.
Which memos?
They're not for you yet.
Oh,
Maybe.
Analyzing.
Thanks.
Are we on the record? We're on the record, yeah.
We are, but it's not your turn yet. Was there anything else, Mr. Boring?
no, Your Honor.
Okay. Mr. Lefkoe, good morning to Judge Coomer's team. Anything we need to discuss before we get Mr. Lane back on the stand?
A couple things. One, I want to put our attention on the record.
Can you get to the microphone? That'll help.
Yep.
Thanks.
Better?
Yeah.
Oh, it's on. Good. So I don't want to be in front of his computer. We want to put our contention on the record that if the portions of this chronology or whatever it is that's being reviewed are produced that they're not exculpatory and they're helpful to their case, we contend the privilege is waived or work product is waived
Okay.
as to the entire document.
So haven't looked at them at all. I know we've heard the term chronology a lot from the director's side. I think what these are would be interview notes that investigator Alford made and preserved in some way for his interview, in particular right now with Ms. Smith. That's what I think we're going to be looking at. I think there are 3 that we were given. But if anything should be unsealed, we need to talk about whether everything should be. So I'm not agreeing or disagreeing with you. I think you're putting a good marker down that if we look at this and determine that something ought to be shared, then we need to work through why would only some of it as opposed to all of it be shared.
Okay. And I want to make an objection I can kind of see down the road with respect to Mr. Lane's testimony. The scope of the formal charges in paragraphs 118 through 138 relate to specific transactions in the amended formal charges. It seems like we're going outside the bounds of those allegations. They were specific transactions. And now we're talking about meals. We're talking about El Nopal. None of that was in the formal charges. The expert disclosure as well said that he would be testifying relevant to the facts in the charges, not outside the charges, making new allegations or taking allegations that were withdrawn by the Campaign Finance Commission and trying to breathe new life into them here in this proceeding. The basis for that objection is beyond the scope of the expert disclosure, and it's a due process issue for our client in that we have not been given adequate opportunity to prepare to address all these additional allegations that apparently are going to be raised again by Mr. Lane on the stand.
Okay, so I'll let Mr. Boring respond in a minute. I don't think I've heard Mr. reference that famous restaurant yet. So you may, as you said, you're looking down the road, but nothing yesterday do I recall was Mr. Lane saying, "Oh no, Paul, what was going on with that charge?" If there is not, and I'm not remembering the details of all 36 allegations in the amended formal charges, but if there is not a charge in there that Judge Coomer allegedly failed to comply with campaign finance rules, regulations, law, because as an example, he would put on his CCDRs simply Amex bill and not blow them up into what they were, then it sure seems to me like it would be appropriate. I don't think it's happened yet, but you are forecasting what may happen. It would be appropriate for Mr. Lane to discuss, here's an example on, I'm making this up now, the December 2017 disclosure says Amex bill, $5,000. And then if there's a discussion about why that would be inappropriate, to get into, well, here's what's in the Amex bill. How are we at the Campaign Finance Commission supposed to know if El Nopal was a campaign meal or a family meal or a meal with Mr. Philhart to talk about how to get another loan? So I don't know how that's going to play out, but where Mr. Boring can help me respond to your concern, I guess would be to talk about how Amex bills fall within the ambit of the formal charges, because I agree with you that we ought not to get too far afield unless some of this might be in response to things your client said, in response to questions that the director asked him, because that is also in play as well. If your client is injecting into our analysis, let me explain to you why certain things happen and why I thought it was appropriate or allowable, or that was my read of the regulations. A response to that from someone from the CFC could be, no, here's why a scenario like that wouldn't work. I think that's perfectly within bounds if that's where the director's going. You and Mr. Boring may have had a discussion about where he's going, and so you know much more than we do about what's coming. And I appreciate you flagging it now, but right now I see a couple of bases in which it would be appropriate for those kinds of things to be disclosed. Again, we'll hear from Mr. Boring in a second. I think my counsel to you is going to be object at the time if you think we've gone too far afield, but you have helped the three of us know that there are minefields out there and you are going to jump up appropriately. So if you think things have strayed into that area, but push back if I'm missing something, because your binder is about 3 inches thick. And here's my summary of the charges.
It's actually just one page I'm reading from.
All right, well then we're equal.
Right, yeah. But the only things that I understand with respect to Amex that were alleged in the formal charges were Hawaii and Israel. That should be what all we're talking about with respect to Amex.
Okay, let's hear from Mr. Boring. Mr. Lane, you're welcome to stay standing because you're going to be sitting. You don't need to stay standing even though we're invoking your name.
Judge, as you know, as far as relevant admissible evidence, you're not wedded to, you don't have to put all your evidence in the formal charges, although this charging document has a lot more factual information than I'm used to.
It is robust.
Yes, robust is a great term. A lot of this, Judge, as far as if we're going down the trail of El Nepal and those types of charges with the American Express, obviously
Well,
that
pause for a second.
Yes.
Are you going down that trail? Because
not
was
that
it.
far down the trail. No, what we intend on talking about is the overarching amount, and this may come in more through Pat Salem, talking about the real crunching the numbers of the money that was spent on the Amex over those years, the amount that was paid from the campaign to pay off that versus the very few payments that were made from personal accounts. And in doing that, it's been interposed that, oh, he's intermingled funds. He didn't keep track of them. He put miscellaneous expenses. I paid a lot of personal funds off to pay these things. Maybe relevant in that regard to show, look, you're intermingling all these different things that could be personal, couldn't, but on your campaign report, you're putting miscellaneous expense when you're taking ostensibly trips that may or may not be campaign related. And so that is one of the, basically the evidence to rebut mistake or rebut that I made payments back when the referred to payments don't even match up to what they're claiming. So also as far as, and this isn't on the Amex, it's more of the other charges we talked about as far as what was in the bank records and transfers. And we do have in the factual basis, generally speaking, a description of him violating by not identifying or not disclosing numerous transactions to the law firm or to other places. And I think we actually put that in there that there were 43 different occasions. Now for the charges, we've tailored it to specific instances, but those all put it in context. So yes, you are correct. We're going to talk about, I do intend to go into the end recipient issues, but to boil it down, we're not going to go way down the rabbit hole on, okay, was Bojangles at 9 a.m. on a Tuesday morning for yourself? Is that campaign or personal? I do intend to go into some of this stuff, but we're not going to go too far afield of it and make sure we keep it relevant to what the charges are and either the intent and motive of the defendant or rebutting the defenses he has raised.
What is your response to the due process concern that Mr. Lefkoe raised, that the formal charges, they do lay out things in a fair amount of detail, and there doesn't seem to be a formal charge that would be the bucket into which you could pour testimony from Mr. Lane about, well, this didn't seem kosher either, doing this with the Amex, other than Israel and Hawaii?
I think from an evidentiary standpoint, all of that goes to the formal charges. What we've discussed, it goes to either the travel with Hawaii, with Israel, those type of transfers, the failures to disclose. So I think that is all motive, intrinsic evidence as well. And all that is not due process. It's all been disclosed to them. We've turned over a number of Amex records, a number of bank records. We've also turned over demonstrative evidence from not just Mr. Lane, but Pat Salem that goes into the different breakdowns of expenses and that type of thing. So I do not believe there's any type of due process violation. You know, we've been, not only have they gone through this with us, they've gone through it with the Campaign Finance Commission. And so I believe there would be no due process. It'd be like any type of indictment. You got a murder count. The evidence doesn't lay out all the different things that show the motive that are that intrinsic, but those are admissible to prove up or rebut a defense.
Okay. Well, I appreciate both sides' input. Mr. Lefkoe, we're on notice, and I think if things stray in the direction, and I'm adopting your thought process, that would be straying into an area that should, if things move into an area that you think qualifies as what you described, then at that time, I'd ask you to make a contemporaneous objection so we can process.
Yes, Your Honor. May I make one comment on what Mr. Boring said?
Yeah, is your microphone on? Is the
It is.
green light on?
It is.
Okay, we got a little feedback that it's hard to hear folks if you're viewing remotely, if you're speaking. If a speaker is not near a microphone, folks watching this remotely can't hear that speaker.
Fair. And I'm a terrible stage talker. So, so giving us Amex records does not give us notice that they're going to contend something is improper. Yeah, we have the Amex records. We had the Amex records. And the fact that the Campaign Finance Commission made charges and then withdrew them does not give us notice that the JQC in this proceeding is going to proceed and say everything we ever did in campaign finance is now subject to being reopened or discussed as something improper that Judge Coomer did. So that does not comport with due process.
Okay. Well, I think right now we've got a not completely defined picture for the panel. We've heard testimony from your client that there was a consent agreement that appears to reflect, as I understood the questions, at some give and take from both sides. So understanding why the CFC ended up doing what it did to reach that consent agreement, I think is where we've been going so far. We'll see how it unfolds. All right, and Mr. Lane, if you wouldn't mind coming back up here, you remain under oath from the oath that you took yesterday. And Mr. Boring, if you, which are you going to be using a device to share things, and which one?
Yes, I will be using the podium computer, but not immediately.
Okay.
And yeah, I'll just plug it in when it comes time, so we don't have to look at my
Okay.
silly background.
Okay.
Good morning, Mr. Lane.
Good morning.
All right, so still under oath from yesterday. We left off as we were turning to the issue of travel as it comes to campaign accounts, legislative duties and that type. So generally speaking, what are the rules as far as the Campaign Finance Commission about using campaign funds? Let's just start with official events or legislative purposes.
Sure. For using campaign events for legislative events or campaign purposes, those expenses can be allowed, provided the candidate or public officer is able to draw a nexus between those expenses and them either seeking office, retaining office, or executing the duties of their office.
And when you're talking about seeking office, that would be like campaign events? Like
Correct.
fundraisers, taking in money and then spending money on that.
An example of like seeking office or retaining office would be going to a campaign fundraiser, going to another official's campaign fundraiser, going to events to increase your name recognition and name ID. All of those have been deemed to be appropriate nexuses for authorizing campaign expenses.
And as far as aside from the campaign, but what were the other terms that you used about, I guess, executing the office you're in?
Sure, executing the duties of your office. People are allowed to use campaign expenses or campaign funds to help them execute the duties of their office. So for example, if you're hiring an intern to help you with correspondence, that's an example. But on the travel realm, for example, one of the cases that springs to mind is former Governor Nathan Deal expended campaign funds to go himself along with members of staff and some other state legislators to, I believe, New Orleans to look at a number of school system issues, because this was during the whole period of time where the Deal administration was pushing forward their like school opportunity district legislation. There was a lot of work between the Deal administration and the Campaign Finance Commission to ascertain exactly what events were going to be happening, who was going, the scope of that trip, to confirm for them officially that their expenses would be authorized.
And with that type of trip,
Mhm.
what is necessary for it to be able to say, this is a camp, or this is executing the office that I'm holding?
Sure.
I'm gonna object to that question. What's not clear is whether he's asking under statutes, regulations, or just practice of this agency.
Explain your answer and what the basis is.
Sure. The guidance that we provide to campaigns rests upon 21.533 subsection A, which is the ordinary and necessary expense provision of the Campaign Finance Act. We have further refined that with our case law. Under the Campaign Finance Act, all of the orders of the commission, whether they be consent orders or final orders after a contested hearing, serve as precedent. They have precedental authority in effect. So we have addressed a lot of campaign travel issues over the years, and that's what forms the basis of our guidance that we provide both unofficially and officially to campaigns.
You also have rules and regulations that govern the Campaign Finance Commission and your application of the statute and rules.
Correct. Whenever the statute itself is vague or unclear, our commission is authorized to promulgate regulatory rules and regulations, which we have done. Additionally, we have the authority to issue binding advisory opinions as well, which we've also done.
Just while I'm on the topic, did Judge Coomer ever contact you or your commission back in 2017 or 18 about trips to Israel or Hawaii?
Not to my knowledge, no.
When you're talking about these official trips, is there something you look at as to whether it qualifies regarding coordination with other governmental agencies, or what type of, I guess, trip this is going to be and what type of things the person will be doing?
The first analysis we look at is the purpose of the trip. We ask for the public officer to inform us of exactly what the trip is for and why are they doing it. And then they have to draw that nexus between their duties and what they're looking to do. Additionally, we will look at the length and duration of the trip compared to what the official duties are. For example, there was a case in which the commission had in which a gentleman went to New York for a fundraising event, which was perfectly allowable. However, the fundraising event was for one day and he spent over 1 week at that event. And we deemed that only part of that trip would be authorized for campaign expenditures.
Can't use one-day trip for a whole vacation.
No,
Okay.
that is correct. Our standard guidance to campaigns is that you get a travel day that is covered along as the day of the event. So that's 2 days. And then anything beyond that's not covered by official purposes, you have to pay for with personal expenses.
I make the same objection. He just said our policy is this, and he's not identifying where this policy is published.
So you're free to explore that on Cross if you're going to be crossing this with.
In a situation like that, Mr. Lane,
Yes, sir.
where you have a one-day event in
Mhm.
New York, but you're there for 7 days, how would the candidate or the publicly elected official go about apportioning what they could pay with campaign funds versus what they would pay with personal funds? In terms of, let's say, like the flights, you
Mhm.
have to fly up and fly back, whether it's 1 day or 7 days, there's just one flight.
Correct.
And so can they pay for the entire flight? Or would they have to apportion based on the number of days? they were there?
Yeah, well, no, we try and make it very easy for math purposes. If you are flying to New York, since you're going to take the flight, irrespective of how long the trip is, the entire flight is covered because you have the one-day event. You're not apportioning the flight itself. Additionally, if you're taking your spouse with you, because in that case, there was a question of, can I take my spouse? The spouse's ticket, if she's not participating in an official event or a campaign event. So for example, in campaigns, it's not uncommon for, there to be a spouse luncheon or a spouse breakfast or something. If that's happening, then her ticket's allowable. If not, the ticket is paid for out of personal funds. But then for like the hotel room, we have had some candidates who are very diligent and they will apportion the hotel room between themselves and their spouse. We don't require that. If you're going to have the hotel room anyway, You're not required to discount that your spouse is staying with you because you're going to pay the rate no matter who's in the room. So those are some examples of the apportionment that we all, then the other guidance we provide to candidates is for like per diems and food and whatnot. Your meals can be covered for the days of travel and the official expense, but personal days where you're just on personal time, you can't use campaign funds for. You don't get a per diem for those. Yes, sir.
Flight up.
Mhm.
On a multi-day trip,
Mhm.
which was only one campaign a day.
Mhm.
What about the flight back?
That would also be covered because even if you were just going for the one day, you have to go up and come back. Yes, sir.
While we're on that topic, I have a question too to cover with, so you talked about if the spouse is on the trip and is going to be there, do they have to be there for some official purpose or some related purpose, or can they just show up and go and then they get it reimbursed?
If the campaign is going to be paying for it, they have to have an official role or function. A more recent example of this was done by the Kemp administration. There was an official function in which the First Lady participated as well. But her participation in this event was because she is a member of a state commission and authority. So she had an official public officer role to go, and it was perfectly fine for those funds to be expended.
Did you have examples in the past where you talked about Governor Dill with his wife being very involved with the education system and that type of thing, being going along on trips or going to different things and it being appropriate to use campaign funds?
Yes, and that trip to New Orleans, Miss Deal did go on that trip, and her expenses were paid because, if memory serves me correctly, she was a former educator and would be able to provide kind of examples on what works, what doesn't work within the educational context.
But she actively participated in.
She did.
And did they reach out to you to talk to you and discuss this with you before they went on the trip and used these campaign funds?
Yes, there were extensive back and forth correspondences and discussion about what would and would not be allowed.
How about, let's just say for argument's sake, it is let's just say at least a hybrid or mixed use campaign trip. You do have at least a couple of campaign related or official things that qualify. Can you take your kids?
No.
You can't just have them come hang out like on a vacation or.
Well, I assume you could bring your kids. You
Oh,
can't
I'm
use
sorry, that was-
Campaign funds to pay for anything related to them.
That would be very correct, sir. The children are more than welcome to travel, but the campaign cannot pay for their hotel room, their travel, their flights, their per diems. You eat that cost.
Thank you, George. That was a terrible question. That's one of those I got in my head. I knew what I was talking about and it really sounded crazy. So yes, the kids aren't barred from going on a trip.
Correct. And an example of that would be our current Lieutenant Governor. Mr. Duncan is known for taking his family on his official trips, but he pays out of pocket for his children and for his spouse, but his expenses would be covered for those official trips.
All right. And so let's say you've got meals and I guess activities, recreational things that happen on these, even if it's a legitimate, the trip there for the candidate, doing things outside of that, the official act, can the campaign pay for those types of things? First for the candidate, separating meals versus recreational extracurriculars, then as applies to a spouse and children.
Sure. As far as recreational events, like for downtime where you're just entertaining yourself, none of those expenses, whether for the candidate or for the family, would be allowed as either ordinary and necessary or as a conversion event under subsection C of 21.533.
All right. So generally speaking, can a candidate, and this based upon the statute, interpretations of the statute, the rules, everything you've talked about, can a candidate, and what happens if a candidate decides to book a trip, pay for tickets, but does not yet even have a campaign event, and then tries to find a campaign event to justify it? Like, how does that work, and how do you analyze that?
Sure. We use that as an example. Basically, when we analyze it, it goes towards the weight and credibility of it being an official trip. If you make your travel plans and then are in a desperate search to find something to classify it as official, we look at it with kind of a jaundiced eye as that it's not an official trip. It's possible, but it's an uphill climb.
While I'm thinking about it, let's say you're going to Hawaii and you've already booked your trip and you're taking the wife and family. And then you try to find you're a state rep and you try to find somebody with a rural hospital to go tour it. Like, does that qualify as a campaign event to justify travel to another state or to Hawaii?
No, it would not.
And tell me about that, sorry, go ahead.
Maybe you were going there, but I'm curious why, let's say touring a rural hospital in Hawaii actually was germane to the public official's work because he was on the public health committee within the legislature. Are you saying if the tour had been planned and then travel arrangements are made, I get it that's probably the flow you'd expect to see. But if in the end, I go to Hawaii, I tour that rural hospital, and it's claimed that it's relevant to the legislative work I do, but I didn't secure those plans until one day before I got on the plane. I bought those tickets 3 months ago. Still declarable, or I can use campaign funds. You just might tut a little bit that you should have structured it differently, or no, you can't because you were just clearly trying to come up with a fig leaf for your vacation.
No, exactly. It's never a hard rule that just because you planned it out of the preferred sequence, that we would declare it unordinary and unnecessary. As long as you can show a legitimate official purpose, we will deem the transaction to be ordinary and necessary expenses and allowable. But we do look at the intent and motives behind what you're doing to determine whether it is a fig leaf or if you are really exercising your duties.
All right, and in that regard too, let's say you got this vacation, then you decide to try to set up something, and that thing that you try to set up doesn't actually materialize and you don't do it.
Mhm.
Do you get to keep that money?
No, we would
Or you get
require,
to not return that money?
no, we would require you to refund and return the funds back to the campaign.
And if that's not done, is that a violation?
Yes, it would be. It'd be a conversion event or a violation of unordinary and necessary.
How about if, let's say you have some campaign events, you end up using the campaign account to take your wife and kids, all of that. And then you basically use a campaign account, and then, the next year you refund, you pay back the kids' tickets with your personal funds, or pay the credit card off, or whatever it may be. Is that a violation of campaign finance law?
Yes, it would be a violation.
I'm going to object, and he's not been tendered as a legal expert. He's talking about the Campaign Finance Commission's practices, is what I understand. And the statute speaks for itself, and why this gentleman needs to say it violates the statute. Everybody can read the statute. So I object.
That brings up a good point, Judge. I did mean to tender. Mr. Lane is an expert in the field of campaign finance law and regulation of campaign finance conduct.
Okay, a reactive tender.
Yes. I noted that yesterday. I wrote it down and I forgot to go back and do it. So thank you, Mr. Lefkoe.
Okay, so objection is well placed. Check with the tendering of the possible expert. So table the objection for a minute. Do you want to examine this witness on his credentials, his background, et cetera, or do you have any other thing you want to say in opposition to having the panel identify Mr. Lane as an expert in campaign finance issues? And we'll get the wording right in a minute at this point, belatedly, but perhaps appropriately.
I have one question.
Sure.
With respect to your interpretations of statutes
Mhm.
that you're giving here, you're doing that based on your reading of the statutes, right?
Yes, the reading of the statutes and their application by the Campaign Finance Commission.
And those are all published materials in writing, right?
Yes, we are required to publish those findings by the commission from 2005 to present.
You understand you can't make ad hoc determinations as we sit here right now as to what the commission, your commission, Campaign Finance Commission, would do with a particular circumstance, right?
Correct.
And so if you're an expert on what the Campaign Finance Commission does, right? In practice, right?
Yes, sir.
You are not an expert beyond the scope of what the panel can do as to reading of the statutes, right?
Well,
Everybody can read the statute, right?
Everyone can read the statutes, but if you're going to delve into like campaign finance regulations, I'm in a unique position as I've drafted most of them. So, you know, if you're wanting to know the intent of the commission or the intent of the staff, I do have knowledge on that one because like I said, I drafted almost all of them.
You're saying you have knowledge as to the intent of regulations outside of what the regulations actually say?
If you have a question as to what did the commission intend when they adopted that rule and regulation,
I don't have that question.
I understand. I'm
Yes, sir.
posing if you had that question.
I object to this witness being tendered as an expert with respect to reading of statutes, which everybody can read. If he's going to be sitting here making ad hoc determinations, and it sounds like that's what Mr. Boring is asking him to do, make ad hoc determinations whether a particular circumstance would violate the statute, I don't think that's the proper place for an expert. The statute says what it says. We can all read the statute. We all heard what Judge Coomer said he did and why he did it. And the question of statutory interpretation is not for an expert witness to advise the panel on.
Okay, Mr. Boring, your thoughts, because it does seem from the evidence we've already heard that the statutes apparently aren't so clear and have resulted in much confusion and alleged misreporting of expenses and use of campaign funds.
Yes, and so part of this is to rebut some of those claims that have already been made. And honestly, I don't know what even ad hoc means in this context. I think just on the fly. His job is actually to advise and interpret these rules too. And so I think it's obvious when part of the defense is, oh, I didn't understand it. It does mean, well, I think there have actually been statements made by Mr. Coomer or Judge Coomer that, oh, the law does say this or does say that. And so this is rebutting that and explaining what it is. And he's actually available if people have questions to call and ask questions of. And I think this is very similar to, I'm not going to belabor it, the same similar arguments that we made regarding the objections to our ethics experts regarding the Georgia Rules of Professional Conduct.
Okay.
May I ask for one clarification from this witness?
Meaning you have another question for Mr. Lane.
Yes, I
I'm
suppose.
just not
Yeah.
sure if you're wanting
No.
Mr. Boring to explain something
No,
more.
I
or
think
Mr. Lane?
your point is well taken. Yes, I do think I have an additional question. I apologize for
Okay.
that. Are you here in your official capacity as counsel for the Campaign Finance Commission or as an independent expert?
I mean, it's a good question. I've not addressed it with Mr. Boring as to what my exact capacity is, but I am being paid by the commission to be here. So
And that brings up another issue in the consent order.
Stop for a second. When you say you're being paid by the commission, you're being paid by your employer?
my employer.
Okay.
That brings up another basis to exclude this witness on the issue, some of the issues he's testifying. The Campaign Finance Commission agreed to not take further action against Judge Coomer with respect to a number of the allegations that he's discussing here today. And he's here on behalf of the Campaign Finance Commission to take further action against Judge Coomer.
Okay, I'm not seeing it that way. He's providing testimony. The only one who will be taking action would be the hearing panel. And of course, that's merely a recommendation to the Supreme Court, and the Supreme Court will have the final say only after we've issued a report and recommendation, and then both sides have had a chance to critique the report and recommendation. So can you repeat again the expertise that you think this witness possesses that you'd like him to have recognized for?
An expert in campaign finance law reporting and what advice is given and how the statutes are interpreted, what is required of the campaign commission, and what is allowed and what is not allowed under the rules.
I think he is that. I will declare him that for purposes of this hearing. And most importantly, I find that his testimony along the lines that has been going, as I expected, will continue during your examination and the cross-examination, is very helpful for the hearing panel, not experts in campaign finance, anything, to understand what the requirements are, what the obligations are, and how the CFC has applied them as they have interacted with candidates and public officials who have been working through these issues.
Judge, is my objection overruled?
Yes.
Thank you.
One thing to clear up, just to make sure we're clear on the record, because I know you got bosses too. When you said the Campaign Finance Commission's paying you to be here, that's just your regular salary, right?
That is correct.
You're not getting a stipend to be here to testify for.
No, sir, just my
And
regular
we,
salary.
we actually sent you a subpoena and you were a fact witness in this case as well, correct?
Correct.
All right, so I can't remember where we even were, what question?
You had asked a hypothetical about travel, and was the official purpose in the official's mind before the travel was planned? It was going down that path.
Okay, and so, yeah, I think I'd ask at that point, well, this is where I'm going. You paid for a trip, ostensibly, you do have a couple of campaign events. You wanted to, you know, spend a business with, in another country with your state, that type of thing. But you take your kids in violation of campaign finance. When you use campaign finance or campaign account funds, is it okay to just pay that back like the next year?
No, you're not allowed to use campaign funds as a short-term loan for you to expend as you please and then to repay.
And on that topic, explain that about what is the difference between, we talked a little bit about it yesterday, like your campaign funds and campaign account versus your own personal funds and what that may be subject to, or, you know, as far as the public and the law is.
Sure. The way the law is written, whatever you do with your personal funds is your business between you and whoever owns those funds. We don't care. As far as your campaign funds, the way the law is structured, under 21-533, it states that your campaign funds are never the personal assets of you, the candidate, or your campaign committee. As such, you cannot use those assets as you see fit for personal expenses. The way I analogize it to new candidates is that your campaign funds are held in trust by your campaign, and you are restricted in using those funds for either campaign events, for reelection events, or for executing the duties of your office. And then once your campaign ends, you're further restricted on how those funds may be disposed of. You cannot just convert them at that point. Prior to 1989, you could. You were allowed to retain those funds as kind of your service bonus, for lack of a better term. But after 1989, you're required to donate the funds to other candidates or to a bona fide charity. And we have further tightened in recent legislation that the charity cannot be your charity or a charity on which you have an interest. It must be an independent charity from you, the candidate.
So we going specifically to Judge
Pause you
Coomer's.
for one
Oh,
second.
I'm sorry.
If you were a public official of one sort and had a campaign fund, became a public official of another sort, you're a legislator, then you're a judge. Can the corpus of your campaign fund move from one to the other? Or do you have to do these things you described, give it to a charity that you don't run or have an interest in?
When you have a candidate that goes from state rep to a judicial office, you are allowed to transfer funds from the state house account to the judicial account, but subject to campaign contribution limits. So you are able to contribute up to that maximum limit. And then any remaining funds are subject to that you must give to other campaigns, or you have to dispose of by donation, or there's a third option. We call it the Making Friends Pack. And you are allowed to convert your old state house account into basically a political action committee and change your reporting schedule. And then you may make donations to other candidates to help you in your election bid.
But if you had 50,000 left in your state house campaign fund, not all of that could go to your now I'm a judge fund.
Correct.
Whatever the limit is, doesn't matter.
Yeah.
It could go, everything else needs to be disposed of in the ways you described.
Yes, sir.
Follow up with a question along those lines. You have a campaign finance checking account.
Mhm.
As a representative.
Mhm.
You then become a candidate for judge. Choose not to open a new checking account. Is the conclusion is that the only amount that could remain in that checking account would be the amount that you could legally contribute to the judge campaign?
We give the advice that the best and highest practice is to open a new account. And if not, you have to engage in what's called separate accounting. You have to maintain two sets of books to show us that your state house account has X and your judicial account has Y in the same account. So you're not, it comes, it's called the option of separate accounting. You're allowed to elect that, and it's an example of how you can raise money for a primary and a general and a runoff election. We don't require a separate bank account for each one of those elections. You can do separate books, like accounting books, and then have one account with segregated funds within it, if that makes sense.
But any residue fund in the, I'll call it the rest
Mhm.
funds, checking account, the maximum that could be used in the judge campaign account would be whatever the legal maximum contribution that would be allowed.
Yes, sir, that is correct. You could use up to that maximum limit, and then that would be the end.
So one last question.
Yes, sir.
No.
Did I understand you correctly? For now, did I understand you correctly, that is never appropriate to use campaign funds for your kids' travel?
Unless there is a limited exception where they are engaged in an official activity, which I've yet to see.
Okay, so even if they're attending the event, that's not part of they are not part of the event?
Correct.
All right, thank you.
And two questions piggybacking on Mr. Winter's question. So are you supposed to use, just under your advice, and I'll ask you a follow-up about that. Are you supposed to use, if you've got a bank account, you're using that for your campaign for state rep, you go to become judge, should you keep using that same bank account?
No, we always maintain that you should open a new account, one for each candidacy that you're doing.
And even though Judge Coomer did that, did y'all ding him for that at all?
No, we didn't.
Okay. Same thing with the other question about the questions about donating money, moving money from your state rep to the judge account. Did Judge Coomer go above the campaign limits on that as well?
I'm gonna object to that. That goes precisely to the objection that I made at the beginning of this. They're trying to establish additional things they say Judge Coomer did wrong without putting them in the formal charges. It's an issue of due process for my client. We're not prepared to defend against things that he's just thrown against a wall here.
It was involved in everything that was included in the campaign finance evidence that we did. And the purpose of this is to rebut the theory that everybody's just going after Judge Coomer. It's showing that, hey, there are things that were like, we did not, it was raised about, we're trying to get nickel and dime every little thing that's happening, or the campaign finance commission did. They're talking about the consent order, what was in there, what was dropped. This is an example of something that they decided, even though technically was a violation, they did not either charge him with or really do anything other than tell him not to do it.
Okay, but I'm gonna ask you to move to a different area. I mean, you've gotten that point out through the question about
Okay.
Not changing accounts, which came up through our questions and not Mr. Boring's questions, meaning the panel's questions. But for now, let's stay away from, hey, is this another thing that you as an expert would say Judge Coomer did wrong on the campaign finance front, but you guys didn't fuss at him for that?
Right.
Your point is understood that the CFC was selective in its approach, and there may be a different point of view that we'll get through cross-examination about how.
That's right. And there may be more of this covered, and I'll bring it, note it when we get to discussing the consent agreement about what was in there originally, what was dropped, what was not executed. But that, I think that's a different topic, and I will stay away from what we just discussed. Thank you.
Okay. I assume whoever keeps passing you guys notes is not a witness that you're going to be calling.
Oh, absolutely not.
Okay.
Ready. So let's talk about the trip to Israel that Judge Coomer took in 2017. Now you were presented with, I guess you saw the financial records, you looked at the American Express records, the campaign account records. Did you also review evidence, emails, pictures, and things of that nature provided by Judge Coomer and his counsel when you all were addressing this trip?
Yes, during our audit and investigation, we asked the Coomer campaign for evidence related to any official purpose on the Israeli trip, and that was provided by counsel.
All right. And are you familiar, who all went in Judge Coomer's family on this trip?
From what was represented to the commission, it was Mr. Coomer, his wife, and his, I believe, 3 children.
And did the financial records that you saw reflect the same amount of tickets purchased for travel to Israel as was represented as who went on the trip?
The expenses did line up with what was told to us as who went on the trip.
And so on this trip, I mean, I won't belabor the back of it. Were you presented with emails where he had been in discussion sometime before they actually purchased the tickets about events?
Yes, there were a number of email chains that were presented to us between Mr. Coomer, his assistants, and economic development and representatives like the Georgia Beverage Association.
So on a trip, let's say that you have at least, we'll just say you've got a tour, you've looked at well, let me strike that and regrade it. You looked at the records, you're familiar with 2 tours he took of facilities in Israel relative to the beverage industry.
Yes, I believe one was with the National Bottling Association located within Palestine, and then there was some kind of technology authority in Tel Aviv, I believe was the other one.
With that, and let's just start at that point. If you're purchasing tickets for travel, who would be, well, okay, let's say, first of all, if the wife and kids, if the wife did not accompany him on those trips, what would be allowed?
For
The money traveled as far as just the flights.
May I ask for clarification? Are you asking what would be allowed under the statute or what he personally would allow? And that the second part I would object to.
Is everything that you're testifying to based on the statute, the rules and regulations, and the interpretations of the Campaign Finance Commission?
yes, it's not based on my personal opinion or preferences.
So you can now answer the question.
Sure.
Why don't you ask the question again, though,
Okay.
because it was a little unclear
Okay.
which trip wife is going on, to Israel writ large or to beverage facility tours?
It was a poor question.
It was a great question, just tweak it.
Okay. Okay, Mr. Lane, let's say the family is going with Judge Coomer, and Judge Coomer alone is going to these 2 events. What would the campaign account be allowed to pay for?
The campaign would be allowed to pay for Mr. Coomer's flight there and back, as well as per diems for the days in which he actually had official functions.
And you say per diems, like, would he be able to spend whatever he wants on meals, or is there a limit?
What the general guidance we provide is that the per diem is the same as what the General Services Administration allows for per diems. If I remember correctly, the current amount's like $95. Now, of course, we don't limit the hotel room to that per diem, that the per diems for food and what have you, incidentals, I believe is what they call it. Whereas the hotel room would be permissible for that day.
And so any other hotel rooms, if it's not the travel day or the day of the event, hotel room, even for the candidate, is not allowed.
Correct.
Now, let's say the wife attends on those 2 occasions as well and goes to the facilities. Would that necessarily be allowable and make the campaign, okay for the campaign to pay for her flights? And does that depend on what her purpose is?
It depends on what her purpose is. If she has an official function with the campaign or with the delegation, then the expense is allowable. If they are literally just accompanying the candidate or public official as a companion, not allowable.
Okay, I'm going to turn your attention to, well, we've talked about the flights being purchased. Were you, in reviewing the records, were you aware that campaign funds were used to purchase numerous things on the Israel trip involving recreational things, meals, hotels, rental cars, all that kind of stuff?
Yes, sir. There were a lot of expenses for food, for incidentals, tours. I'm trying to remember exactly which account it came out of, but there were cash withdrawals,
And when they arrived on this trip, were you provided an itinerary by Judge Coomer and his counsel about what they actually did each day on the trip?
Yes, sir. We were given a synopsis of what each day contained and what the alleged official events were.
I believe this has been admitted as Exhibit 238. I looked up there to try to locate it and could not. I will put it on the screen now. And I'm going to go through it with you and ask you about these specific events and how that would be allowed or not. On the itinerary provided by Judge Coomer, it says that the 23rd of September 2017 was the travel day. As far as campaign funds, the flight and whatever accompanied that travel day would be, Judge Coomer would be fine as far as per diem, all that type of stuff.
For
Hotel.
his flight, for his meals, for his incidentals, yes, those would be allowable if he had an official event.
And we'll kind of skip ahead a little bit. Were you given any information that his wife was actually involved in some official capacity on any of these tours, or that she was merely accompanying?
Our understanding is that she was a personal companion and she simply accompanied.
Sorry, I was gonna object and it was too.
All right, so on the 24th of September, we see here the travel to Tel Aviv for a meeting at the Bridge, this technology incubator we talked about before. 7 hours on official functions and stay. Based on your review, the emails and what you were provided in the, I guess, your analysis of the law, would this have been an allowable type of event for Judge Coomer?
That's a tricky question in that there were a lot of discussions internally with the commission about what we would agree to as an official event and what we would not agree to as an official event.
Mhm.
So
For this specific situation, or in general, when you're working through a concern about how a candidate used funds to cover travel?
with this specific case in mind, and we discussed it at length, we had very extensive negotiations with Mr. Coomer and his counsel regarding what we would deem official and what we would not deem official. So
Well,
Yeah.
without going into the details of that, is this one basically that in your analysis, tie goes to the runner, it's close enough, it's allowable?
it could be allowable.
Does it matter how long the function was? Judge Coomer indicates he was there 7 hours. If he had been there 2 hours instead of 7, but it's still an official event, is it, other than it shouldn't be a 2-minute official event?
No, you're correct, and that's how we analyze the event. We are not going to break out a stopwatch unless it's not going to pass the smell test of, you can't say it's an official function in which you did a drive-by and then skip it out.
Wave to the bridge, that's not enough.
Yeah.
Okay.
So on that day, why it doesn't appear anybody else attended. So he's good for that day. How about the rest of the family?
No, the family would have no official function.
September 25th, 2017, you got Judge Coomer traveling to the Syrian border to observe the border while present, observing active military exercises. Later the same day, a business owner discussed with him how to expand his business into Georgia. His wife was with him on that day, and it appears they were out and about for 9 hours. First of all, obviously Georgia has close ties with Israel, has a relationship. Would that okay this type of scenario being an official campaign funded event while in Israel?
No, and the reason I say no is because you would have to be able to tie it to your official duties. Just because you happen to be a public officer does not convert all of your acts to an official function because you go. You must tie it to your duty. And that's one thing that we ask of candidates when they present these trips is, what official duty or function did you perform? How can you tie it to the duties of your office?
And does it help if you're going through, I guess, the government of wherever you're going or some official agency?
It does help if an agency helps arrange those trips.
If you just kind of do it yourself or you set something up with a family member, is that what you were talking about, or is that something different?
No, that's an example of a factor that weighs against it being an official trip.
And you're aware from your investigation of the case and analysis that Judge Coomer's brother and sister-in-law lived in Israel, the Palestinian area of Israel. He lived somewhere over there and worked in a school. You were aware of that?
Correct. I believe they worked in a Christian school that was in like Beit Jala.
Again, so that day for Judge Coomer, would that be an allowable day?
No, sir.
Okay, how for the wife and kids?
No, sir.
September 26th, 2017, while in Caesarea, Israel, sure I butchered that. He met with Israeli Defense Forces and discussed the Israeli-Palestinian conflict, including security concerns in the West Bank. Again, his wife was with him. That was about an hour that day. He called it a legislative meeting. That description to you, is that an official event that would allow campaign funds to pay for it?
No, that description alone would not be enough.
Did you get any further description that would have okayed that one for campaign funds.
No, there was no additional information provided by the campaign.
September 27th, Judge Coomer attended a tour of the Jerusalem School Bethlehem campus, met with students, teachers to discuss challenges of Christian education, meeting American standards in the West Bank. His wife was with him on that occasion. And just assume for the sake of what I'm asking you, the kids were always with his wife. Is that an official, as far as your analysis in this case, was that an official function?
Hold on.
I'm sorry.
My objection is, I'm renewing my objection. He's just making ad hoc determinations as to whether specific instances comply with the statute or don't. And that is improper for an expert witness to do. He's not even referencing a statute. He's just saying, like, putting his finger in the air and saying the wind's blowing west. So that, I don't think that's the proper function of an expert. And I object.
So who would you call? I don't mean the name of the person, to help educate the panel, because this is a charge. This is part of a formal charge. How did Judge Coomer use his campaign funds in connection with the trip to Israel? And this itinerary your client created, and in it, he is saying, this was a legislative meeting because I talked to some Israeli Defense Forces guys about the Israeli-Palestinian conflict. Who on planet Earth would you call in here to help us understand if that's a sufficient justification for that day to qualify as those expenses? That's a proper use of campaign funds.
Nobody, because I would never put an expert on the stand to testify about opinions about what a statute, how a statute applies to a specific circumstance. That's not proper. He's just, the statute says what it says. This is the itinerary. What he considers ad hoc to be a violation based on his reading of the statute is irrelevant, because that's not what's before the panel. But what's before the panel is, did he violate the law? And he's not identifying the law every time he's talking about this. He's just saying, well, this one, I would say no. What?
So
why is that the proper?
before the panel is whether Judge Coomer violated the Code of Judicial Conduct, and in particular, with connection to the trip to Israel, whether some of what he did impacted the public's view of the integrity of the judiciary. That's what we're deciding, not whether he in fact violated the campaign finance laws. There are other aspects where that may come into play, but as you've read the formal charges as we have, most of what we'll call the alleged incidents are addressed in several different ways through the CJC, the Code of Judicial Conduct. And not all of them are, hey, that was a violation of the law. Some of them are, the way you allegedly did things, Judge Coomer, calls into question the integrity of the judiciary. Why is it inappropriate for us to hear this type of testimony when that's what we're evaluating? We don't need to find that, in fact, he violated it. We need to find, well, would these steps that were taken or weren't taken, do those call into question the integrity of the judiciary?
Because he's not an expert on the integrity of the judiciary either.
And has Mr. Boring asked him, hey, would you find, Mr. Lane, that these steps that Judge Coomer took or failed to take call into question the integrity of the judiciary?
Was that a question, Your Honor?
Yeah, I'm asking you, did you hear Mr. Boring ask Mr. Lane that question?
And of course I didn't hear him say that, because he didn't ask that.
Didn't. That's my point. Overruled.
Thank you.
And Judge, just for the, Mr. Lane, are your analysis of this, is this based on the statute, the rules, and the law?
Yes, sir. It's based on an analysis of code section 21-533 subsections A and C.
All right, so I think we've answered the issue on the 27th of September, so I'm going to move on from that. The 28th of September, now this is an event that Judge Coomer attended at the Capitol of the West Bank, the administrative Capitol, meeting with National Beverage Headquarters. And this was some of those events that were set up by economic development and other pseudo-official government-related agencies. This thing that he describes here, as far as touring the facilities, giving official gifts, that type of thing, because he had a gift from the Department of Economic Development. Is that something, when you analyze it, that's an appropriate day to count as being available to use campaign funds?
Same
Don't
with,
answer yet.
Same objection. I would like a continuing objection to this line of questioning to that so that I don't interrupt his examination.
No, I appreciate that. And you do, I think you preserved it. I think we've got several more days left on the itinerary. I expect we're going to hear similar questions. And it's noted that you object to, in other instances as well, this witness offering an opinion about whether a certain scenario or alleged conduct violates not just the statute, because we've now heard this many times, but the regulations, or is it inconsistent with what Mr. Lane has referred to as the case law of the CFC, my term, which would be their orders and their formal opinions. So I understand your focus has been violation of the law. This person shouldn't be telling us about that. But of course, it's a little richer than that. Is this consistent with or violative of regulations and the amassed case law of the CFC? But your objection stands, and we deem that it applies to any other questions of this nature, Israel or Hawaii, because I assume we're going to get to Hawaii. I assume that will be a little more streamlined because there's not an itinerary like this. Right. So you waive nothing. You may want to renew it when we shift to Hawaii, but even that won't be waived. I think you have flagged this as an issue, even when you objected to having this witness declared as an expert.
And might I have that continuing objection also applied to the law firm transactions?
I guess let's see how those flow.
I can re-raise it. That's
Okay.
fine.
You only need to do it one time.
Okay.
All right, I think I had asked you about September 28th, 2017. I don't believe you gave an answer yet.
Correct.
But is that something you would have considered for Judge Coomer, an official event that would have been an allowable campaign fund use designation?
Yes, we analyzed both the summary and the additional evidence presented and deemed that to be an official trip.
Can I ask why? What's the tie between this tour and his official duty?
The tour was arranged by the Georgia Department of Economic Development in coordination with the Georgia Beverage Association. Additionally, it was blessed by a state agency in which they provided official gifts for Mr. Coomer to provide to an official. My understanding is that the National Beverage Association is an authorized bottler of the Coca-Cola Company, which has extensive ties with economic development and their international operations. So it wasn't a stretch,
What's good for Coke is good for Georgia.
more or less.
I don't think we got an answer to the September 17th or September 27th tour of school. I think there was an objection for you. Was that an official campaign event?
No, sir, they're not from that summary, and there was no additional evidence provided about that tour.
Thank you.
And would it make a difference depending on who set it up? If it was a state official or if it was his brother?
It does make a difference as to, is it a state sanctioned event or is it a personal event that you're trying to deem to be official?
All right, so we've talked about the 28th. So how about his wife did not accompany him that day and the kids did not, obviously. So would that day be allowable for them?
So I think
sorry.
you don't need to keep, we get it.
Okay,
That if
got it.
the wife is not present in an official capacity, that's not a day for which the per diem applies to her. And the kids never, ever, because there hasn't been a scenario yet, maybe it would be a kids dance cultural exchange, not this case.
I think one of the biggest faults of my week here is that I keep forgetting I don't have a jury here. So that point well taken, and I will move along. Thank you. September 29th, 2017, the designation and itinerary shows traveling to Jericho in the West Bank, meeting with a Palestinian couple who are Georgia citizens. They discussed matters concerning Palestinian Georgians living in the West Bank. That same day, attended a dinner with a Georgia citizen whose husband is a Palestinian citizen, discussed life in the West Bank for their family. And on that day, wife was there with the kids, 7 hours function. Is that an allowable expense with campaign funds?
Based on that summary, no, and no additional information was provided, although it was requested.
September 30th, last day before, I guess, travel back. The itinerary has that Judge Coomer met with a Palestinian business leader in Bethlehem and discussed challenges of doing business in the West Bank. Again, provided an official gift from the state of Georgia. Same day, purchased souvenirs for staff, donors, political contacts. Also took a driving tour of the Palestinian side of the Israeli border wall and to agricultural sites, and then left Israel. Again, on that day, the wife and kids were with him 5 hours. Was that an allowable day?
No, it was not.
And why is that?
Once again, not arranged by the state, not arranged by any kind of government official or organization. It was simply a summary in which we had no corresponding documents or evidence to back up the summary. In our analysis of this summary, we only considered the beverage trip and the Tel Aviv Authority to be officially sanctioned events.
Understood.
Is there anything in the work you do that makes something an official gift of the state of Georgia versus gave him a Braves hat? I'm not suggesting it was a Braves hat, but that phrase is used in two situations. And in the one that fit in, that was a day that we did deem to be official business. You mentioned the State Economic Development Authority and this and that.
As far as I understand how the State Economic Authority will do it, they will give you the official gift for what they arrange, but they also give, for lack of a better term, like keepsakes that you can kind of like pass out as well. They're kind of de minimis gifts, you know.
I cannot hear what this witness is saying.
Okay, well, we had a cough at the same time. If you could just repeat.
Sure. My understanding with the way the Economic Development Department arranges the official gifts, they give you the official gift for the function that they've sanctioned as happening, but then they also give you additional like keepsakes that you can hand out. So from my understanding, there was an official gift given to the National Beverage Association. We had no evidence of any other gifts being provided to anyone else. And we did ask for that information. It was not provided.
All right, well, Mr. Lane, we'll move ahead to the Hawaii trip. And again, yeah, I think this may be much more abbreviated. You're familiar with and have looked into the purchases for tickets and travel and meals and that type of thing in Hawaii for their trip in September into October of 2018, correct?
Yes, sir.
And the trip again was purchased, everything was purchased on that American Express card that he mostly used for campaign purposes and paid off with campaign funds, correct?
Correct.
Okay. Now, this trip in particular, when he actually purchased the first tickets, did he ever have any type of official thing planned?
No, my understanding is
I'm going to object. This calls for hearsay.
In your review of the records and any information you were provided, did you have any information that he had actually had anything planned before he purchased the tickets?
You're all right with it phrased that way?
I don't like it, but it's okay.
All right, you can answer that question.
Thank you, sir. After reviewing the bank statements, the credit card statements, as well as the email chains that were provided to us for the arranging of the trip, the travel was planned and purchased prior to any official trip being formulated.
Had they even had discussions about any trip before he made the purchase to Hawaii for himself and the kids?
Same objection. Calls for hearsay.
Based on your review, did you have any evidence or provided anything that he had made any attempts to even have an official visit before he bought the tickets, or was it after?
No evidence was provided to us that there were discussions beforehand.
All right, let me ask a question about it. You can word expenditure.
Mhm.
Is the date of the expenditure the date that the American Express card was used, or the date in which American Express was paid?
Sure. The date of expenditure is the date that you use your card and use your card to pay the vendor. So if you're paying Delta Airlines, it's the date you buy the tickets, not the day you pay American Express.
And kind of a follow-up on that too. Are you allowed to, let's say you purchase tickets for an event, you've got, let's say you have a legitimate campaign event. Are you allowed to not pay that back until after you actually go on the trip? Like pay, let's say you use a credit card. You use a credit card in June, you pay for the trip, you use campaign funds to pay for it. You know, now I got way off track with that. Okay, now I know what I was going to say. Are you allowed to purchase basically, let me scratch that all. I got way off track on that, and it was going to be more confusing than it's worth.
Back to Hawaii.
Back to Hawaii. Yes, back to reality. Okay, so Mr. Lane, in that case, did you see where, or provided evidence about Judge Coomer then trying to schedule some type of visit to tour a rural hospital in Hawaii?
Yes, there was email chains between Mr. Coomer, various assistants, and then I believe Kaiser Permanente as to arranging a trip to a rural hospital. There were two hospitals. There was one Mr. Coomer wanted to see, and then one that Kaiser Permanente was willing to provide.
And within that, were they ever able to firm up any type of tour?
No, they were not able to firm it up, and I believe the trip was canceled.
Did he ever go on any tour or anything in Hawaii while he was there with the family? Or was it provided?
Same objection.
So you don't have to keep doing this. Over your objection, Mr. Lane was, excuse me, declared an expert. So in some ways, he's offering expert opinions. When he does, he can rely on hearsay, just laying that out there. But your question wasn't, in your opinion, X, Y, or Z. So what is your response to the objection about?
Before the objection, I was trying to say with what you were provided or something of that nature. Was there evidence provided that actually showed that?
And you've asked it that way a number of times, and Mr. Lefkoe said he didn't like it so much, but he's not objecting to it. Can you have this witness, I'll ask Mr. Lane, this evidence you're relying on, is it evidence that information that you're relying on and that the CFC was relying on, is that information that Judge Coomer's team submitted, so you got it through Mr. Chalmers, or is it evidence that the CFC obtained through subpoenas, or what's the origin of the materials you rely on to answer a question like, was there ever a trip to a rural hospital during Judge Coomer's trip to Hawaii?
Sure. The information comes from documents provided by other state agencies, which they received by subpoena, documents that we received via subpoena, as well as documents provided by campaign counsel.
Campaign counsel meaning
Mr.
Judge
Coomer.
Coomer's lawyer. Okay, all right, overruled.
So based on that, I think my question was, did he ever go on any type of tour of any hospital or any official business while in Hawaii?
No, during our discussions with Mr. Coomer's campaign, it was agreed upon that there was no official trip to Hawaii. It was canceled before the trip occurred.
Okay. If, let's just say hypothetically, he'd actually gone one day on a tour of a hospital in rural Hawaii, from trying to coordinate something with Kaiser Permanente, would that have been an allowable official event that would permit campaign funds to pay for it?
Under that hypothetical, Mr. Coomer would be authorized under 21-533 subsection A and C to spend for his plane ticket to and from Hawaii, as well as for his hotel and per diem for that tour.
And once, let's say if he really had this set up and actually had it firmed up, then he got back and realized and it had fallen through, what would be his duty and responsibility?
He would be required to reimburse his campaign for his plane tickets as well as his hotel and per diem because there was no official function that occurred.
Is the reason that you think that if that tour had occurred, it would have been an official event? Is that because it was set up through a Georgia contact, or?
It does help in the analysis that it's a Georgia contact. It was through the Georgia Office of Government Relations through Kaiser Permanente. If I remember correctly, I believe Mr. Coomer was involved in a number of things dealing with healthcare and other issues. So there's a rational basis that it relates to the duties of his office.
All right. So in this case, did you determine that he had, was in addition to the initial purchase of the flights for himself and the family, did you also find that in August he had actually purchased 7 different purchases of upgrades for the 5 family members?
Yes, we noticed that there was an initial purchase of tickets. Upon our analysis, it looked like they were either purchases for the basic economy or the next rung up on the basic. And then right before the trip, there was an upgrade purchase to Delta for either going from basic, whatever the most basic is, to the next level up where you can pick your seats, or from that one to Delta Comfort, whatever they call the step between first and economy. So that's what we noticed.
And also, did you note that he had made numerous purchases paid for with campaign funds on the American Express for meals and those types of things for himself and the family?
Yes, those were all contained.
Are we talking about Hawaii, just Hawaii?
Yes.
Then I don't have an objection.
And let me pose another hypothetical to you. Okay.
Before you get to the hypothetical, I'm just going to New York, clear official purpose. I want to fly first class, and I use my campaign funds to fly first class.
Correct. We tell our folks in our trainings that we are not the arbiter of you doing the best and highest use of your funds. We are to determine whether you're doing ordinary and necessary expenses. So if you want to go first class and stay at the Royal Suite, you're free to do so, and you can take that up with your campaign contributors when you need more money. But we just care if it's official business, and if it's ordinary and necessary. Prudent expenditures are not our remit.
I'm not required to take Greyhound to get up there.
That's right.
I could do Delta Business One or whatever. It's called.
You can get the lie flat seats, and we've actually had candidates who have used fleets of limousines to transport their staff to their events, and so we're fine with that.
But you would have to disclose that on your
It-
disclosure.
That candidate properly disclosed all of those expenses to the chagrin of their contributors.
So, yeah, so while probably not the best for public confidence, it's not a violation of the code of or the campaign finance laws to do that.
Correct. It is not a violation of the Campaign Finance Act to travel in style.
Got it. All right, so if you've got a, let's say, like in this case, where you've got, did you recognize where in October after the trip that Judge Coomer reimbursed his campaign fund $1,031, which amounts to the $311 tickets, and then one of the main $998 tickets?
Yes, there was a transaction, which I believe was listed as reimbursement.
And that you can see that on the account.
Yes, sir.
Well, first, since there was no campaign account, were any of the tickets allowed?
No, they were not.
So just paying back 4 of the 5 initial ones would not be okay.
Correct.
Also, how about just, waiting those months from purchasing it and then paying it back later? Does that excuse paying for the kids or your wife?
No, it does not excuse the use of campaign funds initially to purchase those tickets.
The upgrades, any campaign account reason or allowable expense for those for Judge Coomer and his kids and his wife?
No, not based on the facts presented.
Same thing, meals, no allowable expense.
There was no allowable purpose that was presented to us for the Hawaii trip.
All right. I'm going to turn to, I think, one last issue before the consent agreement. As a Court of Appeals judge, did you find something concerning looking at his reporting back from his report end of December 2019 going forward until, I guess, the reporting date was April 30th, 2020?
Which allegation does this relate to?
The fake loan.
Okay, I dispute your characterization of it, the extension of credit, but I don't object.
Loan/line of credit. That's where we are now.
LOC. Got it.
Okay.
Yes. Okay. And what did you notice and what occurred?
When we audited the Court of Appeals account, we did notice that Mr. Coomer disclosed a loan in the amount of $50,000. If my memory serves me correctly, it was listed as occurring on December 30th of 2019. It was disclosed by Mr. Coomer on his December 31st, 2019 campaign contribution disclosure report, and then redisclosed again on his January 31st, 2020 campaign contribution disclosure report, as well as his April 30th, 2020 disclosure report as well. And if I recall correctly, it showed a repayment of that same $50,000 loan right after the general election for judicial officers that occurred that March.
And do you remember the date of repayment that he had listed? Was that the last day of qualifying?
I believe.
I'll show you the exhibit in a minute.
I believe so.
So first of all, let's talk about that. Did you look back and review his bank records or all his financials to see if there was in fact any movement from his personal account or any other account into the campaign account in the amount of $50,000.
Yes, we looked through all of his personal business and campaign accounts and saw no movement of $50,000 to constitute a loan.
And did that concern you?
It did. We actually alleged it as a violation of the Campaign Finance Act in our prosecution, Mr. Coomer.
And why did you do that? I mean, it's obvious, but.
We viewed that since there was no evidence that there was a loan or a line of credit or sufficient assets to justify that line of credit, that it would be a violation of the Campaign Finance Act.
Now, when you've got these forms, do candidates often make loans to themselves?
Yes, it's very common for new candidates to make loans to themselves to get their campaign off the ground.
And generally, what types of scenarios, what avenues do they have to do that? To be able to loan themselves money or that?
The Campaign Finance Act authorizes candidates to take out normal conventional bank loans. They're allowed to take out normal loans through insurance companies, other investment brokerages. But the standard that most people do is they use their credit card. They either obtain a campaign credit card or they simply use their own personal credit card.
And this is a new topic, and I renew my objection with respect to his ad hoc determinations of what's allowed and not allowed under the campaign finance laws.
Okay. Just so the record is clear, because you're wanting to make it and preserve it. We're talking about how your client's case and allegations played out before the CFC. Now, this is not a hypothetical. This is the $50,000, whatever we're going to label it. So articulate, I think you should articulate more fully why it's not appropriate for someone who was part of the to and fro with your client and his lawyer for that to help us understand how the CFC viewed this alleged transaction.
Irrelevant, unduly prejudicial. The undue prejudice outweighs whatever minimal relevance it might have. It's other act evidence.
But it's not, because I guess that's the part I'm missing. The line of credit is one of the allegations in the formal charges. So it is squarely before us. Hearing what the CFC, it came before us because it was an issue that your client had with the CFC. So I don't know how it's unduly prejudicial, certainly not good news for your client, but none of the formal charges ought to be, or we wouldn't be here. But how's it not relevant?
And let me take that. We have a statutory basis as to why this whole thing is not the issue that he portrays it as. So saying, I respectfully dispute the characterization that this is bad for my client, that this extension of credit is bad for my client.
But the allegations that it was, I'm not reaching any conclusion, and I don't think we decide whether it violated CFC, but the allegation that it violated it is I don't think, a welcome event.
Sure. What I'm saying though is I'm in the Hawaii and the Israel context. I made this objection and I said, when he's making ad hoc determinations of what is permitted and not permitted under the statute, that's not a permissible purpose for an expert. You granted me, thank you, a continuing objection to that line of questioning and those questions on those trips. I want to renew that objection. I think I know the likely result of that objection and what the ruling probably will be, but I want to make it clear that my objection applies to this line of questioning too.
Okay, understood.
And
overruled but preserved.
May I be granted and impose on the panel to grant me a continuing objection to this line of questioning on that basis?
Yes, sir.
Thank you.
Okay, Mr. Lane. So we were talking about like this, the line of credit loan thing and how candidates actually can do their, can take out loans and loan their campaign money. So I'm going to turn first to was what he, first of all, assuming that there was actually some internal line of credit in his head, versus then we're going to turn to what the other evidence showed to rebut that. Okay. So first of all, is this allowable what he did as far as if you say you have a loan and then you have no proof whatsoever and there was no loan, is that allowed? Can you
I object to that statement within that argument within the question.
Which,
Where he said there's no proof whatsoever.
So you're asking a hypothetical.
And well, actually based on what he's been provided, but yes.
Then it's an improper hypothetical, not based on facts.
Said it was facts. Judge, my argument is he's going to have him subject to cross-examination
Right.
to explore the deficiencies if there are some.
Overruled.
Okay, Mr. Lane, let me reset, ask again. Okay, so with, first of all, can somebody just put a amount of a loan that was never made on a campaign finance commission CCDR and then report that you paid it back with no money actually transacted or changed hands?
No, under the requirements of 21.534 subsection B, that governs what information you are allowed and required to put within your disclosure reports. There is nothing contained within that code section that permits you to put in numbers that you feel are appropriate outside of what's factually in existence.
So you can't just say that you made yourself a loan, but you did.
Correct. You cannot just say you made yourself a loan. You cannot say that you have a certain balance on hand that does not exist.
I think you testified that you looked at all the records and found no money changing, going from campaign account to, or into the campaign account or back out in the end, correct?
That is correct. The campaign account, if memory serves me correctly, remains static at about $72,000, but the campaign disclosure showed cash on hand in excess of 120.
On that point, is cash on hand really supposed to be what's in your bank account on that day?
The way our government accounting works, it's supposed to be what funds you have on hand and that you're able to use.
So you can't, like, if you're posing a hypothetical, let's say you're a super rich person running for office and you got $1 billion in the bank. Can you say I've loaned myself $1 billion because I have that money. I haven't committed it, but I really would if I got asked to spend some.
It actually has to be committed to the campaign. It cannot just be a promise that I intend at some point to spend as much money as I can.
Right. And in this case, just specifically, I handed you 3 CCDRs, exhibit, I think 1, 9, 1, 10, and 1, 11. Just looking at those, were those the CCDRs you looked at?
Yes, 109 is the December 31st, 2019 report. 110 is the January 31st, and then the 111 is the April 30th.
And on the 109, the December of 2019, is that the first date in which the loan was disclosed that it had been made to the account?
Yes, that's the first date that it was self-disclosed to the commission that it had occurred.
And how did that change the cash on hand as it was represented on that CCDR? How did it change the amount that he had appearing to have cash on hand before and then after this purported loan?
It increased the balance from its stated 72 to 124,935.
The next exhibit 110, that was, I believe, was that a February filing?
It is the end of the January 31st report, which is filed in February.
And on that, did it reflect the same thing, that a loan had been made, that had been something that had brought in, and that it was still cash on hand, money on hand that he had to spend in the campaign?
It was a continuing report showing that a loan had been made in a prior report and that no transactions related to that loan had occurred.
And the final exhibit 111, is that one that where he reported the repayment of the loan?
Yes, he reported a loan repayment. Forgive me. Should be in here. Yes, he reported a loan repayment and it was reported as being repaid March 6th of 2020 with a purpose of retire debt.
Let's talk about a couple of things. Okay. Let's take the argument that, okay, now in hindsight, okay, it was a line of credit, which there is nothing documenting that whatsoever, except somebody saying, yeah, I was going to do that. I was going to give myself my campaign money if need be. First of all, are the drop downs, do they have something saying line of credit in one of the drop downs on your reporting, CCDRs?
No, these reports were created with the old filing system, which was retired earlier this year. There is no drop down that says line of credit.
Are there ways if somebody wants to say that this is actually a line of credit, they can? And how does that rebut the claim that in this specific case that, oh, I really was thinking and really genuinely wanted to contribute $50,000 to my campaign?
You would have two abilities to do that. Contained within the loan, contained within the entry creating the loan report and its retirement, you have the ability, once you pick the drop down, you have a free-form text box where you explain the purpose of the transaction. So where you see where there's the typed in retire debt, that is physically typed in by the candidate or someone operating on the candidate's behalf. That is not a drop down. So you could explain it there.
Well, let me stop you right
Sure.
there. On that note, with Judge Coomer specifically, when he disclosed in 111, he actually had to go in and type in retire debt.
Yes, sir.
Was there any debt that he had that was retired?
Not that we saw now.
The other option, if you think it's unclear and you're not sure about how to describe it, is there another option?
Sure. On this older system, the last box that you have to go through when you're filling out your report is box 9, which is the addendum statement, which is a free form text box where you can type as much as you want. There is a pagination limit. I think it cuts you off at 4 pages. But you're allowed to explain every transaction you want to identify and explain to us with additional information of this really was transaction X. I had listed as A because I had this problem, but it really is this.
Get some very wordy candidates that you have to read their responses.
Oh, yes, some actually hit the text limit and then ask us for additional ability to respond, which we can accommodate.
All right.
Mr. Lane, you said this earlier. I want to go back to real quick. You said there's no evidence of the loan, and there's not sufficient assets
Mhm.
to, I guess, support any potential loan. Did y'all actually look and determine that there were not sufficient assets in Judge Coomer's personal accounts to be able to make such a loan?
Based on the records that were provided to us, we did not see them.
You did not see,
The sufficient assets. We actually calculated to see what he had on hand to see if he could actually meet that line of credit.
In the new system, is line of credit an option for that would be a contribution? If I loan to my campaign, that's a contribution. That's where I would put it. Am I using the right terms?
No, and this is where in our trainings, we explain a contribution to your campaign is a sum of money you will never expect to be paid back. It is a donation directly to your campaign, and that's the end of the matter. If you are doing a loan, you have to report that, because now it's just 3 sections you're filling out. You have contributions, expenditures, and then you have loans. And then you would show that any money you want repaid to you as a loan to your campaign. And then within that section, you disclose the terms of the loan, how much you're making to the campaign, when you repay it, the transactions related to it.
And is that area, is it all free text or does it have drop downs?
It's like the old system in that it has drop downs with suggested entries, but it does have free form ability as well.
Any suggested entry line of credit?
No, sir.
We were talking about the funds. If say Judge Coomer had an investment account, $200 some odd thousand, but you know why we're here. And those were things that were contested, or loans that he had taken from somebody else that were at contest at that time. Would that impact your analysis too about the credibility of using that as campaign funds?
Don't answer yet. Mr. Lefkoe, hypothetical question.
This is way outside the bounds of what any statute, regulation, guidance, opinion, or anything provides. Anything that this witness could add is just his own personal opinion based on facts that are presented that are untrue by Mr. Boring.
Well, we've already established, I don't know about the untrue part, but we've already established that we're not accepting his personal opinion. We're getting his opinion based on the expertise he has. So overruled.
Using your example, we would not count those as assets because there was a separate claim on them. Using normal accounting practices, they'd be considered a doubtful account that wouldn't be subject to being an asset.
Regardless of that, putting that aside, even if he had those campaign funds, would this still be a violation of the campaign finance law?
Yes.
And while we're on that topic, so I know you ended up entering into a consent agreement with Judge Coomer and his attorneys on the case, correct?
We did.
I think you have it up there in front of you. I think it's 218. Is it 218?
Pause for 1 second. We were just mapping out when we're going to take the morning break. And you had forecast, you were at one point going to get to the consent agreement. Are you doing that now?
Yes.
How much more topic-wise do you have with Mr. Lane beyond the consent agreement?
Other than that, I think I've got one brief exploration of one page and a demonstrative of Judge Coomer's. That's it.
Demonstrative of.
It's one that's already been entered. And so we've gone over it. I'm just going to ask him his
Meaning a demonstrative you've received from Judge Coomer's team.
that's our, yes, that we've already used with another witness.
Okay.
Correct. And that'll take 2 minutes.
But the exploration or discussion of the settlement agreement, that'll take a little bit.
A little bit, yes.
Okay, then let's break. It is 10:38. Let's try to be back at 10:50, 10:50 to continue with the direct examination of Mr. Lane. Thank you. Go back to mute that thing. Go back to orange.
Oh, yeah.
And then got
I can
Shane.
see that.
the hearing.
Not talking too fast today, am I? Not
This
going too
was,
fast.
this was pretty, this is a super, pretty much. There's no take anything in this. Do me a favor, hand me that stapler. I'll hand it back to you so you can put it back to. Want to use that?
Johnson, you ready? I think we'll finish pouring our water and we'll be ready. All right, we are back. Mr. Lane is still on the stand, still on direct, but I think we'll get close to the end of that, and then we'll see about cross-examination. Mr. Boring.
Thank you, Judge. Mr. Lane, we started going into, we're going to talk about the consent order. Do you have that exhibit for you, 218?
Yes, sir, I do.
Okay, specifically, before we get into the details of what's in the consent order, I want to ask you about what may not be in it. Regarding what we had just talked about, the claim that a loan had been made to the campaign, did you, first, did you all charge them, Judge Coomer, with that as far as claim that it was improper? And then B, was it included in the consent order? And if so, why? If not, why?
We did charge the inclusion of the loan as a violation of the Campaign Finance Act, and we did that in the second amended complaint that was filed against Mr. Coomer in 2021. As far as it being included in the consent order, that issue was withdrawn by the commission, and we did not include it in the consent order as a term of punishment.
And why did you not, did that mean that you do not, that y'all did determine that he did not violate the code or the campaign finance commission, campaign finance laws, or was it done for some other purpose?
No, in that instance, we had extensive negotiations with Mr. Coomer's counsel about a resolution to the case. We did it a little more unorthodox than what we normally do, where we came to an agreement as to the actual civil penalty amount. So we agreed on the $25,000 civil penalty issue. And then we began negotiating the underlying transactions as to whether they would be a violation or not. When we reached the issue of the loan, we were unable to reach an agreement as to how we would word that. And we made a decision internally as the prosecutorial staff to withdraw it, simply because the amount of fine that we could justify and attribute to that was not worth the continued litigation of pursuing it. The maximum civil penalty we could impose would have been $1,000. And we figured that the $25,000 civil penalty for the other violations outweighed that one transaction.
So, and kind of a couple of things working
Sure.
through my mind from doing criminal work for years. So basically you reached like in a criminal case, you got the sentence you want to get to, then you're figuring out what charges to use within the indictment complete.
We did. We got the sentence we wanted, and then we horse traded how we got there.
So effectively, it would be like you've got, say, felony murder based on 3 different felonies, and you pick one of the felonies, not 2 of the others.
That would be a good analogy.
Or with a domestic violence case, you've got several hindering apprehension, you got family violence, regular battery, and then you just settle on which type of charge.
Correct.
So is it still your position, based on your analysis, that this act violated campaign finance law?
Yes, that would still be my position.
I'm going to object with respect to he's standing here in the position of an official member or a staff member of the Campaign Finance Commission, which promised to take no further action on that allegation in the consent order. And now he's saying it's my position. The Campaign Finance Commission has no position here and cannot assert that position here, and they're stopped from asserting that position.
Judge, I've called him as a fact witness, and I'm getting him to analyze what the facts are.
So I'm going to cut you off.
All right.
As I understand it, the Campaign Finance Commission was adamant that the phantom loan violated the Campaign Finance Act.
Right.
As part of the negotiations, they stepped back from that. That's what I take from the testimony. I don't know that we need to go further than that.
Was that testimony stricken, Judge?
Well, he didn't answer that very last question. If he did, it's stricken.
So, Mr. Lane, going to the rest of the consent agreement, again, with determining how you came to this consent agreement. Basically, when you agree to something like this, does that mean necessarily that the facts didn't happen or the acts didn't occur?
No, just because we reach an agreement doesn't mean that it changes the facts.
Did you come to any agreement within this document regarding language you were going to use specific to certain statutes or levels of intent based upon negotiations with Judge Coomer's counsel?
In discussing it with counsel, and as counsel knew, we are not required to show intent. We have strict liability statutes, so we don't allege intent within our documents. There is a statement contained within the consent order that states that the commission did not allege an allegation of intent, which is a factually true statement that we didn't allege one because we aren't required to.
Right. So basically, you didn't try to prove something that wasn't necessary within your document.
Correct. We are not required to prove intent, and we do not seek to prove intent.
Let's go through what did Judge Coomer agree to in the consent agreement?
May I review it just for?
Yes,
just for a
absolutely.
second?
That's why you got the document there.
Okay. Okay. Well, as far as what he agreed to, the overarching civil penalty was a $25,000 civil penalty to be paid, which has been paid.
Okay. And is that a public filing, this consent agreement?
It is. It's a publicly available filing.
And is that the largest fine that you've had at the commission or you've seen for a judge in office?
It is the highest fine for a judicial officer. Yes, sir.
So go ahead with the consent agreement about what the terms were you came to as far as you have the fine and it's a civil penalty, correct?
It is a civil penalty.
As far as your commission, what can you all do do you have the ability to exact, let me rephrase that. What are the sanctions you can have on a candidate for violations?
For violations of the act, aside from statutorily imposed late fees, if there are late disclosures, for the first violation of the Campaign Finance Act is a maximum $1,000 civil penalty. For a second subsequent act of the same class, it's a maximum $10,000 civil penalty. For a third and subsequent violation of a similar class, it is $25,000 for each one.
And can you all do anything just like other than fine people and make a public finding? You can't throw anybody in jail or charge them with a crime or anything like that, right?
We can't throw anyone in jail. If we do find issues that rise to a criminal level, we are able to refer those to the proper prosecuting authority for criminal action. The only other issue we can do is we can seek injunctions and other extraordinary writs to enjoin people from certain acts.
Can't have anyone removed from office either.
No, sir, we can't have anyone removed from office.
And you all regulate not just judicial candidates, it's every candidate in the state, I take it, for state office.
We do everyone from governor to city council members and everyone in between. The only people we don't regulate are the presidential and vice presidential candidates, the members of the U.S. House and Senate.
I'm going to actually go through, I think, did you, within this, that is irritating. Did you, in preparation for talking about the consent agreement, do you have within that demonstrative we've already admitted, have explanations for just summarizing the violations agreed to and what was
Yes.
done? Okay. I'm going to.
Which demonstrative?
Don't remember the number. Check.
That in front of the witness?
It is about to be.
This is a different PowerPoint than the one you gave.
It's the same one.
So it's the PowerPoint from yesterday.
Yes, it's actually 260. I'm sorry. Should continue. I only got to the slide yesterday, so this is finished.
That was one you didn't have an extra copy for me of?
I emailed you the copy the day before.
Can I just see it? I'm sorry. There's so many things. Different places.
Keep it, don't lose it.
You're not admitting this.
It's already been admitted.
You admitted 260?
Yeah, it's a demonstrative.
As a demonstrative. So it's not, I mean, my understanding of demonstratives is it's not in evidence.
Correct.
I know this is a peculiar thing. I mean, you guys are the jury and the judge who considers demonstratives. So
Right. I mean, it'll be made part of the record. I guess the distinguishing thing would be that we wouldn't be relying on 260 as proof of anything because it isn't in the record as evidence. So we would need to independently confirm, but it's based on what's on the screen, what 21.533A says.
understood. Thank you.
You're welcome.
All right, you've already talked about, we discussed, I think, at length, the issue of ordinary and necessary expenses versus what doesn't qualify. So I'll move along to the next slide, because I think as we're getting into this, I don't think we've gone deep into the requirements of the regulations on payment by credit card, mere conduit, and end recipient. So on this slide, I've got rule 189.3.04. Can you tell the hearing panel about that and what that rule and regulation actually says and how it's applied?
Hold on one second.
I'm sorry.
Yes, sir.
So this goes to my prior objection, and we were sent this regulation on Saturday. I didn't know it existed. I hate going in the administrative code, would never have searched for it in a million years. I'm sure Judge Coomer said the same thing. We were not notified that the commission until Saturday of the week before trial was going to be saying that there was a violation of the reporting requirements for Amex expenses. So pursuant to my previous objection, I moved to exclude that testimony and to, I guess it's an objection to this line of question.
Does 189-3-.04 appear anywhere in the consent order?
I'm not sure, Judge. I know this is just like, it's a rule that applies and it's public record. It's like citing OCGA or this or that. Additionally, it was raised during the deposition of Mr. Coomer, Judge Coomer, when he started claiming that he had actually, because we've alleged that he did not disclose it. And this goes to the fact that saying miscellaneous expenses for Hawaii and Israel are, somehow he reported it by saying miscellaneous expenses. So this is merely going into the definition and the regulations on what payment by credit card requires an end recipient.
So I'm understanding the objection in part, I think. There's nothing wrong with you having this slide up on the screen. It is, assuming that's what 0.04 says, it's a public record, no issue. Are you going to be asking Mr. Lane if certain things that are now in the record, the CCDRs and an Amex bill, when you match them together, is there a violation hidden in there? Because what it says on the CCDR is Amex bill, $4,000 miscellaneous, but we see the Amex bill, there's nothing miscellaneous about it. There's some things that maybe would be personal or be pretty hard to allocate to the campaign. And then there are things we've learned, apparently El No Paul would be a campaign related thing as opposed to a family or personal I have to eat thing. Right. So where are you planning on going with Mr. Lane?
I plan on getting him to explain what the requirements are. And I'm not going to go further into asking him to opine specifically on specific expenses. I think that's more for closing argument or for argument to the hearing panel.
Okay, so if that's what we're hearing from Mr. Lane, why does your lack of knowledge of the regs that are publicly available, or even more so, your client's lack of knowledge of the regs that applied to the way in which he was to report his campaign expenses, why is that a prohibition on the panel learning about how it ought to work?
Judge, the year of my mom's birth is public record. It doesn't give notice to Judge Coomer or to me. He's going to be prosecuted for an act that's a matter of public record or a regulation that's a matter of public record in this proceeding. And so we were not notified of this. And the question for the panel is the panel going to be considering whether Judge Coomer violated the law based on alleged violation of this regulation. I mean, that's a question for the panel. It's not in the formal charges. And it's something they brought up at the last meeting.
Judge, it is the statute that is in the formal charges that talks about requiring disclosure and about the fact that he did not disclose certain things. This is the law as it applies to how you disclose relevant to that statute.
I understand. Very different from Mr. Lefkoe's mother's date of birth, which doesn't govern Judge Coomer's conduct as a candidate.
Yes, sir.
I appreciate the distinction. But I also appreciate Mr. Lefkoe's repeated concern that Judge Coomer is before us, the hearing panel, for these 36 formal charges, not something different. And I don't believe in the 36 is you failed to itemize the Amex miscellaneous entry on your CCDR. If it is in there, then have at it. If it's not in there, then I think you need to be somewhat circumspect so that your argument to the panel in the end isn't, and another reason that you should be concerned about whether, of course, we need to stay grounded, did Judge Coomer violate the Code of Judicial Conduct, not 189 3.04, not our call. But we need to be focused on the conduct behind the charges and not parallel, arguably related conduct. I know you're going to say it's intrinsic, but if that's not what was alleged, we have to guard against saying, well, we're pretty frustrated with how these credit card expenses were reported or underreported or insufficiently reported. If that's not something that we should be focusing on. So that I'm doing a bad job of articulating what Mr. Lefkoe's concern is. I think it's a fair concern. How are you not bumping into that concern by asking Mr. Lane, well, tell me about what Judge Coomer did wrong, my words, not yours, with the way he dealt with the Amex bills.
And I'm going to tailor this specifically to asking him about this application of using the credit cards, and it specifically ties into his expenditures of alleged in the formal charges as to the trip to Hawaii, the trip to Israel, and the fact that he didn't report it.
Okay.
But I will not go down the rabbit hole of start arguing you should find that he's violated the Code of Judicial Conduct because he had, Armando's Italian one night, and I think it's personal versus campaign. If I do, I will get an objection and it should be sustained. May I continue?
You may.
Okay, thank you. Okay, so there are specific rules in addressing candidates for office using credit cards.
There are, yes, sir.
And why is that necessary?
It's necessary because there was a period of time in which candidates were not disclosing the end recipients that are required to be disclosed. Because the way the code is written in 21.534, you have to disclose who the ultimate end recipient is. There was a period of time in which there was confusion as to what that meant. And you would have candidates that would say, I paid American Express, and this is a hypothetical, I paid American Express $20,000. And then there was no, well, who did you pay with the American Express? The American Express is a financial tool. It's not the ultimate end recipient. So we promulgated the rule which requires that you have two ways in which you can disclose those transactions. You can disclose the transactions directly that you paid with the American Express and just leave out the fact you paid American Express. That's an allowable way of doing the reporting.
For instance, let's say you pay like a bill.
Correct.
And you pay with American Express, but you disclose it directly, like I spent $430 on this bill.
Yeah, if you said I paid Bob's T-shirts $400 for campaign T-shirts, we don't care that you used American Express to do that. That would be allowable.
So we're doing exactly what we were just talking about. He's talking about what's allowable, how to report Amex charges, and
He is in this, if this ties into how your client handled Amex bills for Hawaii or Israel, then it seems to be squarely within not one or two, but many more of the formal charges. And currently we're dealing with hypotheticals. I haven't heard about Bob's T-shirt business until now. I'm not linking that to anything Judge Coomer did. So
he's talking about what an allowable way to report under this, and presumably he's going to say it wasn't done in an allowable way.
presumably he will say that about Hawaii and Israel, which you've been on notice for years.
not that it was a violation of the regulation, that it was unordinary or unnecessary expenses. That's what we've been on notice of.
Noted.
The allegation that these were unordinary or unnecessary expenses. So is my objection overruled?
It
Judge?
is.
Okay, we were talking about Bob's T-shirts.
Sure.
Is that actually a place?
No.
Okay. All right, go ahead and instruct. What is the other way to disclose it?
The other way is that you disclose that you paid American Express, but then you are required within the reporting to break out the individual charges that make up that payment to American Express. So if you said, I spent $20,000 on American Express and there are two transactions, you would say that I paid my campaign consultant $10,000 and then I paid, the campaign sign vendor $10,000. You would list those vendors, the date, the amount of that transaction, and the purpose, the campaign purpose. And then that has to add up to the amount of money you paid to American Express as a campaign expense. It's called credit card reporting in recipient, and both the old and new system allows that functionality.
I'm going to go to the next slide talking about, is end recipient defined in the rules and regulations?
It is. It's contained within the definitions of the regulatory rules at 189-2-.01 subsection 8.
Okay. And how is it defined?
It's defined as the person or entity actually providing the goods who received payment for those goods.
All right, so now getting to summary of the allegations, the violations of the statute that you all had in the consent agreement. Go to the next slide. Will this slide help you explain to or describe to the hearing panel exactly what transactions that you guys reached an agreement on and that you all had alleged he had violated?
It would.
Okay. Can you go ahead and explain to the hearing panel?
Hold on one second. Yes, Mr. Lefkoe.
Now we're talking about allegations that are these just the ones that are in the formal charges? Or are these
Yes,
outside?
we in the formal charges, we described 43 different transactions that he failed to report on his campaign disclosure. This then goes into other ones specific to other formal charges and other allegations, not just the general 43, but specific failures to report between the law firm and the campaign.
These 21 are part of the 43 or in
Yes.
addition to?
These are part of the 43, Judge.
So that goes to notice within the charges. I mean, if he's just saying general 43, there are Hawaii charges, there are Israel charges, and then there are specific transactions set out in the formal charges. My reading of those was that he was documenting what at least the categories of these quote 43 are. If he's saying that he had in his head, there were an additional bunch of transactions which are not documented or set forth specifically in the charges, that's not notice to Judge Coomer. It's not like we can send Charles Boring an interrogatory and say, what are the 43? And we couldn't take his deposition in this case. So how is that fair notice to us if he's just going to say, well, I had 43 in my head. They don't relate to the specific transactions. Some of them don't relate to the specific transactions set out in the formal charges.
Judge, we actually provided them with the consent, with the formal charges and the agreement, which laid out specifically which transactions were those, and they encompass the ones that are included in the formal charge.
The consent agreement between Judge Coomer,
Yes.
his lawyer sitting here in court behind the rest of the lawyers, and the CFC detailed the 43.
Yes, he's been on notice, a long time.
So overruled as the notice. And just so we're clear on the record, the paragraphs in the formal charges, it's not the specific formal charges, the prefatory paragraphs where that language about unordinary and unnecessary personal expenses, that language is in there, paragraph 129, and a couple others. But also in there, it is alleged that Judge Coomer failed to disclose these expenditures, disclosure being identifying the end recipient. So I find that Judge Coomer and his many lawyers have been on notice for many years, either through the formal charges as amended or the 43 different itemized issues and the 21 transactions that look like they're pulled directly from the consent agreement into which Judge Coomer entered with eyes wide open and upon advice of counsel.
May I have a continuing objection to those types of questions outside of the bounds of the specific transactions within the amended formal charges.
Yes, it's going to be hard to keep track of all your continuing objections about things for which you claim you didn't have notice, but you may. So insofar as someone can follow all this on appeal, you have a continuing objection in that space as well.
Thank you.
Judge McBurney, just to make sure I'm clear, it was paragraph 129 in the formal charges that you referred to?
That was just one, yes, but there are several that do include that phrase about unordinary and unnecessary expenses, but it's a conjunctive and failed to report. And that's the language that I'm pointing to that might have, I think should have, but might have put one on notice that it's not just needing to justify if one's combating that allegation that the expenses were ordinary and necessary, but also the way in which they were reported.
Understood. Thank you for your clarification.
All right,
I think that, I'm
sorry.
sorry. I think that language repeats itself because that language related to either Israel or Hawaii in 129, then it repeats itself in the subsequent paragraph for the other trip.
Yes, sir.
All right, Mr. Lane, so we went through the fact that this would help you describe the agreement you reached. Could you please now describe to the hearing panel, tell them relevant to this slide, what was the agreement, what did he admit to for your consent agreement for campaign finance purposes?
After negotiations, the parties agreed to a consent order in which Mr. Coomer agreed that there were 21 distinct transactions of failing to disclose those transactions on his campaign contribution disclosure reports. I broke it down further into the transaction types. There were 17 transactions between the campaign account and the law firm that were not disclosed on the campaign contribution disclosure reports. Those transactions totaled $18,350 worth of transactions back and forth. There are an additional 4 transactions not disclosed between 3 different persons. Of those 4 transactions, the total was $2,870 and some change. The majority of those transactions were to Ms. Kay Smith.
Would you say failed to disclose, you mean the amounts were disclosed, but maybe descriptions were not appropriate?
The
Or-
entries were completely absent,
So 18,350 was not disclosed at all.
not at all.
So would that impact, I guess, the amounts like cash on hand in those calculations?
Yes, sir, it would.
Thank you.
And also, you talked about the K Smith thing you've got, or delineation you have on the PowerPoint. Those dates, October 29th, 2018 and November 1st, 2018, those kind of bookend the last day of, or next to last day of Judge Coomer's term as a judicial candidate, and then the first day of his term as a full day as a judge.
That is correct. I believe he was sworn in on Halloween.
Okay, and you reminded me with your answer there about the failure to report the transfer from out of the campaign is when something is transferred or sent into the campaign, maybe transferred back a week, a day, 2 months later. You also have to report that transfer back.
Yes, you have to show all transactions coming into the account and all transactions going out of the account.
Okay, going to the next slide, talking about unordinary and unnecessary campaign expenses now. Can you talk to the hearing panel a little bit about that?
Sure. The remaining violations that were agreed to by Mr. Coomer were violations of Code Section 21533 subsection A, which is the ordinary and necessary expense provision of the Campaign Finance Act. We broke down those transactions after negotiations to show that it was an improper expenditure of $10,458.58 in campaign expenses, which were the payments to Ms. Kay Smith in the amount of $3,258.58, and then $7,200 in expenses from the campaign to the law firm.
And then did you also, within the agreement, discuss and come to an agreement on the travel regarding Israel and Hawaii?
We did. Those were the final terms that we agreed to. Also violations of 21533 subsection A. We agreed upon an amount of $6,658.55 in total, with $2,687.78 attributable to this trip to Israel, and then $3,970.77 attributable to the Hawaii trip.
And did you come to those numbers just in negotiation?
We did. We negotiated the underlying transactions and came up with figures that we both could agree to.
All right. And you spoke earlier about doing an audit regarding Judge Coomer's finances as far as over the term
Mhm.
of your investigation, looking at not just the campaign stuff, but generally the law firm. Did you create, you know what, I'm just going to go to the last slide on this one, get you to explain what it shows and what you were talking about.
Sure. What we did is an overarching income versus expenditure audit, and we annualized it. One of the reasons we do that is although we're not required to show intent, we sometimes look at intent to help determine the level of punishment that we mete out onto a candidate. It also helps us when we do an audit to see if we can identify patterns, because everyone in their financial life has a pattern and course of conduct. For Mr. Coomer's case, what we noticed is that in 2015, he ran a positive year. He had more income than he did expenses. When you look at preceding years, you see the drop in his income, but there is not a corresponding percentage drop in his expenses. They remain relatively flat or increase, but his income does not. It continues to decline, and he has to dip into campaign funds to make up the difference of the expenses. He runs an annualized deficit of about 6%, and that does not change. But what does change is the course of his income and that deficiency with what he makes up with campaign expenses. So the blue is personal income supplemented with his law firm income. The green is campaign finance funds utilized, and then the red, of course, is expenditures. And then we noticed in 2019, Mr. Coomer balances his books when he ascends to the bench.
Now, with the final resolution, you talked about the civil penalty.
Mhm.
Is there a difference between a civil penalty and a fine?
It's the two sides of the same coin.
Final thing, looking at these donations to the Atlanta Volunteer Lawyer Foundation, can you explain what that is, why that is, what happened?
Sure. It's not uncommon when we resolve these cases, we do not want to leave a candidate with additional campaign funds. So it's not uncommon for us to require that any remaining campaign funds be donated to charity. And generally, we pre-clear with the opposing counsel what charity will be receiving those funds. It is also not uncommon that instead of having a candidate reimburse themselves for unnecessary expenses, we just have them go ahead and donate money to charity directly. So we're cutting out the middleman of put money back in your campaign account just to turn around and donate it to charity. We just say, go ahead and donate it to charity. And that's what you see here.
Okay, and in Judge Coomer's case, did they actually make two donations to the, Atlanta Volunteer Lawyer Foundation?
Yes, there was a $5,000 donation made after the complaint was filed, and then there was a subsequent $2,000 transaction that disposed of the remaining campaign funds.
2,000 negotiated, that was part of the outcome, or that just happened?
It was part of the negotiations and the outcome that represents the remaining campaign balance after all ordinary expenses were paid.
So the 2,000 came out of the campaign fund. Did the 5,000 come out of campaign fund or Judge Coomer's money?
I believe the 5,000 was personal, if I remember correctly.
Would Judge Coomer have claimed a charitable tax, whatever the term would be, credit, exemption, deduction for that?
Yeah, well, if it came from personal funds, yes. If campaign funds, no.
Right. No, if it came from personal.
If personal funds, you would be entitled to charitable deduction with the IRS.
Can I ask you about the 7,000? So did y'all determine how much money was left to be reimbursed to the campaign at the end of your audit? And was it some figure, was it $7,000 or was it some figure other?
It was a figure slightly higher than that, but we negotiated down to the transactions we would be willing to agree to.
So the $7,000 is what y'all negotiated as needing to be reimbursed to the campaign through contributions. Thank you.
And just to be, I think it's obvious, but this 7,000 reimbursement, this wasn't something Judge Coomer just independently for the investigation went back and reimbursed improper fees or anything like that. This was after they talked with y'all.
Correct. These donations all occurred after he was sued by us.
I believe that's all I have.
Lefko?
Yes, sir. Have exhibits. Might as well take off the exhibits. That's history. Ready? Sorry.
I had one other, I just saw this, I had one other question. I can wait until Mr. Lefko's done. Or
Why don't you just
whatever.
wait? He's situated.
Yeah, I'll do that. Sorry.
Sir.
Not yet. Are you about to tender some?
Yes, sir.
Those are exhibits. And then someone's amended formal charges.
Ready for the number.
We're ready.
319, 324 through 328. Oh, actually through 334. Oh, make it through 350.
350?
Exhibit 23. $359.
You don't sound so certain about that one.
360 and 359. Pamela, is 358 in this stack? Let's see with the witness. I think I may have overcopied. We just had.
It doesn't have an exhibit sticker, so I'll just leave it there. It's not mine.
Now, this is what had been handed to me.
324 to 335 though.
I can put them on the board.
Maybe we're,
In lieu of the originals, and we can track down the originals when we get them. Fair?
Did you provide three sets? Yeah.
I did. There should be. It's not 3 sets.
No, we'll work through it, but it's a collection of different things.
Okay. We'll fix it on our end, but I've got electronically, I can show the witness.
I want to get it clear on the record. 23,
Yeah, 23, correct.
trying to do it in numerical order. 23, 319, 324 through 350, and then 359 and 360.
And let's add 358 as well.
Okay, so 358 to 360. Mr. Boring, any objection to the admission of 23, 319, 324 through 350, and 358 through 360? Assuming you've had a chance to figure out.
I've
what
only,
those are.
I got to 23 and I'm perplexed. Probably my fault about why an email from Jim Philhart to Deborah Conley, who's his former admin in 2015 about the guardianship is relevant.
Because it mentions Deborah Conley is at the Capitol that week.
Deborah Conley's not a witness.
So you don't back and forth like that. Why don't we do this? When
I'll
we
hold.
get to 23, you could raise an objection as to relevance or whatnot. Again, this witness, well, maybe this witness has seen 23, but we need to avoid what happened with the previous witness where the witness is a conduit for things that ought to come in through Judge Coomer or someone else. But for now, no objection to that universe of exhibits, subject to revision as you get a chance to look at that long list that was provided to you.
Yes, it looks, I don't think I have any objection to them at this time, Judge.
All right, I'm gonna let Mr. Lefkoe go forward. Assume, Mr. Lefkoe, they're all in, and we'll revisit maybe 23, but we'll see.
Okay. Would I be able to get my screen?
Yes.
Okay. Mr. Lane, my name is Mark Lefkoe. I represent Judge Coomer. We have met briefly in the hall. Is that right?
That is correct.
I want to just talk about the $50,000 loan first.
Okay.
And or the extension of credit as it was reported on the CCDR as a loan. You with me?
Yes.
So 21-5-34
Mhm.
B1C
Mhm.
is the statute that we're talking about, right?
Yes, sir.
Extensions of credit. And
Mhm.
there are three things listed in this statute as to, and 21-5-34 is the reporting statute, right?
Mhm. Correct.
And that's what candidates and officials are required to report. That's the statute that governs that, right?
That is correct. Subsection B governs candidates for office and public officers.
21-5-34 references, quote, a loan, advance, or other extension of credit,
Mhm.
end quote. Did I read that correctly?
You did.
In the definitions section of the statute, there is a definition of a loan as, quote, in 21-5-3, 16.2,
Mhm.
a thing that is borrowed, especially a sum of money that is expected to be paid back with interest to the lender. Did I read that correct?
Yes, sir, you did.
Where is the definition for an extension of credit?
There is not a definition for extension of credit.
Is there a definition for extension of credit in the statute, in the regulation, in the case law, or in opinions?
No.
How does a candidate supposed to figure out what an extension of credit means under the statute? That's required, by the way, to be reported by your statute.
Mhm.
Ask you?
Yeah, no, I understand. Well, generally, most people, when they extend themselves credit, actually transfer those funds and use those funds. They don't simply state they exist somewhere esoterically.
Is this just your ad hoc statement as we're sitting here right now, how you think about it?
No, I'm telling you how campaigns function and how I've seen them function for almost 9 years.
You're saying that's the general practice of everybody in the history of time who's ever run a campaign?
That's not what he said.
Yes, sir. I withdraw it. Now, you told the panel here today that you, the commission, not you, you're not the commission, right?
No, I am not the commission.
You're a staff member of the commission, right?
That is correct. I'm their
There-
general counsel.
There are people over your head in the commission, right?
There are 5 commissioners appointed by various entities and persons.
The org chart is commissioners up here, and where's the staff in it? Is
Below
it
the commission.
right below?
Mhm.
Is that a yes, sir?
Yes, sir.
And you told the panel that this allegation was withdrawn by staff in the interest of resolution and because of a low fine amount, right?
Correct.
Will you please tell the panel what you told me out in the hallway as to why you withdrew that allegation?
There was additional reasons too. We had an additional reason was that there is a number of commissioners that we did not want to muddy the waters, to put it that way. We had very strong allegations. We had a strong fine amount, and we did not consider that the $1,000 civil penalty, for lack of a better term, we didn't think the juice would be worth the squeeze.
You told me that there was a commissioner who was like a federal judge, and you didn't want to pursue that allegation in light of that commissioner, right?
Correct.
And meaning that the commissioner would scrutinize your allegations and your contentions of law, right? That's what you're worried about, right?
More worried about the commissioner being distracted by a non-viable argument.
Because you were worried that it might be a non-viable argument, you didn't want to pursue the allegation, and you because of the concern about the commissioner, withdrew the allegation. Right.
Among other reasons, but the main reason we did it is simply to reach an agreement, and we didn't feel like doing litigation for the next 5 years.
If that is among the reasons, when Mr. Boring asked you, why did you not list that as a reason for withdrawing that allegation?
Because it's generally not top of mind. He didn't ask for every single reason that we refused to, pursue it.
So it was top of mind when you talked to me in the hall, but not when you're on the stand in front of the panel. Is that? Have there been allegations that you, as a staff member, have made publicly that the commissioners have disagreed with?
Have I made statements that they've disagreed with?
Yes, sir.
I'm sure I have. I can't recall all of them.
Not just statements that you disagreed with, public allegations, allegations against public officials and candidates, which the commission has disagreed with your interpretation of the law, the statutes, the regulations, the opinions, and the case law.
I'm sure there are. They are very infrequent, but they do happen.
Is it customary for the commission to withdraw allegations of criminal violations?
We don't make criminal allegations.
Let's look at the first amended complaint, which is exhibit number 216, allegation number 5, paragraph 17. And this paragraph 17 and 18, allegation number 5, by the way, relates to the $50,000 allegation, right?
Mhm.
Is that a yes,
You
sir?
need to
Yes.
say yes or no, please.
And in allegation number 5 in the first amended complaint that you as a staff member of the commission published to the world, it stated that Christian Coomer was guilty of committing a misdemeanor criminal offense under your campaign finance statutes, 21-5-9, right?
No, that's not exactly what paragraph 17 is alleging. Paragraph 17 is literally stating what code section 21-5-9 states. That violations of the Campaign Finance Act can be prosecuted as misdemeanors. That does not mean that I'm prosecuting it as a misdemeanor criminal violation. You have to keep reading the paragraphs to show we actually list what the violations are.
Okay, well, let's go backwards in this complaint then. Allegation number 4,
Mhm.
you're talking about alleged conversion of funds for personal use, short-term loans, this
Mhm.
phrase you've mentioned. And you don't make this allegation of it's a violation, it's a misdemeanor, or under 21-5-9 as the beginning of allegation number 4, right?
No, it's not contained there.
It's contained in allegation number 5, though, the stuff about $50,000, right?
Yes.
Why would you put it in 5 and not put it in 4?
Honestly, this was drafted quite some time ago. I don't recall every single paragraph and why we drafted it that way. It was, if I remember correctly, the complaint ran into the hundreds of pages when you attached exhibits and audits. So
Are you saying it was an oversight, or just because you're busy? Or
I'm just
'cause
saying,
there's too
honestly,
many papers?
I don't recall exactly why we chose to insert that paragraph at 17. It could be included earlier. It could be paragraph 2 in the actual complaint, because every violation of the Campaign Finance Act could be prosecuted as a misdemeanor.
The CFC can't do that, though.
Yeah.
You mentioned that in some instances, the commission might refer the investigation to the appropriate legal authority, Attorney General, GBI, wherever that would go.
Yes, sir.
But the CFC couldn't hand the candidate a ticket, misdemeanor, you got to go to court.
We cannot prosecute a misdemeanor. If we feel that criminal prosecution is warranted, we have to pass it off either to the local district attorney, to the local solicitor general, or to the attorney general's office. We don't get to make that determination of whether there's a criminal accusation.
You pass it off to other law enforcement agencies, right?
For criminal prosecution, yes, sir.
Sometimes you do that in cases, right?
Sometimes.
Did you do it in this case?
No.
How many, well, strike that. 21-5-34. I keep wanting to say 51 because I live in Tortland a lot of the time. 21-5-34 B1, and we were talking about extensions of credit under B1C. You remember that?
Yes,
Now, you told the commission, I'm sorry, you told the panel that lines of credit were not a contribution, right?
correct.
Well, look at 21-5-34B1C. You see where it says, quote, when a contribution consists of a loan, advance, or other extension of credit. End
Mhm.
quote. Did I read that correct?
You did.
Extension of credit is a contribution, right?
Correct, if it actually occurs.
Actually occurs. Let's talk about
Sure.
how an extension of credit actually occurs. Given that there is a distinction between a loan where money has changed hands, right?
Correct.
You would expect that in a loan, right?
Generally, in a loan, you have an agreement and a repayment term as well as a term of interest.
How do you, well, your statute doesn't distinguish at all. It just uses different words for different things, right?
Well, in this one, it continues on with you have to disclose the repayment of the loan, the advance. It defines a loan as a term with repayment terms and interest. So
Extension of credit is used as a separate series of words within your statute. It means something different than a loan, right?
I
Fair?
mean, you can argue that.
It doesn't say a loan includes a line of an extension of credit, right?
Extension of credit occurs in this part of the code section as well as, that's it.
Right. Extension of credit, general understanding of the word or the words, does not necessarily involve a change of hands of money, right?
If you're talking about a line of credit, like on a credit card, is an accessible line of credit,
There's not an exchange of money, right?
not until you actually expend it.
You mentioned that you believed Judge Coomer or Representative Coomer did not show, trying to find your language. I think you said something, did not find sufficient assets to justify an extension of credit. Is that what you said?
It is what I said.
What documents did you rely upon? What accounts did you review of Judge Coomer when you made that assessment? And did you write it down anywhere?
It was contained within our audit logs, and we looked at his personal account, his law firm account, his campaign account.
Let's look at this is in the bank records that Mr. Boring submitted on DVD.
What exhibit number?
It's not an exhibit number because it's within a giant stack of documents.
That has not been submitted yet.
Sorry, that is not an evidence, but I have, there's an exhibit if he wants to tender it. I have no problem at all.
Okay.
He announced that he's going to submit a DVD as evidence at the beginning, I think somewhere at the beginning of this hearing. And he told me that before we got here. I mean, I guess, are we going back on that? I don't want to just hand you a stack of bank records that's this big.
I appreciate that. We just need an exhibit number. Before you flash something up on the screen, it needs to be linked to some exhibit number. So the record that you are joining us in developing reflects what it is we're looking at. So now there's something on the screen that says Chalmers and Adams at the top. I don't know what exhibit
That's
that is.
360.
We're on exhibit 60 now.
No, that was 360, the Chalmer and Adams letter. I moved it to a different one when you said we didn't have an exhibit number when that issue arose, so I could be off.
Okay.
And Judge, I don't have a problem, just for the record, with him going into the UBS accounts. It's not one of the bank accounts, so that's a separate account. So
Okay.
just for,
Do you, Mr. Boring, have an exhibit number for either UBS separately or universe of financial records?
I actually, it's one of ours. I've sent to them and I have not used it yet, but I would be happy to get that for the record. Yes.
Need a number because
And I
Mr.
will-
Lesko can certainly use it.
Yes.
I will why don't I put a number on this page and I'll get it printed out.
Okay.
But it won't be printed out as I'm showing the witness.
Just want the record to be able to, if one needs to return to that page, we need a reference.
I designate the UBS statement from December. I've got the right. From December of 2019 as exhibit 360.
361. Any objection, Mr. Boring, to 361 a single page from the UBS records?
No, Judge, and at this time I'll submit our exhibit 205 as well, which is our UBS records, and I'll put that into evidence when I get back up.
Okay, but 361 separately will
No
be that
objection.
one page, no objection. You're welcome to republish now numbered 361.
Okay. Do you see exhibit 361 on your screen, sir?
I do.
And that is a UBS record from December 2019 in the name of Mr. Christian A. Coomer, right?
It is.
Did you look at the balance for this account when you made that assessment that Judge Coomer did not have sufficient assets to justify an extension of credit?
Yes, we did.
How much is in that account?
$240,000 was the closing balance on December 31.
That's not sufficient to justify a $50,000 line of credit, $240,000.
Not when you consider the other claims against his other assets, no.
What are the other claims against his other assets?
At the time we conducted the audit, we were well aware of the fact that he was engaging in litigation and claims with a former client seeking in excess of $240,000.
Any liens on these funds?
No,
Pre-judgment liens,
no,
post-judgment liens,
not that I'm aware of,
UCC statements,
not that I searched for.
UCC1 statements.
No, sir.
So you just discount an asset because somebody has a free-floating, non-liquidated claim against somebody asserted in litigation. You disregard their assets for that reason, right?
We didn't completely disregard his assets. We analyzed it.
And tell me the analysis then. How do you discount $240,000 from Judge Coomer's assets? And how do you discount his house that he owns from his assets?
When you look at the actual, and you also have to look at it as well, if I remember correctly, while he was still reporting this loan, without having all the records in front of me, I believe he disposed of the assets contained within UBS as well.
He disposed of what?
He withdrew money from UBS. I don't believe the funds remained in the account forever.
Do you think he withdrew those funds at the time of the loans or the extension of credit, the loan reporting or the extension of
told you,
credit
without
that's,
having-
wait, let me finish, sir.
Don't talk over.
Do you think, or do you have information or knowledge that Judge Coomer withdrew from the UBS account that brought it below $50,000 at any time during the time that his reporting of the extension of credit was in his reporting?
I do know that he did withdraw the funds, but I do not recall the date on which he withdrew them. I don't have the audit sitting in front of me.
There's some audit somewhere where you think you determined he did not have sufficient assets to justify a $50,000 extension of credit. Is that what you're telling me?
Yes, we ran a very extensive in-depth audit of your client and all his sources of incomes and his assets and his expenditures going from March of 2015 through 2019.
So what's the total number of available assets Judge Coomer had as of the time he reported the extension of credit?
Off the top of my head, I do not recall exactly, but it wasn't enough to cover the line of credit, in our opinion, when we removed what we consider to be a dubious asset because he would not have access to it.
So where in your regulations, where in your statutes does it say that you can discount assets in his hands or in his accounts on the basis of free-floating unliquidated claims?
We use general accepted accounting principles. We don't have it contained within our regulations.
Are you an accountant, sir?
No, I'm not an accountant.
Did an accountant perform this sufficient assets analysis that you're referring to?
I have no idea.
Did you do that sufficient assets analysis? Was it yours? Or somebody else's?
I don't know which one you're referring to.
You're
Talking
saying,
about the audit?
he says that somewhere that we've never seen, there's an analysis that determined that Judge Coomer did not have sufficient assets to justify a $50,000 line of credit.
Were any accountants involved in what you've been describing as the detailed audit from, I think you said, March 2015 through December 2019?
No, we did not retain a certified public accountant. We do have a certified fraud examiner on staff.
Was that person involved with the audit?
They did not at the beginning. They did come in and once they were hired, forgive me the month, but they were hired in 2020, late 2020, beginning of 2021.
And would that have been before or after your team reached the conclusion that there were not sufficient, I'll call it unencumbered funds, to support a line of credit?
It would have been after, but we did have him review our work. There was no reason to bring him on and then not utilize his services. He's now on staff. He's still with us. He's not a contractor. He's a real staff member.
So no accounting.
Are there notes? Are there any pieces of paper where you have determined that the UBS account was a doubtful account?
I know there are notes on the UBS account.
Do you know if there are
on all the
notes
accounts.
that document that account as a doubtful account?
I don't recall exactly what was written on it.
Right? How does one commit an extension of credit to a campaign? Does there have to be a piece of paper?
Normally, most people don't disclose an extension of credit till they actually draw on that line of credit.
You're not saying that's required, are you?
Well, the way the law is written, you're required to disclose the loans and the funds you're actually using.
You're required to not just disclose loans, you're required to disclose loans, advances, and extensions of credit, right?
Correct, once you've committed them to the campaign.
And your form has, where does it say on your form, extension of credit?
It doesn't state extension of credit, it states loan.
And so let's look at
I believe it says loan
exhibit
reporting.
number 216. I'm sorry, not 26. Yeah, it is. It's 319, sorry. On page 11. So this is a campaign disclosure report from 2020. In terms of retiring an extension of credit, do you have a form or a place in the form specifically designated for extensions of credit and retiring extensions of credit?
No, there is not a drop down that states the term extension of credit. It will state loan repayment in the drop down. You have the free form text box for the expenditure purpose. And then there's an additional part of the report called loan reporting where this information is also inputted.
So we were talking about your regulations, and one of the things I hate the most in the world is looking at the Georgia Administrative Code, and yours was even worse because for some reason
I
Westlaw,
object to Mr. Lefkoe
I withdraw.
giving opinions about.
Let's just get to the question.
Okay. So what you do is you publish the rules on your website, right?
Correct. The official custodian of the rules is the Secretary of State.
But on your website, you've got a link to the rules, right?
We do have a link, but the official copy of the rules is maintained by Secretary of State and published by LexisNexis.
Have you looked at it recently? The rules link?
Honestly, no, I have not looked at it recently.
Did you know that it was a page not found when you try to click on the rules
When did you try and click on it?
in the last 2 days?
That's news to me.
Object that Mr. Lefkoe's kind of making himself a witness right now.
Let's stay focused on what you need to cover with this witness.
Yes, sir. We need to unpack some things you said yesterday as well.
Okay.
You suggested to the hearing panel that Judge Coomer did not self-report anything before your second amended complaint. Remember that?
I believe my exact terminology was, I don't recall it.
Okay, so you think maybe he did self-report before your second amended complaint?
I don't recall it. I don't think he did, but if you have something that says he did, I'm happy to look at it.
Yes, sir. Let's look at exhibit. Let's first look at your second amended complaint, which is exhibit 217.
Mhm.
Let's look at the date. November 9th, 2021.
Okay.
See that?
Mhm.
That's the second amended complaint against Christian A. Coomer before the Georgia Government Transparency and Campaign Finance Commission, right?
It is.
You agree with that date, November 9th, 2021?
That is the date on the letterhead.
Let's look at Mr. Chalmers' letter in exhibit 360 dated November 7th, 2020. Are you with me?
I am.
What number was that? I'm sorry.
That's 360.
Depending on what we get into, sorry, Judge. If we're going to something specific regarding when this was reported or any type of self-report or whatever acknowledgement, I don't have an objection. I may, if he tries to go into other substantive arguments made by council in a letter regarding this.
Okay.
Let's actually go backwards. I believe it's in the earlier letter. This is gonna be exhibit 358. And this is Doug Chalmers' letter after your first complaint, immediately after October 16th, 2020.
There it is.
See that?
I do.
October 16th, 2020. And exhibit 358 is the letter from Chalmers and Adams, Doug Chalmers to David Amati and you, the executive secretary, and you're the deputy executive secretary, right?
That is correct.
And you received that letter, correct?
That's, yeah, eventually I received it.
Let's look at page number 7. You see the section, paragraph or section number 3, self-report of other transactions.
Yes.
And do you see in the paragraph, the second paragraph that, well, let's start with the first paragraph. Quote, out of an abundance of caution, respondent has ordered that a comprehensive review of his campaign finances be conducted to ensure there are no issues that need to be addressed and that are not already set out in the commission's complaint, end quote. Did I read that correctly?
You did.
As of the date of the first complaint, there was no allegation about any kind of credit card or anything of that sort, right?
Not that I recall, no.
What
And
was the first complaint was focused on what? If it wasn't credit, yes, about credit cards.
Sure. No, if I recall correctly, it was related to the non-disclosure of various transactions.
so let's look at this self-report. The second paragraph, Judge Coomer's lawyer, Mr. Chalmers, identifies that there is a credit card on which certain personal expenses may have been paid, right?
Yes,
And that was sent to you before you made any allegation about that, right?
correct.
And at the end of that, he says that upon a comprehensive review, he will address that by making a donation to charitable organizations, right?
That's what it says.
And in fact, Judge Coomer did make a donation to charitable organizations, which you documented in Exhibit 324, which is your consent order, where he had, go back, on page 3 of 5, under findings, paragraph 29, quote, in October 2020, respondent Coomer voluntarily made a charitable contribution for $5,000 to the Atlanta Volunteer Lawyer Foundation, end quote. Did I read that correctly?
You did. I think in the earlier letter, it said it would go to a veterans organization, but I could have misread that.
Dispute the finding of the commission that he made that charitable donation in October 2020,
No, we were presented evidence that the donation had actually been made.
and that was provided to your satisfaction, right?
Yes, we requested for proof of donation and received it.
Yes, sir. And you mentioned, or Judge McBurney asked you about charitable contributions. Are you aware that Judge Coomer did not take a charitable deduction for this donation?
I have no knowledge one way or the other.
Or the $2,000 donation? Are you aware of that?
Again, I don't know one way or the other. I didn't ask.
October 2020, he made this charitable donation, and that is a standard way because his campaign for representative is closed of resolving those issues, right?
Yes, a donation of excess campaign funds may be donated to charity.
Right. So do you want to go back on your testimony that Judge Coomer did not self-report anything before your second amended complaint?
Well, with all due respect, if you read your letter from Mr. Chalmers, he doesn't disclose what the transactions are. He says, we think we have a credit card account that has some transactions, and we'll get back to you at a later date once we've done our own audit.
So is
mean,
the
if-
answer yes or no to my question, sir?
No, I'm still maintaining what I said is true. Just because you tell me you intend to self-report at a later date is not a self-reported disclosure of what the violations are.
You find a self-report of an American Express card that has personal expenses on it to be insufficient for your purposes before the audit's done, right? That's what
You're
saying?
presuming that we've not looked at accounts and that we've not flagged our own like violations. Just because Mr. Chalmers is promising to cooperate on what he will find in his own audit doesn't bind us in any way. And Mr. Chalmers is a very good attorney who deals with this on a regular basis. So
You were saying to this panel that we didn't self-report to make us appear uncooperative, right?
I mean, we never got a detailed listing of transactions of here are the personal expenses we are claiming that we commingled and never repaid. I don't recall ever seeing that.
The fact is Judge Coomer did cooperate with the commission, right?
Well, I mean, his counsel cooperated with the commission as we entered into negotiations, if that's what you mean.
At the end of this process in Exhibit 324 on page 4 of 5, paragraph 31, the finding was that respondent Coomer does not personally owe his campaign committees any funds. Do you see that?
Yes,
You're not going back on that here, are you?
I never said he did personally owe campaign committee funds.
Paragraph 32 states, quote, respondent self-reported various transactions to the commission, did not file a motion to quash the commission's subpoena, and has cooperated with the commission in its investigation. End quote. Did I read that correctly?
Yes, you read it correctly, and it's not uncommon for us to have what we call client consumption language contained within our consent orders.
Are you saying that language is inaccurate?
I'm saying that it is inaccurate if we're going to expand it to the scope that you are trying to give to it.
I'm not trying to expand it to anything. Is it accurate or not that Judge Coomer cooperated with your investigation?
If you consider not filing a motion to quash a subpoena cooperation, then he cooperated. Yes, sir.
Mr. Lefker, can you leave that portion up, please? Going back to number 31.
Sure.
Respondent Coomer does not personally owe his campaign community funds. Is that after the $7,000 payment?
Yes, sir. That's after the $7,000 payment, the $5,000 and the $2,000 payment.
How much of paragraph 32 was the product of negotiations with Mr. Coomer's lawyer and the commission versus that's the specific language you would have put in there if there weren't negotiations?
That is whole cloth from negotiations. That is a deviation from standard language contained within our orders.
You signed the consent order yourself, right?
I sure did.
Sir. Now, one of the things that Judge Coomer did to cooperate was for purposes of resolving things with your commission, to withdraw statute of limitations defenses, right?
Correct. He withdrew some of his defenses. We withdrew some of our allegations. It was horse trading.
October 2020 is your first complaint, right?
Yes.
And you were making allegations concerning transactions that went back to 2015, right?
Correct.
And you understand you have a 3-year statute of limitations for pursuing such allegations, right?
Yes, that is correct, provided the transactions themselves are disclosed. There is an exception.
Not only is there a 3-year statute of limitations, well, there's a 3-year statute of limitations for reporting errors too, right?
Well, generally reporting errors in and of themselves are not violations of the act.
Failures to report, 3-year statute of limitations, right?
Well, it gets, I mean, I don't know how much the panel wants to be bored or you want to be bored with. If you fail to report like if you don't file a campaign contribution disclosure report at all, the way the law was drafted at this time, you would have a 1-year statute of limitation within which to sue someone for those failures to report.
Candidates such as Representative Coomer have an obligation to maintain records for 3 years, right? Past transactions, right?
That is correct. At the time, it was 3 years.
So you were
Is the statute of limitations any different in this context than it is in others where if you don't have a reasonable way of knowing it hasn't started running? So you would know if no report was filed. Everyone has to file one. Judge McBurney didn't file one. You've got a year to go after Judge McBurney. Knowable fact, I didn't file one. If I file one and on it is incomplete, misleading, incorrect, whatever negative adjective, because that's why you'd be concerned about it, but it's not facially obvious, does the statute of limitations start running on that until you reasonably ought to have known that there was something deficient about my report?
You have summarized the statute of limitations correctly. The 1-year statute applies when we are on notice you should have filed, you failed to file. The 3-year statute applies and starts running when you make a disclosure, but we should know that it's incorrect or somehow unlawful. And then if you conceal those transactions or don't disclose them, it's until we are reasonably on notice that we should have known about it, that the statute starts to run.
If you did not disclose a $1,500 contribution at all,
Correct.
the statute's not 3 years because you have no real reason to know that that contribution occurred.
Correct. When that statute of limitations defense was raised, because we have addressed it in the Oxendine case, which lasted for 8 years. That defense was raised and rejected. It's basically what you just said, sir, is if you file the report and we have it, but you don't disclose a transaction within that report until we're placed on notice that transaction's missing, the statute didn't start running for that specific violation.
Thank you. Let's move past statute of limitations.
Yes, sir. A line of credit is an extension of credit to a borrower that can be accessed or drawn down at any time at the reporting entity's discretion. Do you agree with that definition?
I don't have a problem with it.
I'd like to, there are other UBS account statements that I'd like to designate as an exhibit. I think the last one was 360.
So what you could do now that the director has given a number to all UBS is just refer to the specific page or date of page. And that way we don't need to create new ones. But if you'd prefer to have individual page exhibits 362, 363, that's fine. Just know that there is now an exhibit number that is all UBS.
205. I think it's the wrong, it's the wrong.
Well, that one's not going to work then.
Yeah, it doesn't. So I will, why don't I designate exhibit 362 as the 2015 to 2017 UBS account statements. And I believe the understanding that I have with Mr. Boring is that the UBS account statements, the bank records will be filed under seal. Like when he puts that whole DVD in, public's not going to have access to that giant DVD of stuff.
I think that's accurate, but we can work through those kind of logistics, not this week.
362, any objection?
No.
Is that admitted, Judge?
Yes, sir.
Let's look at exhibit 362 then. Something you said yesterday struck me because you said something to the effect of law firm income going down, expenses in a campaign going up. You remember that?
I believe I said the expenses remained constant. They were flat, but the income did go down.
You're trying to suggest Judge Coomer was broke and that's a reason for him violating campaign finance laws, right?
I'm just simply stating what the evidence showed within his campaign records and within his personal accounts.
You didn't have any other reason for saying that? You just said it?
But the evidence showed,
What was the point of saying that?
it explains why he was using campaign funds.
Well, so that's what I want to get to. Okay. 2016, what happened to Judge Coomer in terms of his position in the House of Representatives in the General Assembly?
I know at some point he was a member of leadership, but I don't recall exactly when that occurred.
He became a member of the leadership of the House of Representatives, right?
I'll take you at your word.
Became majority whip, right?
He did eventually become majority whip. I don't know the date.
And you told me in the hall as well that one thing that you look at when you look at a candidate or official's expenses is the position of the official, right?
Correct.
Why do you do that?
Because different officials have varying levels of expenses. You would anticipate a gubernatorial candidate would have more expenses than a city councilor from Hayhire, Georgia.
You would anticipate that somebody who's majority whip would have more expenses than somebody who's just a plain old representative, right?
Possible, yes.
You produced in this court, or I'm sorry, in this hearing, 0 documents suggesting that Judge Coomer had financial difficulties in 2016, right?
I wasn't asked to produce any of them.
Do you have any such documents as we sit here today?
I don't know if I said he had financial difficulties. I said his income decreased. I didn't attribute it as to why. But I used the same bank records I'm assuming you have access to.
At the times that the challenge transfers occurred in 2015 to 2017, let's add 2018
Okay.
to it. When did Judge Coomer receive Department of Defense payments?
He received paychecks
When?
due to his, I don't remember the exact dates he
What
received
time of the
them.
month?
He would receive them generally after he, Lord. I know there would be reimbursements or what looked like reimbursements after he went to guard training or his guard duties, but there were additional payments that appeared to be some form of salary payment.
So the reason I pulled up exhibit units 362 is I want to focus you on what Judge Coomer had in the bank,
Mhm.
okay? We were talking about 2015, 2016, 2017. Some of those are dates of the transactions you're challenging, right?
You're talking about the transactions from the law firm or from the campaign to the law firm and the law firm to the campaign back, right?
Those would be ones you challenged, right?
Yeah, I'm just making sure we're on the same page.
Yes,
but
sir.
yeah.
Okay, 2015, do you see on exhibit 362, page 1, where in September 2015, there was a balance of $60,000 in Judge Coomer's UBS account.
Yes, that's what it says.
In May of 2016, there's a balance of $40,247.57 in Judge Coomer's UBS account. Do you see that?
I do.
November 2016, do you see where there's a balance in Judge Coomer's UBS account of $42,759.78?
I do.
February 2017, you see in Exhibit 362, page 164, that there is a balance in the UBS account of $44,101.97.
I see it.
March 2017, do you see on page 174 of Exhibit 362, there is a balance in Judge Coomer's UBS account of $44,814.47.
I see it.
Mr. Lefkoe, do you intend on letting us know what those assets are? Cash versus invested in the most illiquid thing on the planet? I don't, it shows that there's 44,000 in here.
I do not invest with UBS. Judge Coomer can testify to that.
Okay, so at some point you can help address that for us.
Mr. Kingman will take Judge Coomer's direct and will address whether
All right.
those are liquefiable. All right. So you don't know whether Judge Coomer was broke, in financial distress, needing money at the time of the transactions that are challenged, do you?
I don't think I used the term he was broke.
I didn't say you use those terms. Do you know whether those things, those conditions existed at the times of your challenge transfers?
At the times of his challenge transfers and looking at all of his accounts, he did not have liquid assets to cover those transactions at that time.
How much cash did he have at those time of those transactions?
Are you talking about in which accounts?
Cash.
In his cash at the time as we alleged within our complaint and as he stipulated to it, he had insufficient funds within his account to cover the pending charges, and he transferred the funds from his campaign into his law firm operating account.
Sir, I'm going to ask it again. Do you know how much cash, and did you ask Judge Coomer how much cash he had at the times of these transactions?
No, we did not send him an interrogatory asking him what he believed his cash position to be.
I pause this for 1 second. I want to make sure I heard what you said correctly, Mr. Lane. Are we going through all this and Judge Coomer has already stipulated that at the time these transfers occurred, he didn't have sufficient cash?
That's what our consent order alleged, or that's what our allegations within the second amended complaint show. We show that on this date, a transfer occurred in this amount, and but for that transfer, the account would have been negative by X number of dollars.
But that's different than saying, and I didn't have any other money anywhere else.
No, and I never
Okay.
alleged he didn't have any money anywhere else in the world.
Okay.
Did you know Judge Coomer had a $130,000 line of credit with a zero balance in 2018 through 2020?
I'm not familiar with it, but I mean,
You don't know that one way or another, right?
Not sitting here right now without reviewing the audit. No, I can't tell you whether it exists or didn't.
You don't know what assets or cash Judge Coomer had access to in other accounts. You can just talk about this one particular account that might have gone negative or been close to going negative, right?
Well, we reviewed his accounts that were produced for, I believe, CAC Holdings. There was a Veterans Association. There was his personal accounts. I believe he had 2 checking accounts. I think he had a fraud event during one period of time in 2019. That explains the 2 checking accounts between him and his wife. They sent his child's bank account for some reason. The law firm Iolta account, law firm operating account. We had UBS and I believe American Express. I believe those are the accounts that I remember off the top of my head reviewing.
By Judge Coomer agreeing to a consent order, do you agree that that helps save the taxpayers money?
Well, that's one of the reasons we enter into consent agreements.
And then maybe you could get from reviewing 15% of the 100% of things you're supposed to review up to 17%, right?
That would be nice.
So I want to talk to you about how this case against Judge Coomer got brought in October 2020.
Okay.
And that brings up the Panther Cologne issue, is what I call it. I mean, 15% of the time you're 100% effective, right? You review 15% of audits. You're supposed to review 100%, but you review 15% of CCDRs, right?
Well, thankfully, the percentage is up now. And frankly, with our new system, everyone gets reviewed now. At least it's done electronically. So
Right. So you're saying you do 100% now?
it's not a full-on audit, no, but every account is reviewed by the new system and it flags violations that are predetermined and inputted.
At the time of Judge Coomer's reporting, are you saying that you reviewed every single one, or was it the old system where only 15%?
And that's why I said currently the new system.
I see. When did the new system go into effect?
The new system went online and officially mandated January of 2022. It went online in 2021 and you had the option to file in one or the other.
And in general, people would get referred for audit randomly, right?
Yes, we used a randomized method, so no one would accuse us of picking on one team or the other or one jurisdiction or the other.
Like the airport, they randomly select me every time, right?
We actually did it off filing identification numbers, so it truly was a randomized.
All
It
right, so
was more sophisticated than throwing a dart at the wall, but
this investigation of Judge Coomer was not a random audit, right?
I believe it was a referral.
Referral by whom?
If I recall correctly, I believe some of the allegations were made aware to us by the Judicial Qualifications Commission or by the GBI. I do not remember which one.
So you had meetings with the Judicial Qualifications Commission to,
The referral actually went directly to our director. I didn't participate in those referral meetings.
Mr. Amati,
That is correct.
and what was referred to you to investigate?
I was given the case to complete the audit with a fresh set of eyes. So someone who hadn't been told anything about here's X, Y, and Z. It was here's his account, here are records, perform an audit, tell me what you find.
Nobody said, here's what we think you did wrong. Can you go check everything else now? They said,
I was not given a here's what we think happened. It was literally here's his account. Here are the accounts you can go audit. Go tell me what you find.
nobody told you, we've already determined he's done something wrong. Now we need to audit him because we determined he did something wrong, right?
That was not expressed to me now.
All right. And then you had the additional power to refer it to another law enforcement agency if you so desired or thought that was appropriate, right?
Correct.
And you did not.
No, we did not make an official referral that I'm aware of.
Did you participate in any discussions with the JQC after you got the referral? Besides this expert stuff you're doing here today?
We met to discuss what we found once we had completed our audit.
How many times?
Oh, I don't recall. It's not. At least less than 5 that I recall.
With whom?
Staff of the commission, Mr. Boring, his deputy, an investigator. I believe that's the extent of
Mr. Alford? You know,
I mean, I could pick him out by. Yes, sir.
that's him.
Sorry, I'm bad with names, great with faces. Sorry.
Did they tell you why they referred Judge Coomer to the CFC in those meetings?
As to why they referred, not that I recall.
I'm gonna shift gears to the law firm transfers.
Maybe we'll shift to lunch.
That's what I was gonna ask. If you want to do
No,
that.
we were waiting for you to have a natural break point as well. So let's do that. It is 12:24. I'd say an hour, but it takes the extra minutes to get to the square. Let's try to be back here at 1:30 to pick back up. So Mr. Lane, hopefully we've got more of your time. from the
Absolutely.
CFC.
I'm here at your pleasure.
Before everyone runs out, Mr. Boring, anything we need to get on the record from the director?
No, Your Honor.
Mr. Lefko, anything?
No, thank you.
See you in an hour.
That you dictate. Here's a video.
One and there it is. Thanks. All right. Ms. Johnson, are you ready? Did you have a good lunch? Excellent. Great. Well, we will pick up where we left off. Mr. Lane is still on the stand. We are partway through cross-examination. Mr. Lefko, you were about to transition into a different area of the CFC's investigation. So if you could remind us what it was and get going when you want to get going.
Law firm transactions.
Law firm transactions. All right.
I think I need to close loop on a few things since I had lunch with people and people talked about things. And this is Exhibit 319. These are all of Judge Coomer's campaign finance disclosures, and they go reverse chronological order. I probably need binder clips for this thing, but there's no binder clip that's big enough to fit this 490 pages. So I'm going to put it on the ledge, and I've got it on computer anyways.
Okay. Well, you and the court reporting world can work out how they want it. Any objection to 319?
No, Judge.
Okay. And we don't need a hard copy up here. Thank you.
All right. I want to talk about a few things here that we talked about earlier today, Mr. Lane. You understand you're still under oath, right?
Mhm.
Is that a yes, sir?
Yes.
We were talking about this sufficient assets determination, and you mentioned GAAP, is that right?
Generally accepted accounting principles.
Okay, what section of GAAP are you relying upon?
I don't recall the exact section.
Did you look at the Philhart debt in making a determination of sufficient assets or not sufficient assets to see when payments were due under those notes?
No, because at the time we ran our audit, I believe Mr. Coomer was already in litigation regarding those debts.
So the answer is no.
That's what I said.
You agree that a line of credit is an extension of credit, right?
You're just using the general term line of credit, correct?
Yes, sir.
Yes.
And by being an extension of credit, no drawdown on the line of credit or extension of credit is required, correct?
I'm not aware of anything that requires a drawdown on a line of credit.
Nothing in your rules, regulations, opinions, statutes, et cetera.
No, sir.
Do you know how long the rules on your website have been down?
It's news to me that they were down because they're currently up. I checked during our break and they are up and active.
Maybe your internet connection.
I don't think so. I don't think it works that way.
Much like YouTube yesterday.
All right.
Now, I do know there was a system outage of our filing system, but that was a planned system outage and it's not related to our website. But that happened earlier in the week for a data production launch, but I don't think it had a knock-on effect.
So we talked about the consent order. Remember that?
Yes.
And there was a finding of no knowing violation, right?
There is a sentence contained in there about the commission did not allege.
So by not
cannot read.
alleging it, there's no finding of it, right?
I believe that's correct. I don't remember the exact language, but I know there's a sentence contained within the consent
Let-
order.
Let's look at OCGA 21-5-9. Okay. Except, quote, except as otherwise provided in this chapter, any person who knowingly fails to comply with or who knowingly violates this chapter shall be guilty of a misdemeanor.
Mhm.
End quote. Did I read that correct?
You did?
So even if it was a knowing violation, even if you did allege a knowing violation, at most, it's a misdemeanor, correct?
That is correct, unless there's some other underlying criminal transaction.
And are you aware of any underlying criminal transactions with respect to Judge Coomer?
Not that I've investigated.
There are cases where you do see other underlying criminal transactions, right?
There are.
Are you aware of, well, let me frame this. We talked about the referral by the JQC to the Campaign Finance Commission. Remember that?
I do.
And are you aware of any other proceeding where an agency in Georgia referred a matter to the Campaign Finance Commission? You came up with a finding of no knowing violation, and the agency then looked behind your finding and turned it into a personal integrity issue in their proceeding?
I'm not recalling that. Is there a specific case you're thinking of?
No, sir. I'm
Okay.
asking if you're aware of any such cases.
If you don't mind, could I hear the question one more time?
Are you aware of any other proceeding where an agency like the JQC referred a matter to the Campaign Finance Commission? You came up with a finding on that referral of no knowing violation, and then the agency then looked behind your finding and turned it into a personal integrity issue in their proceeding?
No, I'm not aware of a case of that type.
Was the no knowing violation language that Mr. Lefkoe has now referred to a few times something that was the CFC's proposed negotiated resolution? Was it nothing that was disputed, or was that language that Judge Coomer's advocate pushed for?
It is a language that was pushed for by Mr. Coomer's counsel. The original language was stronger than what was ultimately included within the consent order. There was a back and forth negotiation on the exact language to be used.
I want to go back to the $50,000
Okay.
extension of credit. Since there's no place to report it as an extension of credit on your form, right?
There's no line item that says extension of credit.
If you do report it as a loan, when you put a loan on your campaign disclosure form, to take that off of your disclosure form, the way to do that is to retire it, right?
Yes, you have to retire it. You have to show a payment on it or a retirement. It's called credit on loan. It basically means forgiveness.
We talked earlier about your position in the commission as a staff member. Remember that?
Mhm.
Is that a yes, sir?
I do.
Thank you. You're not the commission, right?
No, I am not the commission personified, thank God.
So you're not here giving official position statements of the Campaign Finance Commission. Is that right?
I don't know if I've been asked for an official position statement of the commission at this point.
You don't understand your role here to be representing the commission, making statements on behalf of the commission, do you?
I mean, I'll defer to what the parties consider my role to be.
You mentioned that commission members have disagreed with some of your allegations of violations of the campaign finance laws. Remember that?
I do remember that. It's infrequent, but it does happen.
Not only that, but there have been disagreements among staff members as to the meaning and interpretation of some of the laws you administer, right?
Well, I'm sure like any kind, that's true, but it's like that old adage of you give 4 lawyers 2 cases, come up with 9 opinions.
In addition to that, administrative law judges have disagreed with your interpretations of statutes that the Campaign Finance Commission administers, correct?
I'm sure at some point in time they have.
That's because some of these laws are subject to different interpretations, right?
That would be fair to say.
Now, the law firm transactions, that was
Okay.
a long way around to get to where I wanted to start. These transactions occurred between 2015 and 2017, right?
That sounds correct.
And at that time, Judge Coomer, do you understand whether he was a judicial candidate or a judicial officer?
You'll have to forgive me. I don't remember the exact times he was an officer or candidate. I do know that during a period of time, he served as a municipal court judge, I believe for the city of Adairsville. And then I know that he applied for, I believe, the Supreme Court and withdrew. And no, he applied for the Court of Appeals and withdrew, and then applied for the Supreme Court and was nominated or appointed.
You just don't know dates, right?
I don't know the dates now. Sorry.
All right, let's talk about general principles with respect to these transactions. And I think you mentioned the notion of reimbursements in the context of travel. Remember that?
Okay.
Do you remember that?
Vaguely, yeah.
Yeah, where somebody had used campaign funds and some hypotheticals, and then there was supposed to be a reimbursement,
Mhm.
right? Remember?
I remember.
So what does the reimbursement get reported as in a travel situation on the campaign finance disclosure reports?
Is this a hypothetical where the purpose was allowed or not allowed?
Not allowed.
For a not allowed reimbursement, you would simply show, an expenditure purpose type reimbursement, and then in the description field, you would type in that, reimbursement of campaign for unofficial travel.
So
That would
like
work.
when you reimburse it, you don't count it as a contribution, right?
No, I don't believe you'd count it as a contribution. You'd affect your cash balance incorrectly.
So let's talk about law firm transactions then, and I want to look at the statutes. 21-5-3. And this goes to a particular defense that was raised in your proceeding by Judge Coomer's attorney. So actually, let's go start with expenditures. Because we're talking about way that works. Okay, 21-5-3, paren 12. I think it might be 8. No, I think it's just 12.
You're right, it's just 12.
Thank you. Expenditure means, there we go, a purchase, payment, distribution, loan, advance, deposit, or any transfer of money or anything of value, quote, made for the purpose of influencing the nomination for election or election of any person, ... end quote, right?
That is a partial, part of the definition, yes.
So one of the defenses that was raised in that proceeding that was withdrawn as part of the consent order was that these transfers to the law firm were not properly considered expenditures that were required to be reported because they're not within the definition of expenditure under the campaign finance laws, right?
That is one of the defenses raised.
And Judge Coomer withdrew that offense or that defense to enter into the consent order, right?
Correct.
And then
What would it be if it's not an expenditure? Based on that one aspect of what looked like a very, very long definition for expenditure, we seized upon only one of them. I don't think anyone is contending that Judge Coomer lent himself money to influence the outcome of an election. But assume that it's not an expenditure for any of the many definitions. What else would it be classified as if I'm reporting that I took money out of my campaign fund and dropped it into my law firm?
Well, and that's where we would allege that it's a violation of 21-533C, a personal conversion. Because if you were able to say that it's not an expenditure, it doesn't meet the definition of expenditure, and there was no reporting requirement of any kind, you could just drain your account, say, well, I didn't influence my election, I bought a BMW, then there'd be no reporting requirement. So what we've said is if it's a personal conversion, it counts as an expenditure under 21-533C.
let's talk about another aspect of expenditure.
Sure.
Okay. If the campaign is incurring rent, and this goes to ordinary and necessary expenses. Let's talk about what that is.
Okay.
Okay, this is 21-5-3-18. Ordinary and necessary expenses include office costs and rent, right?
Correct.
It includes staff salaries, right?
Correct.
Consultants, right?
Also correct.
And this one, I don't understand, but maybe you can explain. Volunteers. You can pay your volunteers, right?
Yeah, I know, right? You can pay the volunteers. It's generally not to pay them for their time. It's generally to reimburse them for expenses they incur, like for mileage, gas, the door knocking people.
That's your interpretation, right? Right?
It's my interpretation, and it's what happens in practice.
Not what it says, though, right?
It says volunteers.
It says you can pay them, right?
Correct.
And so it also doesn't say in this as to ordinary and necessary expenses, or if we go back to expenditures. It does not say who initially must incur expense? Does it? So, does it say that?
No, because campaigns can receive contributions from others they're in-kind contributions.
So what if somebody's business incurs expenses that are campaign or legislative related? Can you pay those back?
It's possible.
What if your business incurred a bunch of expenses? And, well, let me ask you about when you said it's possible.
Yeah.
Strike.
You'll have to forgive me, they're very fact specific.
I understand. Is there a time limit on when you can reimburse your business if it incurs campaign related expenses?
No, there's not like a statute of limitations on debt collection.
Like if your business incurred expenses that go back 2 years and finally you decide, look, I can't keep floating my campaign and I need to pay some of it back. You could do that, right?
You could, the limitation and the only limitation I can think of is you have to disclose those expenses as being donations to your campaign in order to do the reimbursement.
You have to disclose what?
Like you have to disclose the transaction. It can't just be, out of thin air. You have to inform us that you did a fee for service. There is I'm trying to remember exactly what the terminology was. We've changed it since, but during this period of time, it was, forgive me, it's an outstanding debt that you are not yet paying yet. So if you're incurring those services, you would report it's like an accounts payable.
Let's say a candidate or official.
Mhm.
That's what it is, right? Candidate or official, right?
Either one, yeah.
A candidate or official, their business incurs office costs, rent, staff salaries that are for campaign-related activities and legislative activities. And what you told me is there's no deadline on when it can reimburse those expenses, right?
Correct,
You just got to be able to show that you've got those expenses, right?
correct.
And that you've incurred those expenses at some point in time, right?
In relation to your office or campaign, correct.
And
Can I jump in here real quick? The CFC, does it take a position in a situation like here where Judge Coomer is running his legislative activities and campaign activities out of his law office? Can he subsidize, or not subsidize, or reimburse his law office for some portion of the time that he's doing legislative activities or some portion of the time that his assistant is doing legislative things under staff salaries? How does that work in this type of situation?
In that type of situation, you have to apportion out the salary that you're reimbursing. You can't just pay their salary out of campaign funds and say part of it was for campaign or legislative events. You'd have to delineate for us what was related to their non-campaign / public officer duties and their regular duties. As far as rent and other utilities, we use the but-for test of would you incur that rental expense but for your campaign? And in most instances, they are going to incur that rent. We had a case in which it was Councilman Bond was claiming rental payments for his campaign in his home. He said he was using a home office that was disallowed because he was going to be paying his home rent whether he had a campaign or not. So the salaries are easier to justify than say rent or utilities or other items that you're going to naturally incur.
so if you properly allocated it, and what you're talking about is when it comes to your desk and you're asking for justification for things, right?
Mhm. That's correct.
You're not talking about you have to allocate it on the form, right?
Well,
You have to allocate the right amount on the form, but you don't have to line item detail. Here's percentage, here's how I calculate it.
thank you.
right?
You have to disclose the correct amount attributable to the official expense. You don't have to say their salary is normally $10,000, but I paid $1,000 from my campaign account because they only did $1,000 worth of work.
So now you can pay your business back for incurring these expenses, right?
Correct.
And you mentioned earlier that if there was a payment that you personally got like on travel and you reimbursed it to your campaign, you don't have to report that as a contribution, right?
There are two ways to do it. You have under the system, both old and new, you can list it as a reimbursement, or you can list it as a contribution. In the purpose section, you put that it's a reimbursement for your campaign.
So let's look at what a contribution is defined as under the statute. And that's 21-5-3, Official Code of Georgia 7. With me?
I am.
A contribution means, quote, a gift, subscription, membership, loan, forgiveness of debt, advance, or deposit of money, or anything of value conveyed or transferred for the purpose of influencing the nomination for election, ... end quote. Did I read that correctly?
You did.
Okay, so that was one of the defenses that Judge Coomer raised in the Campaign Finance Commission proceeding, right?
It
That
is.
the law firm reimbursing the campaign does not count as a contribution, right?
That is.
Because of this language in your statute about that to be a contribution, it must be something conveyed or transferred for the purpose of influencing the nomination for election, et cetera, right?
Correct.
And that defense was withdrawn for purposes only of the Campaign Finance Commission proceeding, right?
As far as I'm aware, yes.
That's what the consent order says, right?
Correct.
Okay, so if hypothetically a candidate or an official's business incurred expenses that for office costs, staff, volunteers, and other things allowed under ordinary and necessary expenses in the statute. And then decided, the candidate or official decided, I can't do it anymore. I'm gonna incur these expenses using, or I'm gonna reimburse these expenses using campaign funds. Are you with me?
I am.
You said that could be done, right?
It's possible, yes.
And in that circumstance where that is done, then your business could keep the funds, right?
That were reimbursed to them, yes.
They don't have to send it back to the campaign, right?
Correct.
And then what if you decide, I'm going to reimburse my business, which you said is allowable, for allowable, ordinary, and necessary expenses, and then you decide against it. And you say, before the reporting comes due, I'm going to undo that and make my law firm or my business bear those expenses. How's that reported? Does the statute say?
If you are listing a reimbursement, you should disclose it. If you fail to disclose it, if we're talking about one transaction or two transactions, they're de minimis, that could fall within the substantial compliance requirement that we have, because we don't expect perfection in your disclosures.
Yes, sir. Where is the line item for reimbursements on your campaign, your CCDR form?
It's
Campaign
contained in the
disclosure.
expenditures in the dropdown. You should have a reimbursement item.
If you have an expenditure to report at the time of reporting, right?
Correct.
So what you would like to see, whether it's in the statute or not, is if something like that occurs where a candidate decides or an official decides, I can pay my business back for stuff that it incurred, and then decides against it within the reporting period, you want to see it reported as an expenditure and contribution or an expenditure and reimbursement?
Forgive
or
me,
what?
maybe I've misunderstood your question. If there's no transaction, if we're just talking about what the candidate intends and they're thinking about doing, but decide not to do it, if they don't do it, there's nothing to report.
No, they did it and then they reversed it during the reporting period. Do you need more time, sir?
No, I'm just running through the code in my head to see exactly how you would apply it and how you would do it through a business practice with our actual system. Because I don't want to tell you there's a way to do it and there not be one.
So yes, you need more time.
Sitting here right now, I'm fairly certain contained with the way 21.534B is written, You would have to show the transaction that occurred. And the way you would do that is you would show the reimbursement. And if you chose to reverse the transaction because you didn't want it anymore, you just have the corresponding transaction showing your change of heart, mind, whatever.
But that's not what the statute says. We're gonna look at 21
Not an
dash.
object, Judge. He's actually testifying and arguing what the statute is. He asked a question, he got the answer. Now he's disagreeing with an objection.
I withdraw that statement.
Great, good choice.
Thank you.
And thanks for the mint-based objection.
Sorry, that was, I had no choice, Judge. I'm sorry.
Time was of the essence.
Anyone else want one?
Do not want to move. 21-5-34B is what you're talking about, right?
Correct.
And what 21-5-34B says is you report contributions, right? That's
Correct.
one thing to report.
Mhm.
Expenditures, right?
Correct.
At the time of reporting, right? And it doesn't say anything about exactly what to do in this circumstance, does it? That I just mentioned in my hypothetical.
No, it does not provide you with a roadmap on exactly what to do.
Did you do an assessment of what expenses Judge Coomer's law firm incurred prior to transfers between the campaign account and the law firm account? And when I say expenses that the law firm incurred, I mean expenses for campaign and legislative related purposes. Is that in your paperwork? Is that in your analysis anywhere?
We ran an analysis to see, the answer is yes. And the reason we did an analysis of the various accounts is because Mr. Coomer commingled a lot of his funds and his expenses. So in trying to pull those out, we looked to see what was attributable to where. As far as looking at his law firm operating account and the trust account, there were not a lot of discernible campaign expenses paid for by the law firm.
Did you talk to Kay Smith as part of your investigation?
No, I did not speak with Ms. Smith.
Did you talk to Judge Coomer's former assistant, Deborah Conley?
No, sir.
Do you know how often they were doing work for campaign or legislative related purposes in terms of hours or percentage of their time?
The extent of what I know about their participation in the campaign comes from representations made by Mr. Coomer's counsel.
Excuse me, my question. I know Mr. Lefkoe's been focused on what you found from records you obtained. Was Judge Coomer given the opportunity to supplement any documents you had obtained, the commission had obtained in its investigation/audit? Or were you limited only to things you could subpoena or got to you through other channels? Is
And
that clear? I didn't ask.
no, it's very clear. We are not restricted to just records we can obtain. It is our standard practice when dealing with respondents that we allow them to supplement the record and to provide justification for the expenses they are claiming are not violations.
So when Mr. Lefkoe asked, did you evaluate the law firm expenses to see what might be attributable to legislative expenses? Judge Coomer, through counsel, had an opportunity to give you anything and everything he might want to prepare that would make it easier for you to assess what part of the cable bill is attributable to legislative work versus law firm work, or Ms. Smith's hours, which of her hours are attributable to legislative work versus law firm work.
Yes, sir. We provided that opportunity and Mr. Coomer had very good counsel for this case. And we always provide both that counsel and every other counsel. This is what we're alleging, and we don't play hide the ball from opposing party. We say, this is what we have. This is what we can show. Do you have anything that rebuts that and can show it to be incorrect? And that happened in this case. For example, there was a transfer that was initially alleged to, I believe, a veterans association that Mr. Coomer had access to or founded. And his counsel provided, no, here's the incorrect transfer. Here are the corrective transfers to show that it was an accident, and we withdrew the allegation.
So my last question in this vein then is, when you describe the end conclusions of the commission, that would be after the commission had given Judge Coomer's team a full and complete opportunity to provide whatever rebuttal or additional supplementary evidence, records, et cetera, before the final assessment came down of there was commingling, or it simply was not possible to tell how much of K-Smith's time was used one way versus the other.
Yes, sir, you have that correct. It came after we gave them the opportunity and showed them what we had as far as evidence and were capable of showing.
As opposed to the incentives that Judge Coomer has in this case, do you know what incentive Judge Coomer or his counsel had to provide you with affidavits of K. Smith and incur further attorney's fees in that proceeding, your proceeding, when you were willing to enter into a consent order that said no knowing violation?
I'm not familiar with what his legal strategy would be.
You don't know what incentives he might have had in that proceeding that you were in, since you were going to already enter into a consent order, right?
Correct.
Yeah. Now, there was some mention of a legislative stipend. One thing legislative money can't be used for is campaigning, right?
Correct.
And sometimes the line between legislative and what is campaigning might be a little blurry, right?
It can be.
And would you blame somebody if they used their business staff to do scheduling for them because that line is so blurry sometimes?
I'm going to object to the relevance at this time. I think if we're talking about legislative funds and then business, that's not what we're talking about here. We're talking about campaign accounts. I'm objecting to relevance.
Can you remind us, please, Mr. Lefkoe, about the legislative stipend? I remember someone saying there's $7,000 but
Somebody mentioned it. I didn't bring it up. I mean,
well,
I'm
you
just
did
addressing
just
it.
bring it up.
No, I
so
brought
I'm
it up.
asking, on what basis did you bring it up?
I brought it up because it was brought up before I got to the.
That's what I'm
stand.
asking you. It was brought up in what context, by whom? I'm trying to place it back there as opposed to just pulling it out of thin air. Who talked
Before
about
I
it?
started cross-examining him, either he mentioned it or Mr. Boring asked him about it while he was on the stand with Mr. Boring.
And Judge, I think I may have been a hearing panel member, as
Yeah, maybe.
Mr. Lopez actually asked Mr. Lane about the difference between legislative and campaign, and it had nothing to do with the business. I'm objecting to relevance.
Okay. Explored initially. It sounds like it may be a little far afield, but take a whack.
Okay. And I'm not just talking about the stipend, like your legislative assistant assigned to you or assigned to a representative in the General Assembly cannot be doing campaign work for you, right?
That is correct. You cannot use state paid staff for your campaign. It's a violation of 21.530.2.
And like you said, sometimes that line's a little blurry when you're dealing with lobbyists and things of that sort, right?
Well, it's a little blurry in that an official doesn't stop being an official because they are campaigning.
But if you want to be on the safe side, you don't use your legislative staff if there's any question about whether it's campaigning, right?
You shouldn't.
We looked at some exhibits with a prior witness, which was K. Smith, where Chris Coomer's district address was his law office address. Do you know of candidates and officials that do that as well as Judge Coomer?
Yes, I'm aware of candidates who use PO boxes, their business address, their personal address. I give a lot of credit to the people who use their personal address. I find that to be gutsy.
That's scary. Yeah. What about business phone numbers? Do you know of candidates who use their personal business phone numbers for legislative business?
Yes, there are individuals who use business, personal. Sometimes they use their legislative line.
If
It runs the gambit.
sorry, sir.
Sorry, it runs the gambit.
If allocated properly, you could reimburse your business for its phone costs if it's partially for doing legislative or campaigning business. Is that right?
It's possible if you allocate it correctly.
But under that but-for rule you described, in this era of there are no more long distance charges, you have a flat fee for your phone service. How would you do that? Because but or you'd have to have a phone for your personal business. That's there anyway. And the fact that sometimes you make some phone calls or receive phone calls that are legislative or campaigning. How do you do that?
Yes, sir. You just nailed the issue directly. It has to pass the but-for test. If you are going to incur the flat rate expense for your IP phone, then you're going to fail the test because you're going to be paying that phone bill irrespective of your campaign or not. That's one reason why a lot of these apportionment of rent, utilities, phone bills, they've gone by the wayside simply because they're flat fees now that you're just going to pay because you have them.
But a staffer who you pay on an hourly basis, that could fit very nicely if the right records were kept into the apportionment model.
Yes, sir. That would fit in very nicely if you could either break down their hourly pay, or if you could, if they were salaried and not hourly paid, you could break down the time they spent on the campaign.
Do you operate that breakdown kind of like the IRS does when I'm doing my business expenditures, where you have to have a specific, do you have to have a specific kind of list? It seems to me the IRS requires just some kind of list. Is there something you require specifically?
We generally just rely on the but-for test. The IRS is much more lenient than we are on the reimbursements.
The but-for test, it's not in the statute or the regulations, right?
No, it's not contained within the statute or regulations, but it's how our agency as well as others have determined to enforce the ordinary necessary expense.
That's your rule of thumb when you analyze it, right?
When the commission analyzes it, it's the standard they have adopted. It's not just me willy-nilly applying it.
And when Judge Coomer's trying to assess this himself, or when Representative Coomer was trying to assess it himself, he doesn't have you on his shoulder to tell you what your assessment of the but-for test is, right?
No, but we teach legislators exactly what that but-for test is and how to do it.
Ever see Judge Coomer in one of your classes?
I've not seen him. I could go back and check records, but I don't think he attended.
Do you know if Judge Coomer had a bunch of staff members who were doing his campaign expenses?
I'm not familiar.
Do you know of other candidates and officials who use actual paid persons to do their campaign disclosure reports?
Yes, there are candidates who pay compliance officers to actually maintain their campaign finances. Generally, the higher up the food chain you go, the more likely you are to have compliance staff.
You understand most offices have rent, internet costs, phone bills, right?
I would assume so.
There have been other candidates and officials who have claimed rent, internet costs, phone bills, maid service, right?
Correct. And generally they have a designated campaign office, and that's an allowable expense. Some even have regional offices, to be frank. Yes, sir.
Do you have the consent?
I'm sure I can find it.
I can give him my copy.
We can look at mine. I'm looking at page 2 of 5, the last two entries, 20 and 21, are transfers to Ms. K. Smith.
Yes, sir.
There was a third transfer on October 26th, 2017 for $2,018.36. Or maybe that's a payment to her from the campaign. Do you have any knowledge of that payment, or do you know why it's not listed for the transactions?
If I remember correctly, it was disclosed. We charged it as an unauthorized expense. It's on the next page at 22.
On page 3.
Thank you. Because that one was actually disclosed.
Sure. Yes, sir. It was disclosed and we asked for what was the reimbursement for and didn't receive a response.
I want to talk about travel, and I'm going to circle back to some of these topics.
Okay.
But I want to talk about travel. And have you ever been to a destination conference like I have?
I have, yes.
Where have you been to destination conferences?
Oh, I think the funnest one is the Family Law Conference, generally at Amelia Island.
And were you a practicing lawyer at that time?
I was.
And did you charge that to your expense, or did you expense that with respect to the IRS?
The firm covered the cost, so I'm not sure how they expensed it.
you don't know if they charged it as a business expense in terms of their line items when they submitted their taxes, right?
I'm willing to bet they expensed it with their taxes, but I couldn't tell you because I wasn't a member.
Sometimes you look for conferences and destination places, right?
I'm well aware of people looking for SCLEs, as we like to call them.
Yellies, I like that. All right. So in summary about Hawaii and Israel, is it fair to say that Representative Coomer paid some expenses with personal funds, paid some with campaign funds, paid some back when one trip blew up in terms of business purposes, and should have paid back more, right?
I think that's a fair summary.
And you did not allege that was criminal conduct in violation of 21-5-9, right?
I don't believe we did.
Now, are you familiar with the per diem rate for? That was the per diem. Tel Aviv. Are you familiar with the per diem rate for Tel Aviv back in 2017?
I know we reviewed the General Services Administration for it, but I couldn't tell you exactly what it is today.
And by per diem rate, the candidate can charge the campaign a set figure per day for days when he is or she is doing campaign or legislative related activities, right?
Correct.
Now, so you looked at that itinerary, right?
So that rate would vary. London would be higher because it's expensive than Macon, wonderful place, but cheaper to circulate in Macon than in London.
Yes, sir. It fluctuates based on the cost of living in the local area.
Not just that Georgia determines, hey, you're a Georgia legislature, you get $50 a day wherever you go.
Correct. That wouldn't go very far in London.
All right, so let's start with September 23rd, 2017. And I will represent to you that, and Judge Coomer will testify to this.
Objection to.
I haven't even finished.
Representing facts and telling him what Mr. Coomer, Judge.
There
Coomer
was
will
not a
testify
way
to.
you could successfully complete that question. So
Fair.
word it differently, please.
If the per diem rate for Israel was $571 per day, hypothetically, on September 23rd, 2017, on that date of a travel day to Israel for a mixed-use trip, could Judge Coomer, Representative Coomer at the time, have charged a per diem rate of $571 for that day?
For the travel day, yes.
Did he charge a per diem rate to his campaign for that trip?
Not that I recall.
So then let's go to September 24th, 2017. Traveled to Tel Aviv for a meeting at the bridge. A technology innovation incubator sponsored by Coca-Cola. 7 hours on official functions that day. Did you look behind that and say, no, that's not right in terms of hours?
No, if I recall correctly, that's one that we agreed to let him have, because as Judge McBurney said, what's good for Coke is good for Georgia.
Right. All right. So on that day, Judge Coomer could have charged a $571 per diem rate for him to the campaign, right?
Correct.
Did he do so?
Not that I recall.
And we agree that he didn't charge any per diems for any of the days that would have been legitimate legislative or campaign.
I don't recall any per diems being charged.
And not only could, so out of this, how many days on this itinerary could Judge Coomer have charged a per diem rate, in your opinion?
His travel day, and then the event in Tel Aviv to the bridge, and then there's the event for the National Bottling Group. Which is,
And return,
September 28th.
thank you.
and return travel, right?
Yes,
So that's 4
correct.
times 571 or whatever the per diem rate was for Tel Aviv back in 2017, right?
Correct.
So if his spouse had an official function on those days, she could also charge a per diem rate, right?
Yes.
So that's 571 plus 571, right?
Well, and let me clarify just a little bit. When you say charge a per diem rate, they would be authorized to expend that money if they incurred the charges. With the prohibition you have in 21.533C, if you don't incur the expenses, you can't just profit off the per diem. It's not like when you doing government travel and they pay you irrespective of what you pay.
What do you have to spend the per diem on?
You can spend it on your lodging, you can spend it on food, your incidentals of travel, you need a baggage card at the airport. You take a cab.
You could not bill your campaign or have the campaign pay for your hotel separately from the per diem. The per diem reflects in part the cost of lodging in that location at that time.
I think you could do either or, but you would have to pick. You could either pay the hotel rate, because as I said, we don't determine best and highest use of funds. So if you want to stay at the Shangri-La, you could pay that, or you could do the per diem rate, your choice.
Do you have to, on your campaign finance disclosure forms, disclose an itemized list of what you spent the per diem on? Or do you,
I'm gonna object at this point. I think we're mixing apples and oranges. He's talking about the per diem. That's not the campaign. That's something different. And so he wouldn't be disclosing that on the campaign disclosure report, I don't think.
Well, I guess this witness could say that's not what you would put on
Sorry.
a campaign disclosure form.
For if you are using campaign funds to reimburse yourself for official travel expenses, you have to itemize what those expenses are with two rules. If it's an expense less than $100 and it's not aggregated to the same end recipient, you can just do a straight figure number. So if you paid the baggage handler $20, you just put in $20 on unitemized expenditure, it's a reimbursement. But if the end recipient aggregates $100 or more, you have to itemize those expenses.
if you decided to pay the per diem rate from the campaign to the candidate or official, how do you put that on your disclosure form, and where is it in the statute supporting what you're about to say?
The expenditure requirements contained at 21.534 subsection B. It requires you to list your expenditures when they are aggregating over $100, so $100 and a penny. If the end recipient gets more than $100 and a penny, you have to itemize that transaction. If it's $100 or less, you don't have to itemize it. You just tell us how much you spent.
The phrase per diem wouldn't appear on the CCDR. You would be putting on a CCDR, I spent $120 at this fancy restaurant in Tel Aviv, name of restaurant, in recipient. Whether you then pull that money from your per diem as you're trying to get, I mean, that's
We don't care.
separate.
Yeah, listen, you are not bound by the limit of your per diem. You can spend all your campaign funds if you want to.
Regardless, we talked about this regulation. There are other candidates who have in the past and probably continue to do so, itemize or don't itemize expenses on a credit card that the campaign pays, right?
They're going to find that much harder to get away with now because that's one of the auto flags on our new system. If you just put miscellaneous in a credit card, actually, it won't let you just do miscellaneous now on the new system. If you pick credit card payment, if you don't input the end recipients, it won't let you proceed forward. It locks you out. So
You can, but when the disclosures that Judge Coomer and Representative Coomer made for campaigns were made in 2015 through 2018 that were the subject of your campaign finance commission proceeding, that was not the case, right?
no, it was not.
And if a candidate or official had decided to look on your website, they could search reports, right?
They have the ability to search reports. That is correct.
And you could theoretically find reports and see if other people are doing it where they're just listing Amex or credit cards, miscellaneous expenses, right?
It wouldn't surprise me. There's a lot you can find by searching the reports.
There was an exhibit that went up before. Can't remember, what did we, you know, the exhibit number chart?
It was the one I was about to show him.
I don't, I've got it up here. And did you do a calculation of the percentage of,
What's on the screen?
I'm sorry, this is 253. This is the comparison of challenged expenditures to Christian A. Coomer total campaign transactions.
It's exhibit 253.
253. Did you do an analysis as we did comparing the challenged expenditures of Judge Coomer to all total campaign transactions that Judge Coomer's had as a candidate or official?
I did an analysis, but I did not include some of the years that you did.
And so you don't know whether from the total figure of Judge Coomer's campaign history or official history in submitting campaign disclosure reports, that the challenged expenditures constitute 1.04% of total contributions and expenditures. You don't know whether that's the case or not, right?
That would only be correct if you took prior years and years that we didn't audit as truthful and gave him full credit for that. If you include only the audit period, the error rate is 14.9%. And if you don't include the Court of Appeals $50,000 transaction, the error rate's closer to 20%.
So
For the years you didn't audit, there could be, we don't know.
Mhm.
There could be more of these transfers from law firm to campaign account and back, or credit card miscellaneous $2,000 unitemized.
Yes, sir.
You just didn't eyeball those.
We didn't look, we can find our audit to the records we had available, which was March 2015 forward. We did not go beyond or go backwards in time into calendar year 14 through, I think, 2008.
Right. So we talked earlier about this exhibit 319, remember?
Yes.
I said it's too big to put a binder clip on. Constituting all of Judge Coomer's reports from 2008 to 2020 in reverse chronological order. Remember that?
Yes, sir.
Now, starting with the more recent reports in this exhibit. Okay. Do you see where in the Court of Appeals campaign contribution disclosure report, in terms of expenditures made on page 14,
Mhm.
Bates label 14.
Okay.
That the expenditures made during the reporting period for that reporting period, when Judge Coomer was a judge versus when he was a representative, were significantly less than the expenditures he made when he was a representative, right?
Correct.
And that's something you would expect, right?
Not always. Sometimes if a judicial officer has an opponent, their expenses can exceed what a representative would do.
In a non-election period, though, you would expect a judge to not have all that. It would not, he would not have all the, or she would not have all the expenses that you would see of a majority whip in session, right?
Well, I believe this is the reporting period right before the commencement of his election cycle in 2020. So you would start seeing a campaign gear up in 2019, the latter months.
Okay, well, let's look at other Court of Appeals. Courts. Here's one from, like it's filed January 7, 2020 for the period non-election year ending December 31st, 2019. You see that
I
on
do.
page 20? See that, sir?
I see it.
And then if we look at the expenditures made during that period, itemized expenditures totaled, or the total amount of expenditures was $9,165.95. That's reported on that form, right?
Correct.
Did you challenge any expenditures that Judge Coomer made in his Court of Appeals campaign contribution disclosure reports?
For his Court of Appeals, aside from the loan, no, we didn't. What we noticed is after his appointment, he got very squeaky clean with his disclosures.
I asked about expenditures. Did you challenge any of the expenditures that Judge Coomer made for his Court of Appeals campaign at any time?
Not that I recall, no.
Did you challenge any of the contributions reported by Judge Coomer for his Court of Appeals campaigns at any time?
Aside from the $50,000 transaction, no.
It's not a contribution, is it?
Well, actually, you pulled up the definition of contribution, which showed a loan counts. An
Extension of credit, right?
However you wish to determine it. It would
I
count as
stand
contribution.
Is it your general practice that the majority of candidates and officials come to you in advance for guidance on everything they do?
No, I don't think they all come to us before everything they do, but it's not uncommon for them to reach out to us before they do something they have a question about. Some are more user intensive than others.
Is there a definition of refund or reimbursement in your campaign finance statutes or regulations?
I don't believe it's contained within the code. If it is contained, it's within the rules and regs in the definition section, but without reviewing it, I couldn't tell you right off the top of my head.
Are you aware of the case law that unclear laws such as these campaign finance laws must be construed against the state?
Yes.
Best and highest practice is not defined anywhere in the statute or the regulations. Agree?
Correct.
If your children are doing fundraising for you, you can charge against the campaign for that, right?
Well, it depends. What are you paying them for?
For their time doing fundraising activities.
They are capable of drawing a paycheck just like any other campaign employee.
Yes, sir. You mentioned in your examination that I think it was your direct that there are some tricky questions sometimes when dealing with campaign finance laws, right?
Yes, sir.
Your personal rules of thumb are not contained within the statutes or regulations, correct?
Correct. And I don't hold anyone to my personal rules of thumb either.
When you said that you looked at whether a state agency, what was that state agency you mentioned, set up a trip?
Oh, the economic development?
Yeah, that's an executive branch agency, right? Yeah, you realize that Judge Coomer was a representative in the House of Representatives of the General Assembly, right?
Yes, I am, but that doesn't necessarily make every trip he does an official legislative trip either.
Didn't say that, sir. Now, the House of Representatives is a separate branch of government from the executive branch, right? Right, can I have 1 minute to consult my co-counsel?
All right, imagine the umpire walking out to the mound now. That's the end.
Yeah, that reminds me of Judge Westmoreland when I was in Fulton, and he told the opposing counsel who was a New Yorker, he said, "I think the Yankees are about to wind up for the first pitch." So I'm through with my cross-examination. Thank you.
Thank you, sir. Mr. Boring, how long would you guesstimate your redirect would be if you're doing a redirect?
I'm gonna try to get this done in 5 minutes max.
All right.
All right, Mr. Lane. Demonstrative today talking about the total of expenditure, spending, and challenged accounts.
Correct.
I know you've already addressed all the stuff that happened way before you could investigate. But they put a total challenge expenditures of $13,000 on there. Was the challenge expenditures in the consent agreement close to 20,000?
Yes, it was.
Would that completely impact the percentages that he tried to argue were appropriate?
It would.
Children and fundraisers. Did they provide you with any documentation of paying money to Judge Coomer's children for fundraising?
No, sir.
Let's see.
We talked about, Judge, or Mr. Lopez's question about the consent agreement as to K. Smith, the $2,700 payment. That was actually disclosed, correct?
That was disclosed.
In the
on a-
consent agreement, you found it to be unnecessary and unordinary expense and a violation, correct?
Correct.
And that's when they agreed to and had the opportunity to present you with evidence to rebut it.
Yes, sir.
Let's see. Skip that one. Okay, red flags and violations for audit. Would something you don't know about show up on as a red flag on an audit?
No, if the transaction's not disclosed, we won't see it.
The bank records you got, did you get those from us or get those from law enforcement? If you remember.
I want to say it came directly from the GBI, but I could be incorrect.
And were you involved? Did you have discussions with both the federal authorities and the GBI on this case?
Yes.
And had they already started investigations before you got involved?
I'm going to object as beyond the scope of direct, also calls for hearsay.
And this is exactly rebutting what he was talking about different agencies, Judge.
Right, so the hearsay part overruled as to beyond scope. Not sure that really applies a whole lot anymore anyway, but let's not get into any content of
No.
any communications with a federal or state agency.
I was just, yes, I'm not going to. Did you have contact with them and had they started their work before you even got involved?
Lack of foundation, he does not know, he's not established that he knows what the status of any investigations is.
Do you know if law enforcement, I'm not talking about right now, but back when you started your investigation, had law enforcement agencies already begun investigations?
Calls for hearsay, lack of foundation.
Did you know from speaking with those agencies or being in meeting with them?
Calls for hearsay, lack of foundation.
I'm out. So, Mr. Lefkoe, how can he answer the question of whether he met with them? You're objecting to, did you meet with them or?
No, he can
Okay.
answer that. That's fine.
Okay.
He's asking them, what's the status of their investigations? And that's only things he could hear from other people.
And I did not ask that.
What you sort of did, but
Okay.
why don't you ask this witness if he met with whatever agencies you want to ask about and at whose request, and we'll, based on who's requesting it, we can sort of figure out who would have moved first, or if someone was already moving.
Okay. Did you meet with other law enforcement agencies about campaign finance issues?
Yes, we met with representatives from the Georgia Bureau of Investigation.
And had they already begun their investigation when you met?
So
Same objection.
don't answer
Okay.
that. How's he going to know that without GBI saying, by the way, we've already done?
Okay,
X."
did they come to you all?
They did come to us.
You were asked questions about crimes and that type of thing, from misdemeanors. Can the use of campaign funds, if it's using electronic transmissions and bank accounts, can that be federal crimes?
Yes, it can.
He's,
It's a response. Okay,
There was
sorry.
no objection.
Sorry.
There was a wave, hand wave and a he's, and he stopped.
Okay, when they talked about the no knowing violation, is there an affirmative finding in the consent that there was actually no knowing violation? Or was it that you withdrew and said you are not alleging that there was a knowing violation?
The way it is termed is that we did not allege a knowing violation. We didn't have to allege intent.
Did the commission make an affirmative finding that there was no not knowing violation?
No, sir, we never addressed intent one way or the other.
Okay, I think this was covered. That as far as if Judge Coomer has a law office and he's already paying for the law office and he's paying for the phone and the cable and all that in rent, can he use campaign funds to pay for that?
No.
Almost 75. Just finally, from the bank records that you already had before you got the American Express and before you filed the first October complaint, had you all already identified suspicious activity with the Amex from the bank accounts that you had?
Yes.
That's all I have.
Mr. Lefkoe, anything briefly?
no, I don't. No, thank you.
May Mr. Lane be released, or at least leave for today?
Yes, Your Honor.
All right.
From our perspective, yes.
Thank you, Mr. Lane, for all your time. we're going to take an afternoon break. It is 2:47. Let's be back by 3 o'clock at the latest. But before we break, the next witness for the director or Ms. Cross is,
Speaking role is Mr. Lundberg for the, or Lundberg for the JQC. And can I raise a scheduling issue?
please.
Mr. Lunford is from out of town and he is scheduled to return this evening. I know the court said something yesterday about perhaps an early break today, so I was just making everyone aware of that. For your purposes, the direct of this witness will be approximately 25, 30 minutes. So that leaves however much time the rest of the day for,
Lumberg is next.
yes, sir.
And he's the one who needs to get out of town.
That's the
We'll be fine
preference.
unless there's an hour and 30-minute cross.
That was more my concern.
Just to confirm, my recollection was you were talking about breaking about 4:30 today, is that right?
It's going to be back towards 5 again. Things have changed a little bit with some of the panelists. So I think we'll aim to go till 5-ish. Again, if there's a natural break point, we might break a little bit before then. We won't go as late today as we did yesterday. But we should be able to get through the witness you mentioned.
Thank you.
All right?
Back by what time?
Still 3 o'clock. You guys just used up 2 minutes of your break.
Got such clarity now. All right, yeah. Doesn't matter to me if it's here or there.
Ready? Excellent. We're ready. Welcome back, ladies and gentlemen. Ms. Cross, if you would call your next witness, please.
So JQC calls Donald Lundberg.
Judge, so before we went on break, Ms. Cross said that she would be about 20 or 25 minutes concerning this legal expert, and he has a time limitation, which I don't believe I knew about that before, but I've looked at my notes. I don't think I can get him done in an hour, hour and a half. I mean, I think the Philhart allegations are extensive and there's a whole lot to unpack, and I don't think I can get it done in that time.
Okay.
Well, I can perhaps shave a minute or two off. It's possible that Mr. Lefko's planned cross-examination would go faster based on objections and some other things. Other than going as fast as I can and alerting everyone to the situation, I'm happy to make any other accommodation, but that's what I got.
No, I understand. I'm wondering if your cross-exam takes out, I mean, your direct takes as long as it does, and then Mr. Lundberg needs to go before Mr. Lefko is finished and you haven't been able to do a redirect. How do we reconnect with the witness? In other words, if we stop today and the examination is not complete, how do we, I don't know the logistics after today for the witness. Is it then a Zoom witness?
Actually, that could be an option if we need to.
Okay, all right. I want to be clear, no one is being truncated in any way. Explore things as fully as you need to. And it may be that we pause this witness's testimony, pick up with another witness with whatever's left of today or first thing tomorrow, but we'll make sure during the course of this week, not part B to this, we complete the testimony for this week.
Thank you, Judge.
Sure.
And if you wouldn't mind, Your Honor, switching back to the podium access to the monitors. Thank you. Thank you. Mr. Lundberg, can you raise your right hand, please? Do you swear from the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State and spell your name for the court reporter, please.
Donald R. Lundberg, Lundberg. I'd like to apologize to the panel for the way my face looks. I should have checked the subspecialty of my dermatologist. I think it was sadist, but here I am. And she wouldn't promise I'd look any better after it was all done, so.
We appreciate you being here. I'm going to, for opposing counsel's information for the panel, several documents that have already been admitted. They're exhibits number 130, 131, and 139. Those are the 3 promissory notes. Exhibits 143, 147, and 148. Those are the 3 wills of Mr. James Philhart. Exhibit 151 and 152. Those are the trust documents, as well as exhibits 196 through 201 and 156. Those are a series of email communications that have already been admitted between Mr. Philhart and Mr. Coomer.
I missed one exhibit. You said 143, 147, and what for the wills?
143, 147, and 148.
Thank you.
So no new exhibits at this juncture with this witness.
Correct. That's just for everyone's reference and knowing that the panel has those already.
Thank you.
All right, Mr. Lundberg, can you tell the panel, please, a little bit about your current occupation, what you do, and what your role is here in the case?
Sure. I'm a lawyer in private practice. I'm admitted to practice law in Indiana. I'm actually currently living in New York and essentially winding down my Indiana practice. I'm a solo practitioner at my own law firm, Lundberg Legal, which I've had for maybe 6 or 7 years now. Before that, I was the deputy general counsel of a large national law firm, Barnes and Thornburg, that does have an Atlanta office. Before that, for 18 years, I was the executive director of the Indiana Supreme Court's Lawyer Discipline Agency. The first 15 years of my practice, I was a civil legal services lawyer representing poor people. I've limited my practice pretty much since leaving the disciplinary commission to representing clients in professional matters, generally lawyers and judges, occasionally some other professions, but mostly lawyers and judges.
And how long, I'm gonna, marker I've already provided exhibit 255. Did you provide a copy of your current resume, Mr. Lumber? And is that contained in what I marked as states? JQC exhibit 255?
Correct. I would hope I would never give anybody this resume. It is a curriculum vitae, and so it's more complete than one would normally consider a professional resume.
These 32 pages in exhibit 255, that's your complete and current CV?
It is.
And Mr. Tender, 255 at this time.
Any objection?
No objection.
Admitted?
Mr. Lundberg, you've talked a little bit about your experience. I want to focus your attention. Can you tell us, please, what is your experience or how long have you practiced primarily in the area of legal ethics, rules of professional conduct, and related fields?
Since 1990-ish, probably 1991.
And in that time frame, have you had occasion to publish articles, present CLEs, or the continuing legal education in that field?
Yes, I've spoken frequently. I was a longstanding member of the National Association of Bar Council, made many presentations, former president of that organization, made many presentations at their conferences, have spoken extensively on legal ethics matters in continuing education programs. And for 15 years, I wrote our state bar journal is published 10 times a year, not monthly. And I published an article called Ethics Curbstone on legal ethics topics in that every issue of that journal for 15 years.
I appreciate you summarizing that experience for us. Are the itemized and—
I'm sorry, Mr. Lefkoe.
I was just going to say, we stipulate to him being an expert with respect to legal ethics, if that shortens any amount.
Okay.
Legal ethics and rules of professional conduct is the area I would tender this witness in.
Stipulated.
No objection. All right. So Mr. Lundberg, for purposes of this hearing, you're deemed an expert in the field of legal ethics and rules of professional conduct.
And Mr. Lumberg, if you could, you told us that you've practiced in Indiana primarily and now in New York. And can you tell us what, if any, similarities there are between the rules of professional conduct for attorneys in Indiana? You've identified some federal experience for us and how that compares with the rules in Georgia.
Right. Well, I do want to be clear. I'm licensed in Indiana. I am not licensed in New York. I say that often because it's an important distinction to make. Every jurisdiction, so far as I know, in the United States, patterns their state rules of professional conduct to a greater or lesser extent on the ABA model rules of professional conduct. And so all of the rules of professional conduct from around the country tend to be an awful lot alike. Now, every time you get lawyers in a room to make things like rules, they think they can do something better than the other people did. And so they will make changes. Sometimes it's to accommodate, local practice and local custom. Other times it's because they just think they can do it better. And so you get changes that come into play among the various jurisdictions. And so with specific reference to Indiana and Georgia, there are some differences. For purposes of the rules that I was considering in reference to the Phil Hart matter, there are differences in language, but the key concepts are very, very similar.
And have you made yourself familiar with the differences and the similarities between the rules as they are in Georgia, in federal court, and in Indiana, where you generally practice?
I have.
All right, and you mentioned the Phil Hart matter. Did there come a time, Mr. Lundberg, that you in fact served as an expert witness in a legal malpractice case that was brought?
Well, a legal expert of sorts. I understand Georgia practice, unlike Indiana, to require the affidavit of an expert in order to file that must accompany the complaint for legal malpractice. That's not something I know much about because it's not required in Indiana, but it is in Georgia. And I was approached by counsel for Mr. Phil Hart, who I understood was having some difficulty finding a Georgia barred expert if I would be willing to assist, and I was happy to do so.
Does the name Wright Gammon, does that sound familiar to you as the attorney who approached you on behalf of Mr. Phil Hart?
Yes, that's correct.
All right, and did you in fact prepare an affidavit for use in the civil litigation related to the allegations Mr. Phil Hart was making against
I did.
Judge Coomer?
I did.
Okay. After, my understanding is that that litigation has resolved. Is that correct? To your understanding as well?
So far as I know, my contact with the case began and ended with doing the affidavit, but I think I understood generally that it had concluded in some fashion.
And informing your opinions as they were reflected in the affidavit that you provided for purposes of the civil litigation. Did you review documents and form opinions in the case about whether there were violations of the rules of professional conduct that had occurred in the interaction between Judge Coomer and James Phil Hart?
Yes, I did review a universe of documents, perhaps the key documents. I'm not sure if that's an accurate description, but I did, and I reached some conclusions about what those documents reflected.
There are some documents there in front of you, exhibits that have already been tendered and admitted. They consist of 3 promissory notes. Those 3 promissory notes are those documents that you reviewed in preparation for your preparing your affidavit?
No, 2 of the 3 were. There's a promissory note, Exhibit 130, dated December 6th of 2017, which was not among the documents I reviewed for my affidavit. The other 2 exhibits, 131 and 139, those 2 promissory notes were documents that I reviewed.
Since your involvement in the Phil Hart versus Coomer matter, have you come to review exhibit number 130, what we'll call the 3rd promissory note?
Yes, I have looked at that.
Okay, and that exhibit 130 is a December 6, 2017 note?
Correct.
Okay. There are also 3 documents in front of you that purport to be wills prepared on behalf of Mr. Phil Hart.
Yes,
Those are exhibits number 151, 152, and 147. Is that right?
actually, no, 143, 147, and 148.
Thank you. Is exhibit 141 and 151 and 152, are those trust documents?
No, yes, 151 and 152 are trust documents.
Are those 5 exhibits that I've just referenced and that you have there in front of you, were those documents that you had at the time you reviewed the material and formed your opinions in the case?
All of them except Exhibit 143, which is a last will and testament of James Pat Phil Hart, dated May 4, 2017. That is not one of the documents that I reviewed in preparation of my affidavit.
Between the time you prepared your affidavit and your testimony today, have you reviewed that document?
I have.
And have you come to form opinions about the contents of it?
I have.
And the last collection of exhibits there in front of you, Mr. Lundberg, they are a series of email correspondence between Mr. Phil Hart and Mr. Coomer. Is that reflected in those exhibits there in front of you?
Yes, exhibit, well, I guess it's exhibits 190s. Well, I won't give all the exhibit numbers, but yes, there's a pile of emails that have exhibit numbers at the bottom.
Okay. All right. And did you let us know that you reviewed and made yourself familiar with the Georgia Rules of Professional Conduct. I want to direct your attention to the first slide. You see it there on the screen in front of you.
I do. I'm actually looking at a paper copy, but yeah.
Also, yes, there's that in front of you as well. It's up on the screen. Choose your preferred perspective. Rule 1.7, it's on the screen and we can all read it for ourselves, but can you generally summarize what Rule 1.7 means and how it relates to this case?
Right. Well, this is 1.7A. There's a separate subsection 1.7B. 1.7A is really more or less a codification of what is a fiduciary relationship between lawyers and clients, where the lawyer's responsibility is to attend exclusively to the client's interests and to avoid any other impinging interests that might detract from the lawyer's loyalty to the client. And what it says is, in effect, that if there is any significant risk that that lawyer's responsibilities to the client could be materially limited, then the lawyer has a disqualifying conflict of interest. And I should add that among the detracting interests that would create a conflict of interest, it could be another client, it could be a former client, or it could be the lawyer's own interests.
And I've got up in front of us now 1.7B, referred to a second portion. Can you, again, we can all read it for ourselves, but in general, can you summarize for us how Rule 1.7B applied, if it did at all, to the documents you reviewed and your opinions in the case?
Right. So 1.7B says that if there is a 1.7A conflict, under certain circumstances, it can be waived, or the representation can be consented to by the client if the client gives informed consent, knowing all of the pros and cons of having that particular lawyer who otherwise would have a conflict do the representation versus another lawyer. There is a provision there that any such waiver of a conflict of interest, a 1.7A conflict of interest by a client, must be confirmed in writing.
All right, and this is the last one we're going to talk about in a general sense, Rule 1.8A. Oh, it's scrolling out very nicely there. Rule 1.8A, did that have any application to the analysis you did in the case and the opinions that you formed?
It does. What the 1.8 rules are a series of rules that are essentially specific applications of the more general conflict of interest considerations that appear primarily in Rule 1.7. And 1.8A is a specific rule that deals with transactions, typically economic transactions, financial transactions between the lawyer and the client, where the lawyer brings to that transaction the lawyer's own interests in the financial aspects of the transaction. And so it has, as part of it, I will say, both a procedural and a substantive element. The procedural element is that the client must be fully informed and meet the definition of informed consent that appears elsewhere in the rules, and must have certain disclosures made in order for there to be a waiver of what would otherwise be a disqualifying conflict. More substantively, 1.8A says that any transaction between a lawyer and client has to be fair and reasonable to the client. And what that means is that a client is never allowed to be approached to consent to a transaction that is unfair or unreasonable to the client.
So even with an appropriate procedural waiver, as you've described it for us, an attorney can never have a client waive an unfair or unreasonable term. Is that what you're saying?
That is what I'm saying, yes.
All right, I want to direct your attention to what you've got there in front of you, that first promissory note, December 6, 2017.
Yes.
Exhibit 130. Have you got that there in front of you?
I do.
Okay. Now, we've already been through the terms of that particular promissory note, but I want to know what you, Mr. Lundberg, found, if anything, that was problematic or applies to the rules that we've just discussed in Exhibit 130.
Right. So there are some aspects of this note that I would consider problematic in terms of 1.7A and 1.8A. This is a transaction between a lawyer and a client, or an entity in which the lawyer is interested. In this case, the entity is an organization or a limited liability company called CAC Holdings, which I believe is a limited liability company whose sole member is the respondent in this case, Judge Christian Coomer. And so because he had an interest in the transaction, he, the judge, then lawyer, had an interest in the transaction, the rules that we have been discussing would have come into play. And so particularly with reference to the fair and reasonable requirements of 1.8A, there were some concerns here. As I understood it at the time of this note, Mr. Phil Hart would have been 76 or maybe 75 years old. So he was an elderly gentleman. I can say elderly because that's older than I am. And so we have a term of repayment term for this note of 240 equal consecutive monthly installment payments, meaning it would be payable over 20 years. That would have made the note not fully payable until Mr. Phil Hart was in his mid-90s, which is an age to which most people don't live. This was also a note, as I mentioned earlier, where the obligor on the note was CAC Holdings, not Judge, or I'm going to call him Mr. Coomer just because he was a lawyer, not a judge at that time, that Mr. Coomer was the sole member of. And CAC Holdings, though, was the borrower. And so the credit worthiness of the borrower would have been the credit worthiness of CAC Holdings. And the obligor on the note, and therefore the person against whom Mr. Phil Hart would need to go if there was a breach, would have been CAC Holdings. We know, well, I shouldn't say anything about we. I had no information that led me to believe that CAC Holdings was good for this note. And even if it had been good for this note on the day it was, the promissory note was entered, a week later, those funds could have been transferred elsewhere.
Did you see anything in the document that led you to believe that Exhibit 130, that promissory note, contained in any way a personal guarantee, anything beyond the obligation of the CAC LLC?
No, there was no personal guarantee that I saw. So that meant that it was only CAC Holdings that was on the hook. It was also an unsecured note. It purported to have security in the form of a secured interest in a real property located at 26 Aiken Way Northwest in Cartersville, Georgia. As it turned out, that, at least as I understood, that was the property that was owned by Mr. Phil Hart. And so it was Mr. Phil Hart's own real estate that was the purported security for this note, and which he already owned. So there was in effect no security for this note.
Certainly, you never reviewed any documents, and you have no information that either Mr. Coomer or CAC Holdings LLC had any financial interest in the personal residence of Mr. Phil.
I'm not aware of any.
I object as leading the witness.
As if you had any information.
No, it was a leading question. Sorry.
It had the word certainly in front of it, but other than that, the question was, do you have any information that CAC Holdings had an interest in, or Mr. Coomer, Judge Coomer, had an interest in Mr. Philhart's house.
Do you have any I have no objection to? This, I heard it as certainly you don't have.
I can certainly rephrase it.
Okay, thank you.
Can you please, Mr. Lundberg, explain to us any evidence that you have reviewed or any documents or any information that established to you that Mr. Coomer or CAC Holdings LLC had any financial interest in the home that Mr. Philhart was living in at that time?
I'm not aware of any.
On the face of the note, it appears as though a personal residence, or at least a property, is being held as the security for the loan. Is that correct?
Yeah, on the face of a note, it appears a piece of real property located at a specific address in Cartersville, Georgia, is being held out as security for repayment of the note.
What, if anything, about the term of the loan? I think you talked about that a little bit in relation to Mr. Philhart's age. Is there anything about the interest rate that you found was impactful on whether Rule 1.7 or 1.8 was implicated by the terms of this promissory note?
Well, the interest rate was 4.5%. Standing on its own, that may have been considered a fair interest rate or not, but in the context, I can't imagine that could be considered a fair and reasonable interest rate of a loan from a limited liability company with no security and no cosigner or guarantor to bear an interest rate of 4.5% seems to me to be an extremely low, shockingly low interest rate.
And I think I was the one who used the word first, but we talked about things or terms of this note being problematic or of concern as it is relative to these bar rules that you've talked about. Are they in fact, in your expert opinion, or you tell me, in your expert opinion, were the rules that we've talked about, Rule 1.7 or 1.8, were they violated by the terms of this promissory note?
I don't consider.
I'm going to renew my objection that we made in motions in limine, but a legal expert telling the panel whether a rule has been violated where the rule stands for itself and speaks for itself is unnecessary. It's not helpful. It's under 702 inadmissible.
Under 702, you actually helped me, I think it's 704. I reviewed after our discussion, which helped me appreciate that whole ultimate issue prohibition has greatly narrowed. You didn't invoke 704 here because I don't think it would apply anymore. It might have long ago. But what's the 702? Just it's not helpful to the determination we need to make.
Yeah, I don't think it's permissible. I mean, if it's a legal malpractice action where there's a standard of care issue, in order to establish the standard of care, you've got to establish whether somebody violated some duty that they had. And this expert is not testifying in a malpractice action. He's testifying and just telling you, in my opinion, the rule is violated, which everybody can read the rule. Everybody can look at the evidence. Judge Coomer admitted on the stand as to certain rules violations. And so it's unnecessary, unhelpful to the panel in terms of under 24-7-702.
Okay. Russ.
The witness has been tendered and accepted without objection as an expert in this field. He's detailed his expertise and his experience. While the rule is what it is and the panel will make the ultimate decision, the witness's expert opinion is informed and I believe helpful to the panel and is properly admitted.
It's helpful.
Thank you.
Is that overruled, Judge?
Yes, sir.
All right. So I think my question to you, Mr. Lundberg, and I want to make sure I ask it again, because I think I was the one who started it. We talked about terms being either problematic or of concern. And when I'm talking about those terms, I want to know what you mean when you're talking about those terms. Do you mean that they are a violation of the rules of professional conduct?
I don't think the terms are fair or reasonable, and therefore they violate Rule 1.8A. There's also attached on page 3 a disclosure that's purportedly to comply with the procedural aspects of 1.8A that I described earlier. And it does use the language of 1.8A, and it does sort of summarize the aspects of the note but it is not the kind of disclosure that would support informed consent by a client. Let me just give you an example. It doesn't tell the client that because the borrower is CAC Holdings, the ability of CAC Holdings to repay this note is completely up to whatever CAC Holdings itself happens to have in the way of money at the time the note is due. It likewise does not say, although it mentions Christian Coomer as the sole member, it doesn't say that CAC Holdings is not backed up with a personal guarantee of Christian Coomer, and therefore that Mr. Philhart did not know and should have been informed that his ability to ever see this money again completely hinged on the willingness of CAC Holdings to make those funds available to repay the note. He had nothing else to go on.
Do you recall the other two promissory notes contained in the exhibits in front of you? They contain similar purported 1.8 statements.
Yes, I do. Exhibits 131 and 139. I understood the 130 promissory note to have been actually paid off on March 8th of 2018. The fact that it happened to be paid off doesn't change my testimony, by the way. But the other two promissory notes, 131 and 139, essentially suffer from the same deficiencies. There are larger amounts of money, so that's a greater concern. And in the case of 131, the payment terms are 30 years rather than 20 years. 139 actually is 6 or 7 years and then a balloon payment. But that still would be a matter of concern to me. The interest rates vary as well, but 3.3%, 4.0%, both of those are actually lower interest rates than the interest rate in Exhibit 130.
And I think you indicated you found the terms, were they equally unfair and equally unreasonable, or in your opinion, did they vary in their unreasonableness and their unfairness, but they all fell in that category?
Well, I guess the way I don't want to be too flip about that. If the terms are unfair and unreasonable, they're a violation of Rule 1.8A. There aren't gradations of violations where there's a real bad violation of 1.8A and a not so bad violation of 1.8A. All three of them have the same deficiencies that caused me to believe that there were 1.8A and 1.7A violations.
And insofar as all three notes contain this generally similar 1.8 conflict of interest notice, you found that insufficient in all three of the documents?
Right, for the same reasons that I don't know that, well, I have no idea what was Mr. Philhart's state of mind. I've never spoken to the gentleman, but the burden in gleaning or in gaining informed consent is on the lawyer to bring that information to the client so the client can make an informed decision. And there's nothing in those notes which kind of mouth what 1.8A is sort of about procedurally, but don't really let him know that if it comes to a breach, he has very little legal rights with these instruments.
So your expert opinion is that letting the client know that the word used in here is desirable, I'll say wise. It's wise that you consult with outside counsel. That's not sufficient. That's a necessary part of this waiver, but it's not sufficient because the waiver also ought to highlight the specific risks posed by the nature of the obligation. And you flagged them, but in particular, its utterly unsecured nature. That's not in there at all. Do you think that 1.8A imposes that obligation on the attorney to highlight, if you go talk to another lawyer, these are the kinds of things you'd want to talk about?
Right, or it may convince the client, gee, maybe I really should talk to another lawyer. it's not enough to leave it to some other lawyer the client might talk to say, these are the pros and cons of this. Again, in this case, mostly cons. The lawyer whose ethical responsibility is to get informed consent has to do that lifting.
So I understood, or if I understand, can you explain to the court, was there, in your expert opinion, was there a violation of Rule 1.7 in the promissory notes, all three of them?
Right. So as I mentioned earlier, if there's a material limitation on the representation imposed by conflicting interests, including the lawyer's own interests, then 1.7A comes into play. And here, with respect to these promissory notes, there was very much a personal interest on Mr. Coomer's part to, induce his client to sign these promissory notes.
And you found the disclosures that were contained in those documents insufficient to satisfy 1.7?
Correct. I for the same reason, the concept is the same. It's informed consent. Again, it's because it's a fiduciary relationship. It's the lawyer's obligation to make sure that the client understands all the drawbacks of this transaction. And that's the case if it's informed consent to waive a 1.7A conflict, or if it's informed consent to waive a 1.8A conflict. It still has to be informed consent, and the client is entitled to that information.
Does intent play any role in whether there's a violation of these rules? Here, Judge Coomer says he was doing this as a favor. At least one of the loans was a favor to the client. Hold some money for him for some period of time. Does the intent matter, or the relationship between?
Yeah, of course, I don't know anything about what people's intents were here. I haven't examined that aspect of it. It seems to me that the whole process of waiving informed consent here mitigates against there being kind of an intent defense, if you will, that this is something the client wanted. That's fine. Maybe the client did want that. If the client still wanted it after the informed consent discussion, then fine. But without that, the client wanting it and the lawyer purportedly wanting to serve what the client was hoping to get is you don't get to that question yet without the informed consent discussion.
May I ask a question? Informed consent, you have highlighted approximately 4 items that you felt were very significant in the promissory note.
Mhm.
The mechanism of disclosing those to the lender in this case, the lender.
The borrower,
No,
or
the lender.
the lender, I'm sorry. Yes, you were right.
Okay.
Yes.
The method that must be done, can it be done orally? Does it have to be in writing? What is the method of delivering to the lawyer's client? These are significant issues in the
Yeah.
promissory.
So this is a great question, because I don't think the rules talk about informed consent, and it needs to be informed consent confirmed in writing. The question is, must the whole panoply of information that the client's entitled to receive be provided in writing, and then get the client's consent signing off on that? Or is it sufficient for a writing to say, as we have discussed, the pros and cons and what have you, then the client hereby consents? The rules on their face are not especially clear. Prudent practice, especially in a circumstance where it's not a conflict of someone else's interest coming into play, but the lawyer's own interest. Prudent practice would be to make sure the client knows crystal clearly what the pros and cons of it are, and have it in writing, so that if there ever is a dispute, the lawyer has that to say, look here, this is what I told the client.
Thank you.
What, if any, impact does the client's age or other potential vulnerability have on that kind of informed consent discussion you were just having?
Yeah, well, I think age, I would hope that people in their 70s would be considered pretty sharp, have a lot of personal interest in that point, but you know, not everybody is the same, right? In fact, you don't even have to be in your 70s for there to be concerns about sophistication and ability to you know, to process information, important information. And the burden is on the lawyer to calibrate the discussion with the client so that the client, the real client, not some hypothetical client, that the real client absolutely understands what the client needs to know to give informed consent. And so vulnerability, age, medical conditions, all of those could come into play in making the informed consent process, you know, less challenging or more challenging.
And informed consent, as I understood your testimony, relates to the material aspects of the loan or the business engagement. Tell me again, what is waivable about the fair and reasonableness of the terms?
They're not waivable. A lawyer cannot go to the client and give me your informed consent to abuse your trust in me as a lawyer. That is not waivable.
Thank you. All right, I want to direct your attention, Mr. Lundberg, to Rule 1.8C. We all see it there on the screen, so you don't need to read it. Can you let me know if Rule 1.8C related to a lawyer drafting an instrument for which he or she might have a personal interest? Is that something that came into play when you were evaluating the evidence in the case?
Yes, particularly with reference to the last wills and testaments.
Okay, well, let's talk about those then.
Okay.
All right, Exhibit 147, that's there in front of you. Before I start that, you told me that the 2017 will was not one that you had in front of you when you reached your initial opinions related to the civil litigation. Is that right?
That's correct.
All right. Have you since reviewed it?
I have. I'm not as familiar with it, but I have.
And none of your, or let me ask you, do you have any opinions on whether the 2017 will drafted by then attorney Coomer for Mr. Philhart, is that violative of any rules that we've been discussing?
Well, so that will poured the residue of the estate into a trust, and the trust was to take care of his girlfriend as long as she lived, and then to his legal heirs, I think, is what it would be, as if where his estate would go if he had no will. And so there was no interest in that will per se of Mr. Coomer. He was appointed the executor and the trustee. There's a little bit of controversy on whether that is in fact an interest that ought to trigger all of these rules. I'm not of the view that it is. It's a continuation of the lawyering that a lawyer does for a client, and I don't get. It doesn't bother me that a lawyer drafts a will where the lawyer is then the executor of the estate or the trustee in this case, or both.
All right. Well, let's move on then to Exhibit 147, and that's the May 2018 will.
Yes.
And there are some terms there in front of it that's pulled from pages 1 and 2, paragraph 3 of that document that you've got in front of you. What, if anything, about the information contained on this slide or Exhibit 147 as a whole? What, if anything, did you find to be, in your expert opinion, a violation of any of the rules we've been discussing?
Right. So this will provided that the first and foremost was to take care of Mr. Philhart's, I understood to be his, I'm using girlfriend. I don't know if that's the right term or whatever term we want to use, but Wynell Waycaster, someone he had a close relationship with. And then upon her death, the remaining principal of the trust was to go to 4 different entities, 3 charitable organizations, United Services Organizations, St. Jude's Children's Hospital, and Patriot Guard Riders, and to the trustee, Christian Coomer. What's interesting, and I'll say troubling about this, is that the shares of the residual trust were to be distributed among these 4 entities or people in such shares as determined by Mr. Coomer. So at the end of the day, when the trust was ready to be, the principal of the trust was ready to be dispersed, Mr. Coomer would have been in compliance with the terms of the trust by sending $1 each to the United Services Organization, St. Jude's Hospital, and the Patriot Guard Riders, and the balance to himself.
And is that a direct violation, in your opinion, of the 1.8C rule that we just looked at? About-
It is. It's a classic violation of 1.8C, drafting a will that gives an interest in the estate or the trust that the estate forms, a financial interest, is a classic example of 1.8C violations. And they've occurred frequently across the country. They've occurred in my own state. And they're, I'll just say, a no-brainer violation of 1.8C.
Is there any aspect of a waiver? Is it possible for a client to waive that rule 1.8C violation?
No. 1.8C, in the world, the people who live in the world of ethics are used to a lot of gradations of black and white and gray, but occasionally you have something that's clear. And 1.8C is one of those things. A lawyer shall not prepare an instrument. End of discussion. And so it's a flat out violation of 1.8C for the lawyer to draft that. The lawyer can refer the client to independent counsel, who, with the benefit of independent counsel, could create a will with similar provisions. But that's because the client would be independently advised by a lawyer who didn't have the stake in this that, in this case, Mr. Coomer had.
All right. And Exhibit 148, that is the September 19th, 2018 will. Did you find substantial similarities between those 2 successive wills?
Right, they were very similar. I think the biggest difference was that instead of Mr. Coomer serving as the executor and the trustee, in this case, Heidi Coomer, who I understood to be his wife, was designated to be the executor and the trustee, and it has the same 1.8C problems as the previous will.
All right, it's not that Judge Coomer's violation, or what in your opinion was the violation of the rule, was Judge Coomer serving as the executor and trustee. The 1.8C violation is Judge Coomer serving as the beneficiary in the will that he
Yes, that's exactly right.
Okay. All right, finally, did you review in some of those emails and perhaps some other exhibits, Mr. Lundberg, in the course of your involvement in the case, any communication between Mr. Philhart and Judge Coomer that impacted or potentially violated Rule 1.4 communication that we've got up there on the screen?
Well, beginning in, I guess it was 2019, there was a series of email correspondences back and forth between Mr. Philhart and I guess by then Judge Coomer. I may not have my timeline right. And essentially, he was saying, I want you to pay off these loans. And secondly, he said, I want you to give me my files from your representation of me, and also tell me what you did to justify the fees you were charging me. And so 1.4 in particular would have, I think, primarily entailed an obligation of the lawyer when keeping a substantial amount of money in fees to let the client, to communicate to the client, this is what I did to earn these fees. This is why you owe them to me. And this is the status of your account.
And in your review of the communication between Mr. Coomer and, or perhaps then Judge Coomer and Mr. Philhart, did you form an opinion about Judge Coomer's compliance rule 1.4?
Well, I think it took, I wasn't, when I did my affidavit, I wasn't even aware that there was a final invoice. There eventually was a final invoice that justified a very substantial dollar figure for fees.
Purported to.
I'm purported to.
I'm gonna object to that interjection. That's leading the witness and adding to his testimony.
We'll let the lawyers argue what the invoice showed and didn't show. So let's get to the next question.
And I have on the screen here, rule 1.16 this is a similar rule about communicating with and providing documents to a client or former client. What, if any, opinions do you have about rule 1.16 in the case?
Yeah, so rule 1.16 is actually a little bit different than 1.4. 1.4 is the rule that deals with a lawyer's communicative responsibilities to a client. 1.16 is a rule that deals with the lawyer's responsibilities around terminating representation at the time of terminating representation. And 1.16, it appears to be 1.16.4, but it's actually 1.16D is the proper reference. It indicates that the lawyer is to surrender papers and property to which the client is entitled. There is some, I'll say, division of opinion on exactly what the client is entitled to get from the lawyer. For example, a lawyer's, file notes to him or herself about this is what I'm thinking about this client or whatever. That purely internal work product, if you will. There's some dispute about whether the lawyer really has to turn that over to the client. But the end work product of the lawyer is something that ought to be turned over to the client, especially at a client's request.
And in your review of the facts of the case, did you come to a conclusion about whether that had been done in this case?
Well, I didn't see over the course of the email communications that I reviewed that Judge Coomer made those files available to Mr. Philhart.
And if, for the purpose of my question, assume for me that the communication as far as the final invoice and other surrender of documents contained in Mr. Philhart's file did not occur for over a year and until after the initiation of civil litigation. Assume for me those questions. Would that be a violation of the communication rules and rule 1.6D that we've been talking about?
Yeah, so 1.4A3 actually has the word promptly in it. That kind of delay would not, in my mind, be prompt. 1.16 does not have that word, but I think it's implicit in the rule that when a demand is made by a client, that there be conformity with that demand within a reasonable time. And I wouldn't consider a year to be a reasonable time.
You would or you would not?
Would not.
All right, and my final area for you here, Mr. Lundberg, is rule 8.4. You can all see it there and we can all read it. And I want to know if you formed any opinions in your review of the case materials about whether rule 8.4 had been violated by then Attorney Coomer.
Are you renewing your motion to eliminate?
Yes, Judge.
Okay, it's renewed.
Is it granted or denied?
Was that one where we deferred it until specific questions were asked, or was that one that had been ruled on? If it's been ruled on, it's not being unruled on now. I don't remember there were multiple.
My head is so far up campaign finance laws that I don't even know, but
See what
so
Mr. Kingman's notes say.
I renew it and I would request a ruling.
Okay, but
My-
I've got it in my magic binder. Hold on.
And if it's not ruled upon, I would like to voir dire this witness for a moment with respect to his basis.
Okay. So I believe it was your fifth motion in limine that challenged the admissibility of Mr. Lundberg's answers to questions about whether Judge then Attorney Coomer had engaged in conduct that involved dishonesty, fraud, deceit, or misrepresentation.
My notes, Your Honor, unless you got a conclusion. This is one where we were to make it clear and flag for you via the slide that this was the area we were getting into to give Mr. Lefkoe an opportunity to object.
Right, he's objecting now, so I'm going to let Mr. Lefkoe voir dire the witness, and then maybe that'll bring to a head your concern.
Sir, my name is Mark Lefkoe, by the way. I represent Judge Coomer. Have you reviewed any of the depositions in this case?
I have not.
Have you talked with Jim Philhart concerning his intent?
I have not.
Have you read any testimony of Mr. Philhart concerning his intent behind the transactions he entered into?
I have not.
Have you reviewed Judge Coomer's deposition?
I have not.
Have you reviewed Judge Coomer's testimony as to his intent behind entering into the transactions
I have not.
with Jim Philhart?
I'm sorry. I didn't mean to cut you off. I have not.
And is it your intent to present testimony here that Judge Coomer engaged in fraud on Jim Philhart?
Not specifically. My intent was to answer the question that I anticipated, whether there was a violation of 8.4C or A4, I guess it's in as it is in Georgia, that I believe there was a violation.
And so this
Fraud is only one prong of that.
Yes, sir. 8.4A4 discusses, number one, dishonesty, right?
Right.
And dishonesty is somebody saying something that's untrue to somebody else, right?
Yeah, dishonesty is not a defined term in Rule 1.0 of the Rules of Professional Conduct. So dishonesty and some of the other terminology in 8.4A4 needs to be considered in the context of the relationship between two people who stand in a fiduciary relationship.
And to help inform that opinion as to whether there's been dishonesty, it would be helpful, would you agree to review their testimony, both parties to the transaction?
More information is better. I am not here to, let me just say, I have not taken into account any of that testimony because I haven't been provided it.
Fraud, do you know what the elements of fraud are?
I do.
Okay, can you list them or do you want me to list them?
Fraud as used in the rules of professional conduct, or term of art, as opposed to the elements of a criminal offense. As far as the question's not clear,
Are any of the four terms in 8.4A4, dishonesty, fraud, deceit, or misrepresentation, defined in 1.0?
I don't believe any of them are.
Okay. So fraud.
Oh, no, I take that back. Fraud is actually,
I'm sorry, you don't, we're not, it's not a quiz.
Yeah.
You're not going to need to list the four elements of fraud. If you don't remember what 1.0 has in it, we can get it.
well, no, I'm thinking that 1.0, if the Georgia rules, which I'd be happy to consult, are like the Indiana rules, there is a definition of fraud or fraudulent, referring to fraud under external law, including with the intent to deceive. If that's roughly the definition, if Georgia has that. Am I right, Mr. Lefko?
I will read what's in rule 1.0. 1.05I. Let me make sure there's not a letter. Okay. E5. Hold on, let me find it.
How about tell us fraud? We know
No, it's
in 1.0.
I. I'm sorry. 1.0I. Fraud or fraudulent denotes conduct that is fraudulent under the substantive or procedural law of the applicable jurisdiction and has a purpose to deceive, not merely negligent misrepresentation or failure to apprise another of relevant information. Is that consistent with your understanding?
Well, there's also the concept of constructive fraud, and constructive fraud it comes into play when there's a special relationship where it's not merely concealing information, but failing to disclose information when there's a duty to disclose.
That's the part of failure to apprise another of relevant information, right?
Right.
That's constructive fraud, right? Yeah, the thing that I just read from. So let me read it again. 1.0I, fraud or fraudulent denotes conduct that is fraudulent under the substantive or procedural law of the applicable jurisdiction.
I'm going to pause you right there. That doesn't sound like Georgia. Why would Georgia say applicable jurisdiction?
Because
Georgia
it's
is Georgia.
because it's built on the model rules.
But why would they say that in the Georgia version?
Because-
Are you at the Georgia version or you at
Yeah,
the
that's the
model
Georgia
rules?
version. Yeah, it's because people didn't clean it up, I
That's
guess.
the
So fraud or fraudulent denotes conduct that is fraudulent under the substantive or procedural law of the applicable jurisdiction and has a purpose to deceive, not merely negligent misrepresentation or failure to apprise another of relevant information. And let me go back, Judge. I think also sometimes Georgia lawyers who are subject to discipline in this state may act in another state where fraud elements are different. So, but we're talking about an intrastate transaction in Georgia. You with me, sir?
Yes.
Okay, so what you were talking about, constructive fraud, is the failure to apprise another of relevant information, right?
Right.
Which is accepted from the definition, EXCEPT, accepted from the definition of fraud or fraudulent under Rule 1.0I, correct?
Yeah, it appeared, I was actually trying to look on my computer for the Georgia definition, and apparently I thought I was copying Article 1 and I didn't include the definition, so I don't have it to look at. Which is not the ABA definition nor the Indiana definition of fraud, but it's the Georgia definition, and we're in Georgia, so I will grant you that.
All right, so the only fraud you're aware of, you would say you're going to try to testify as to constructive fraud, right?
No, actually, I said I was going to testify that there's a violation of Rule 8.4A4, which has 4 prongs: dishonesty, fraud, deceit, or misrepresentation.
I'm just
You only have
focused-
to have one of the 4 elements present to be the violation.
So are you removing the word fraud from your opinion with respect to 8.4A4? Are you intending to give an opinion that there was fraud under Rule 8.4A4?
I'm intending to give an opinion that there is a violation of Rule 8.4A4.
Sir, can you answer my question? Are you intending to give an opinion under Rule 8.4A4 that there was fraud?
Not as defined in the Georgia Rules of
Yes,
Professional
sir.
Conduct.
Thank you. Deceit. Are you intending to give an opinion under Rule 8.4A4 that there was deceit in the transactions between Jim Philhart and Mr. Coomer, Judge Coomer?
Your Honor, I interject here? I mean, I think the question on the table is still whether Mr. Lumford is going to be able to give an opinion. And
He's
instead
about to
of
give it.
cross- I know, you just,
So-
well, I like to do it the way I want to do it.
You'll get to, and an objection of cumulative will be overruled.
Sir?
Um, I would say that I would be disinclined to say that the deceit element of 8.4A4 was met.
All right, I'm going to move on from that one. Are you intending to give testimony under Rule 8.4A4 that there was a misrepresentation by Judge Coomer to Mr. Philhart?
No, I'm not.
So I can move on from that. So let's go back to dishonesty. Are
Okay.
you intending to give an opinion that there was dishonesty between Mr. Coomer, at the time a lawyer, and Jim Philhart,
I
or
am.
Judge Coomer and Mr. Philhart?
I am.
And on what basis do you rest that opinion? What documents, what information?
Right. And so what I rest those documents on is what I believe to be the height and due. This was not an arm's length transaction. That there was an obligation on Mr. Coomer's part to be candid with Mr. Philhart in entering into these transactions, to be completely candid. And that when you have a fiduciary relationship where you are to subvert your own personal interests as a lawyer to the superior interests of the client, and you withhold information, I consider that dishonesty.
Right. I object to the tender of this witness as to Rule 8.4 A4. Certainly, it looks like he's just talking about the first prong. He's not identified any basis for a claim of dishonesty. While dishonesty is not defined in the rule, I think it has ordinary meaning and ordinary parlance, and that is somebody saying something that's untrue to somebody else. That he has not identified any instances or information he's reviewed, read, digested in any way, shape, or form suggesting there was dishonesty by Judge Coomer or Attorney Coomer to Mr. Philhart, towards Mr. Philhart. So I object to his being tendered to testify as an expert with respect to 8.4A4.
So you've already actually moved to have him tendered as an expert. You are now, as in you brought it up, to short circuit things. The questions were heading in that direction. And you, counsel for Judge Coomer, said, hey, I don't have any objection to Mr. Lundberg being declared for purposes of this hearing an expert in legal ethics and professional responsibility. You're stepping back from that, or are you, because that's what you just said.
That is, Your Honor, that is not stepping back from that. I'm objecting to him, the conclusion that he's presenting to this panel. Whether I object to his general qualifications as an expert in legal ethics is not the issue when I'm objecting to a specific conclusion that he's trying to make and give to this panel as an expert.
That's different. So you're objecting to him, his ability to offer the opinion, his synthesis of what he's read and heard, and you've helped through this voir dire to illustrate that maybe he hasn't seen and heard everything, but that wasn't the question posed to him. Based on what he's seen and heard or read, does he have an opinion about whether your client's interactions with Mr. Philhart vis-a-vis the wills, the loans, we'll find out what the documents are, did that constitute the violation of 8.4A4? And you don't want him, you object to his offering of that opinion. And we now know what it's going to be. It's going to be dishonesty was involved.
Putting an expert imprimatur on to an opinion or a claim of fraud is improper. That is our contention. We said it in our motion in limine. And this gentleman here, with all due respect to him, has not reviewed anything that is of relevance to that issue, which would be the statements of the parties, the depositions of the parties, just reading documents and saying dishonesty, I do not think is sufficient. And not a sufficient basis for an expert to give an opinion of that sort, even if it could ever be admissible or ever be accepted as an expert opinion.
Okay. I want to make sure I'm following because you may have woven two different things in here. You said fraud about 3 times in there and then dishonesty. Your motion was, original motion eliminated was about fraud. Right now, we're just focused on dishonesty. Is that correct?
That is true. And
Okay.
my apologies.
No, you don't have to apologize. I just want to make sure I'm following what you have to say. Ms. Cross, a response.
What Mr. Lefkoe has just done is identify the areas of, he would like to cross-examine the witness on. That the basis, the information that the witness used to form his expert opinion is not, in this case, given the information that Mr. Lundberg has already testified to that he reviewed, based on the information that he has reviewed, he has been able to come to an expert opinion and he's about to offer it. Mr. Lefkoe thinks that that is insufficient information, and that's something that he can talk to him about on cross-examination, but it's not a basis to exclude an expert witness, an expert, as everyone has agreed in this field, as Mr. Lundberg is. So that's not a basis to exclude the witness, whether it's his opinion or not, and Mr. Lefkoe is free to explore it, but this is admissible opinion testimony. We'd ask that the motion be denied.
Good. It's denied.
Sorry, I didn't hear that.
Denied.
Thank you, Judge. May we have a continuing objection to this line of questioning on that, or must I object?
You need not, you may, but you need not continue to object. Hopefully there won't be a whole lot of questions about it from the JQC side, but the director's side, but anything that pertains to this witness's opinion about any appearance of dishonesty in connection with the transactions between your client and Mr. Philhart are subject to that continuing objection and the motion eliminated you filed.
Thank you. And I, as I'm standing here, I noticed that my hands are on my hips. Did not mean any disrespect by that.
Okay. None taken.
Mr. Lundberg, knowing then that you have already previewed for us your opinion on Rule 8.4, is there anything that you would like to add for the panel about the basis for your opinion that Judge Coomer, then Attorney Coomer, acted in such a way in the documents you reviewed that his conduct is a violation of Rule 8.4?
Well, I'm not sure if my responses to the voir dire questions actually constituted testimony on the merits, so maybe I should just reiterate my thinking.
Please do.
I think that 8.4C is a rule, and the prong of the rule that I'm focusing on is
When you say C, is that the
I'm
Indiana
sorry,
version?
that's the Indiana version. It's 8.4A4. Apologize. The 8.4A4 has to be understood in the context of the special relationship between lawyers and clients. And it is a relationship that requires complete candor. And the suppression of the lawyer's personal interests in favor of the client's interests. It's certainly there with the last wills and testaments, but I think the promissory notes are of particular interest to me, that here, was a gentleman that was lending substantial amounts of his assets to this entity that had no known ability to repay the money. I have seen no evidence of adequate disclosures to Mr. Philhart that said to him, in effect, if CAC Holdings defaults on this loan, there's probably not a darn thing you can do to it if CAC Holdings itself does not have sufficient assets in the bank. And in the context of that special relationship between lawyers and clients, where the client's interests always have to be superior to the lawyers, I consider that to be withholding critical information that amounts to dishonesty.
Thank you, Mr. Lundberg. I have no further questions.
Lefkoe?
Judge, can we let the record reflect that it's 4:18 p.m.?
I overshot, sorry.
It's
It's
okay.
4:18 p.m.
Yeah. I apologize, but I've got to go to the restroom. Is it okay if we take a short restroom break?
We need to, because you're the one doing the questioning. So I'm going to stay right here. My colleagues may want to take a break, but we'll start up as soon as you, Mr. Lefkoe, get back.
Thank you.
And so everyone's where I'm going to speak to the witness on about the substance testing, but the logistics of the process.
Thank you. Yeah, I guess.
Looks like so far, it looks like.
Who was that?
Yeah. I mean, I need to be back. I need to be back in New York. At my desk in time to rush. I had to be here first thing. in the morning. Probably the morning. It is. It's my preference.
Like the JQC Coomer? Yeah, absolutely. I'll text Christian now.
You would prefer another state in beautiful Hilton?
Very, yeah. You actually, that's right. Come back one. No. Just how it will want. Sorry. Don't be gone long, Mr. Lundberg. Here comes Mr. Lefkoe. Bad timing.
Let's talk about exhibit numbers, guys.
Cross, can you, Mr. Lefkoe needs to give you his battery of exhibit numbers.
All right, ready?
I just leave my stuff
All
right
right. One has already been admitted. 2A has been admitted. 2B has been admitted. Exhibit 3. 6A, 6 has been admitted. 8 has been admitted.
Yeah.
Looks like a 10. Okay, so 10, 13, 22, 24, 25, 27, 29, 31, 34, 35, 37, 40, 41 through 48, 51, 52, 53 has been admitted, 55, 56 through 58 have been admitted, 59, 61, 62, 63, 66 and 67 have been admitted, 75, I believe,
75 I have admitted.
admitted, okay. 80 has, can you mark 75 as admitted?
I don't have any.
80 is the APS report. 84, I think that's been admitted. No, it hasn't. Okay. Okay, I'm gonna,
Okay.
guys, 84, 85 admitted, 86, 304, 306, 307, 308,
Yeah, yeah.
310 through 312, 316, 317. Let me know objections.
Yeah, we might have to take those one by one because I'm going to have relevancy objections to lots of those with this witness.
All right, Ms. Johnston, you ready? All right, we have our witness back. We have Mr. Lefkoe at, we're calling it a lectern. told we call it a lectern and not a podium. Mr. Lefkoe at the lectern. And it sounds like rather than a mass admission of exhibits, we may go bit by bit because of some concerns about relevance.
Judge, for scheduling purposes, Mr. Gammon is outside. I do not foresee, given the list of exhibits, that we will get to him. He's willing to hold tight, but I don't want to make him if we're tilting at windmills.
Quick discussion about timing. Mr. Gammon can go. Is now Mr. Lundberg able to be here tomorrow morning? I heard discussions about he's spending the night here, or I don't want Mr. Lefkoe to be operating under this pressure of, you know what, we got to go, you need to hurry up. That's not how he needs to proceed with this. That's not an open invitation. It takes 6 hours either, but there may be something between 20 minutes and 6 hours.
We're going to handle him staying overnight,
Meaning,
Mr. Lundberg, so he'll be back in the morning.
Well, it's a preference to finish tonight if at all possible.
Yes.
Mr. Lundberg's and maybe everybody else on this side.
understood. I don't know that that will happen. And so there is an availability to have Mr. Lundberg here in person first thing tomorrow to pick up where we left off. Fantastic. All right. Mr. Lefkoe.
Okay, let me get my water. All right. Mr. Lundberg, again, I'm Mark Lefkoe representing Judge Coomer. Have you ever testified in a Georgia ethics case?
In a judicial ethics case?
No, Georgia ethics case.
Oh, Georgia ethics case. Oh, no, I have not.
Now, are you familiar with, so you're familiar with Georgia Rule 1.8A, right?
Yes.
Talked about that, right?
Yes,
1.8C as well.
yes.
1.7, I think we need to talk about. So let's pull that up on the screen. That's the conflict general rule.
Mhm.
And what that rule pertains to is continuation of representation after identifying a conflict, right?
Well, that's part of it. You can't initiate a representation if there's a conflict too.
It reads, quote, "A lawyer shall not represent or continue to represent a client if there is a significant risk that the lawyer's own interests or the lawyer's duties to another client, a former client, or a third person will materially and adversely affect the representation of the client, except as permitted in B," end quote. Did I read that correctly?
You did.
And what matters did Christian Coomer continue to represent Mr. Philhart on after transactions that you contend were conflicted transactions?
Well, there was a course of dealing between Mr. Coomer and Mr. Philhart extending, I think, from 2015. There was an attorney-client contract dated sometime in 2015. And multiple matters, including the drafting of last wills and testaments in late 2017 and twice in 2018.
And in the drafting of wills and testaments, okay, last wills and testaments, those took place in May of 2018 and September of 2018, right?
Correct.
Rule 1.7, what was the attorney-client relationship between Mr. Philhart and Mr. Coomer at the time of execution of those wills? What matters were active that Mr. Coomer was representing Mr. Philhart on?
There may be some I don't know about. I know specifically that two of the matters that were under representation by Mr. Coomer of Mr. Philhart at the times of those two wills were, one, representing Mr. Philhart with respect to a last will and testament dated May 23, 2013. And then secondly, representation of Mr. Philhart with respect to a last will and testament dated September 19 of 2018.
Right. Was there representation after September of 2018?
The last documents that I saw were the series of documents that were tied up with the September 19, 2018 last will and testament.
1.8A and 1.8C, the maximum penalty for violation of those rules is what?
Um,
Do you know offhand?
um,
I can pull it up.
yeah, go ahead.
1.8A, 1.8C, the maximum penalty under the bar rules is public reprimand. Is that correct?
That's what that says.
Okay. Are you familiar with Georgia Bar Formal Advisory Opinion 91-1?
I am not.
So are you testifying with respect to any ethical violation concerning placing or Mr. Coomer being the executor on Mr. Philhart's wills?
No, I already indicated that I didn't have an opinion on that.
But you are giving opinions on 1.8A and 1.8C, right?
Right, 1.8A regarding the promissory notes and 1.8C regarding the last wills and testament.
Yes, sir. Both of those rules relate to then current clients, correct?
Right. Let me consult the rules specifically.
Got them up on your monitor.
They are, I have it here in front of me. A lawyer shall not enter into a business transaction with a client or with a client.
So let me give you a hypothetical here. And
Okay.
in certain circles, I've had a side gig doing music, and I got this sound guy that's at my music gigs, who's every once in a while says, "Hey, can you look at this contract I've got with so-and-so at another venue?" Now, is he my client? Is he my friend? Is he my sound man? Do the rules specify?
So you're a lawyer
Yes, sir.
and you moonlight as a musician
Yes, sir.
and your sound guy, knowing you're a lawyer, says, "Hey, look, tell me what these documents mean. Give me some help understanding these documents." Is that what your hypothetical is?
Yeah, help me revise my document for his contract with another venue.
Well, normally the law would look to the reasonable expectations of the person claiming to be the client.
So do the bar rules say, here's when the attorney-client relationship starts and here's where it ends?
No, the bar rules don't specifically say when it begins and ends. There is plenty of law surrounding that question, but the bar rules themselves don't talk about that.
The bar rules do talk about clients on Rule 1.8. And then there's another rule, 1.9, for conflicts of interest for former clients. Do you see
That's
that?
correct, the substantial relationship test.
And,
Yes.
and what's notable is 1.8 dealing with then current clients talks about fairness of business transactions, right?
Yes,
1.9 dealing with former clients says nothing about that, right?
1.9 does not have a counterpoint to 1.8.
Right. So if I've got a former client who I represented him in his 30B6 deposition, but he becomes my Facebook friend and we go fishing together, he's a former client, right?
Well, sure, there's a time when attorney-client relationships come to an end and the person becomes a former client. That's why we have 1.9.
And there's not just, there's a time. Sometimes when that time is a blurred line, right? When somebody's no longer your client and when they're more of a former client than a client. Is that right?
Yeah, I mean, I would say it's one or the other, but when you mark that instant in time, could be up to interpretation.
Yes, sir. All right. what defines what you do about people's violation of bar rules. Are you familiar with the ABA standards for imposing lawyer sanctions?
I am.
Or would you deem yourself an expert on those standards?
I've used them many times. I don't know if I would consider myself an expert, but I've relied on them frequently in lawyer discipline cases, both on the prosecution side and on the defense side.
The ABA standards for imposing lawyer discipline talk about a theoretical framework of factors to consider. Is that right?
It does.
Is this a specific exhibit that we're looking at? I
It's-
understand it's also public record, but.
It's not. I can make it one if Your Honor cares for it to be
It's up
one.
you how you want the record to be structured.
I have no preference, just,
Then let's keep going.
all right. The theoretical framework deals with a number of factors when you look at alleged violations of bar rules, right?
Just to be clear, the standards on lawyer sanctions are what you do after there's a violation. They don't go to the question of a violation. They go to the question of what the sanction should be growing from a violation.
Some of the factors to consider, and I want to go over these because a lot of the minutia of what we're going to talk about in your testimony pertains to these specific standards for imposing lawyer sanctions, okay?
I'm going to object, Your Honor, to the relevance of lawyer sanctions. I think anything in the sphere of is something, particular conduct, a violation of the rule, or is it not, is within the witness's expertise and purview. Anything beyond that is beyond the scope of the direct and outside the witness's expertise, and I don't think particularly relevant.
Let's focus on relevance. I think in terms of scope of testimony, you probably got a good witness to ask these questions, but the panel's role is to recommend a sanction that doesn't include any penalty from the state bar. If the panel finds that there was a violation of one or more provisions of the Code of Judicial Conduct, we recommend a sanction to the Supreme Court, which has the final decision-making authority. Where are we going with this that helps inform our decision of was there a violation? Not what should the penalty be? You could argue that later if you are admitting to a violation, but I'm not following the relevance of this.
These specific standards have been considered by a number of courts in imposing discipline in the judicial arena. He says he knows them. I'm not going to go on a long tangent about this, but I think it helps frame the facts that we're looking at in context. And there are about, like 4 or 5 different areas that this gentleman has delved into about what he says Judge Coomer did. They've been narrowed now under 8.4A4, it sounds like, to 1 out of 4. But those things and these factors under the standards for imposing attorney discipline are relevant. I just want to ask to point out to frame our discussion of what it is that he says was done here.
So we've seen the factors. If you think they're germane to any work we need to do, should we find that there's a violation in terms of crafting a recommended sanction to the Supreme Court, I'm happy to hear about it then. But for purposes of this witness testimony, I don't think it's relevant to go any deeper than we've now seen what those 4 factors are.
Yes, sir. Sir, do you have any opinions with respect to Judge Coomer's mental state?
I do not.
Do you have any opinions as to his actions being having any aggravating or mitigating circumstances?
I don't have any specific information about aggravating or mitigating circumstances other than there is an aggravating circumstance. I think I'm recalling correctly. If the client is vulnerable, which may have some bearing.
Sir, is it your and again, you've not reviewed Mr. Philhart's testimony as to what his mental state was, right?
Not.
Get that off the screen. Do you understand whether all payments to Mr. Philhart due under the notes that were executed were made on time or not?
I don't have a specific understanding one way or the other.
Do you know if Mr. Philhart was made whole?
You used the word no. And I think my answer to that is I don't know. I think he was.
Do you know if Mr. Coomer, Judge Coomer, has any bar disciplinary prior history?
I do not.
Do you know of what the evidence may have shown or is as to Mr. Coomer's character or reputation?
I do not know.
All right, now let's talk about your background. And you gave us a 32-page CV. Are you aware of that?
Well, I provided it, so yes.
Okay. Are there any entries in that 32-page CV that relate to expertise on reasonableness of loan terms or commercial reasonableness of transactions?
I'm not sure.
Are you an expert in non-commercial personal unsecured loan terms?
Oh, no, I would not hold myself out to be an expert in that.
Your practice focuses on representing lawyers in bar matters, right?
That's one of the areas, yes.
And have you ever represented a lawyer in a Georgia bar matter?
I have not.
And are you an estate planning lawyer?
I am not.
All right. I want to talk about your retention in the case of Mr. Philhart versus Christian Coomer. Okay.
Okay, sure.
And you were retained by whom?
I was retained by Attorney Wright Gammon.
Had you ever met Mr. Gammon before?
I met Mr. Gammon approximately 3 hours ago for the first time.
Had you ever interacted
Well,
with?
if you mean face to face,
Yeah. Have you ever interacted with Mr. Gammon before?
I have.
Before you were retained for the Philhart case?
I had not.
You had not. And how did he retain you?
A professional acquaintance, I'll say, who is a Georgia lawyer, recommended that he contact me.
Did he say who that was?
He did.
Who?
Lester White.
Lester Tate?
Tate, I'm sorry.
That he
That
would
would show you how close a friends we were, but yes, Lester Tate, I'm sorry.
At this time, I would tender Exhibit 312, the retention email to Mr. Lundberg.
Any objection to 312?
No objection.
Admitted?
May I publish it?
You may. Generally, if it's admitted, feel free to publish. The other side ought to object if they don't think it should be published.
Yes, sir. I know this is an odd proceeding, but looks like you were retained on March, or there was an email from Connie Lane, who's the assistant for Mr. Gammon, to you dated March 3rd, 2020. Do you see that?
Yes,
And he attached 8 files. Do you see that?
yes,
And I asked you to bring whatever Mr. Gammon gave to you here today, right? Did you
Right.
bring it?
yes, I gave it to Ms. Cross.
I did not get it. Right. Well, she's trying to get that to me. Let's look at the email. Mr. Gammon informed you that he sent you a copy of a will, a promissory note, a trust, a loan document from September 2018, a will from September 2018. Looks like he gave you a general power of attorney from September 2018, an advance directive from September 2018 and emails between who? Mr. Philhart and Mr. Coomer, is that right?
Yes, yes.
Did he give you a timeline?
A what?
A timeline?
No.
So let's look at what Mr. Gammon told you with respect to, do that. With respect to your retention in the case of Philhart versus Mr. Coomer. Mr. Gammon told you, quote, "I think it is reasonable to conclude that Coomer violated Georgia Rules of Professional Conduct 1.8 on prohibited transactions." End quote. Did I read that correctly?
Yes,
And he informed you that he believed that the loans were not fair and reasonable to the client, right?
I didn't say that. He said that he believed they violated Georgia Rule 1.8.
1.81, but he meant 1.8A, right?
Oh, I'm sorry. You were, I was focusing on the part you quoted. You were on the next paragraph.
Right.
I'm guessing because of his quotation of fair and reasonable that 1.81 meant 1.8A.
Yes, sir. He also quoted or cited Rule 1.7, right?
He did?
Rule 1.5, right?
Correct.
And now you're not saying anything about Rule 1.5, or are you?
I didn't state an opinion on 1.5.
Okay, so you don't have any opinions on the reasonableness of the fees charged by Christian Coomer to Mr. Philhart, is that right?
I didn't. I have a very narrow opinion on 1.5. But I have not studied the Georgia situation relative to 1.5 on this particular point. But the $20,000 retainer he charged Mr. Philhart was non-refundable. So if the next day Mr. Philhart had fired him, he would have been out $20,000. In Indiana, that would be a violation of 1.5.
What would be a violation of Rule 1.5?
Non-refundable retainer.
All right. Do you have any opinion as to whether that's a violation of 1.5 in Georgia?
I don't.
Okay, Rule 8, do you see the paragraph starting with "it is clear"? See where it says, quote, "It is clear that he violated Rule 8.4 by violating the Georgia Rules of Professional Conduct and by engaging in professional conduct involving dishonesty, fraud, deceit, or misrepresentation," end quote. Did I read that correctly?
You did.
And that's what Mr. Gammon told you before you executed any affidavits in your case of Mr. Philhart against Mr. Coomer, right?
That is what he said, yes.
And then Mr. Gammon indicated to you that, quote, "Finally, I will forward you a first draft of an affidavit after lunch," end
Yes.
quote. Did I read that correctly?
You did.
Did he draft your affidavit for you?
Did he draft my affidavit?
Yes, sir.
He sent me a draft of an affidavit. That's not the affidavit that that's not my affidavit. I don't know what to say. My affidavit's my affidavit. It's substantially different than Mr. Gammon's draft of an affidavit.
You bring that draft per my request here
The
today.
draft is here in the courtroom. It's, leave it to counsel to,
Your Honor, we might have a motion to bring with that. Mr. Lefkoe declined to depose the witness during the discovery period, did however send a subpoena for these documents that cover much of the same area to Mr. Gammon. The court heard that objection at the time to attorney-client privilege. The subpoena to Mr. Lumberg here, it covers much that same ground. So insofar as there are documents that Mr. Lumberg brought that he had in his file that he reviewed, we have no objection and are happy to turn those over. Insofar as there is draft correspondence and other correspondence between the witness and Mr. Gammon, I believe there is an attorney-client privilege. I think it's subject to the prior ruling of the court. And so insofar as the subpoena calls for that, we object.
Why don't we do this? When we break for today, if you could give Mr. Lefkoe, the way I get it, all the attachments, the PDFs attached to this are things actually Mr. Lefkoe already has, I suspect, but he needs
Multiple
to.
copies.
Okay, but he needs to confirm, and that's fair. If you could get him those. And then if there are things that you think Mr. Lundberg has produced pursuant to a subpoena from Judge Coomer's team that ought not to be provided. If you could get that to the panel, we can look at that and decide what, if anything, from that universe ought to go. Discussion before anything is handed over.
Oh, I'm sorry, I'm kind of left in space on that one.
So no space, you're getting all the PDFs that were attached to the email, and that's where we'll start. So you'll be able to review those. I think you'll find that they're the attachments that were described here, but you'll find whatever you find. And then Ms. Cross has said there were some other items that Mr. Lundberg brought pursuant to your subpoena that may not be disclosable. But that's not Ms. Cross's call to make, it's our call to make. So we need to see what those documents are. Just because you ask for them doesn't mean you get them. You know that.
May I respond to her contentions as to why we don't get them? First off, we sent a subpoena to Wright Gammon for his entire file, and that was ruled upon, and we take exception to that ruling with all respect. Because Mr. Philhart was copied on that subpoena to Mr. Gammon. Mr. Gammon received that subpoena. No objection was lodged.
Work through that. Let's
Yes.
not re-till that ground. Tell me about, you were going to say something about these other documents that I don't know what they are, but we're just going to handle them cautiously. Not saying you don't get them. We're going to handle them cautiously.
It's covered by the subpoena. There's no attorney-client privilege. It's not a communication between attorney and client when you send a draft affidavit to an expert. This is not federal court where draft affidavits are not discoverable. They are discoverable. That rule has not been adopted in Georgia state courts. So I would ask that I be produced all drafts of the affidavit before he executed his final affidavit.
Okay. Ms. Cross, anything you want to say in response to that? I don't know that it's just a draft affidavit. Your description made it sound like maybe Mr. Lundberg had given you more than just a first draft of an affidavit that Mr. Gammon sent him.
I will put the item that I was referring to in a special pile, so everyone can pay particular attention to that. And insofar as I may have referenced attorney-client, what of course I was referring to insofar as the civil attorney, Mr. Gammon, contacted and was dealing with his expert witness as attorney work product, that is not been waived to my knowledge in these proceedings.
Okay. We'll work through whatever that exhibit, whatever that document is. I know you can press on with other areas. Right?
Yes, sir. Did Mr. Gammon inform you that Mr. Philhart had informed him that Chris Coomer did nothing wrong and he was just angry about his taxes?
Say that again.
Did Wright Gammon inform you that Mr. Philhart had told him that Chris Coomer did nothing wrong to him and he was just angry that he had incurred a tax bill on sale of some stocks?
I don't believe he did. One of the emails made reference to him being unhappy about the tax ramifications.
One of the emails made reference to the tax issue.
Yeah, I think so.
Did Mr. Gammon tell you that Mr. Philhart had told him that Chris Coomer made no misrepresentations preceding entry into the March 2018 loan, the September 2018 loan, the trust documents, or the wills?
Your Honor, insofar as the reference testimony occurred in the last, let's say, 2 months, the depositions in this proceeding, I think it's certainly fair to ask, and the witness has already testified, he didn't review any deposition testimony. So we can accept that as fact. I understand that to be true. So the answer to all these questions is going to be no. So I'm wondering what the relevance of the questions are.
Okay.
I object to that, telling the witness that the answer is no. I'm asking what Mr. Gammon told him, and if Mr. Gammon told him these things before he executed his affidavit.
Right.
And my objection is that the testimony that's being referenced did not occur at the time that Mr. Gammon and Mr. Lundberg were talking about his expert affidavit. That was 2 years ago. The testimony Mr. Lefkoe is referencing is very, very recent.
Well, but could be, but the question, as I understand it, I assume Mr. Lefkoe has a good faith basis to suggest this, that he can point us somewhere where He's got evidence that Mr. Philhart back in 2020, whenever this relationship, March of 2020, before March of 2020, Mr. Philhart had said to Mr. Gammon, you know what? This is just about the taxes. Mr. Coomer was on the up and up with these loans and with these wills. He made no, I don't know that he would use the word misrepresentation, but that's what you're saying. So if you have a good faith basis to suggest that that exchange between Philhart and Gammon occurred, then you should keep asking, because that is something Mr. Gammon could have relayed to Mr. Lundberg.
May I
Thank you.
approach the panel, Judge? Sometime before, to assess whether I have a good faith basis, I prepared excerpts, things that I was intending to show in this hearing, which I understand Your Honor's ruling, that I was not to show those during their case. I understood from prior hearings that we would be allowed to show portions of the deposition of Mr. Philhart. I guess that would be in our case. And his availability
Or
was,
to Mr. Philhart.
or to Mr. Philhart, right? Perhaps to somebody who had been there at that deposition, I guess. And so there will be a number of things that I asked like this. So I just would hand the panel these excerpts so you can assess whether I have a good faith basis for that.
Well, I think what you're getting at is that Mr. Philhart, you say in his deposition said, oh, I told Wright Gammon before Mr. Lundberg was in the mix that Christian Coomer didn't do X, Y, and Z. And that is what Mr. Philhart recently said he told Mr. Gammon.
In volume 2 of his deposition, page 89, beginning at 89, line 12, Mr. Philhart did in fact say that he had told Mr. Gammon Chris Coomer did nothing wrong, and he was just angry because he had incurred a tax bill.
Okay. Anything about misrepresentation, or just did nothing wrong?
That would be lesser included, I would assume. I would
That's
think
not
a
what you asked.
misrepresentation is something wrong.
But you had asked the question, did Mr. Gammon tell you that Mr. Philhart said that Christian Coomer had made no misrepresentations to him? Is that in Mr. Philhart's deposition, that I told Wright Gammon that Christian Coomer made no misrepresentations to him?
He did not say those specific words, but he did testify at volume 1, starting at 16, page 16, line 1, and volume 2, 41, line 25, that no misrepresentations had been made to him concerning the loans. And the same thing with
And that he
respect.
told Wright Gammon that?
No,
Okay, so stick with what he said. If you're sticking with what he said, they're fair questions. Don't kludge together two different strips of testimony and say that's what he told Wright Gammon.
I wasn't suggesting he had necessarily told Wright Gammon, but certainly whether he told Wright Gammon that or not, if Mr. Gammon had told him these things, which I know to be true from Mr. Philhart's deposition, that might affect his opinions in this case.
Fair enough, but that's not what you asked. You asked, did Mr. Gammon tell you that Mr. Philhart told Mr. Gammon that Christian Coomer made no misrepresentation?
Right.
That's not what you just read from the deposition. You pulled one strand and tied it to what he told Wright Gammon.
I don't know what he told him though. And so if he did tell him that, I have a good faith basis for asking it because I know he said it in his deposition. Whether he told him that or not, and I know that he told him that or not, is irrelevant because I don't know what he's told him. I don't know what happened before I got here.
Judge, may I have 30 seconds here?
So I think we've got this under control. I think Mr. Lefkow made the point, and I'm going to let him ask the question.
Okay.
Right. Did Mr. Gammon inform you that Mr. Philhart had a history of designating his friends to be beneficiaries for convenience?
So I don't want to step on other people's privileges that aren't my own. So I'm going to be hesitant here to let other people do the heavy lifting on privilege questions, but you're asking me to disclose a lawyer's statements about what a client said to him or not, which may have implications for attorney-client privilege. It may have implications for attorney work product. I'm not
Comfortable asking it because of that. You should say that, and Mr. Gammon will be testifying, and then he'll be in an even better position to invoke or not invoke.
The best answer I can give to your question is my telephone call with Mr. Gammon was Is it 2 years ago? 2+ years ago, 2.5 years ago. I don't remember.
Do you recall whether Mr. Gammon told you that Mr. Philhart had designated Christian Coomer as a beneficiary for convenience to carry out his wishes that he expressed in handwritten lists before you executed your affidavit?
I don't recall.
Do you know whether the loan payments were in default on the loans taken by CAC Holdings from Mr. Philhart? Ever?
I don't know that.
Do you know, were you told before you executed your affidavit what personal reasons Mr. Philhart might have for taking out a loan with a 30-year term?
I don't recall.
Did Mr. Gammon inform you that Mr. Philhart lived frugally?
I just, the last part of your sentence clipped off.
Frugally.
Told Mr. Say, you just have
I'll
to say
say it
that
again.
again.
Did Mr. Gammon inform you that Mr. Philhart lived his life frugally?
Oh, I don't recall.
Did Mr. Gammon inform you whether Mr. Philhart needed the money that he loaned to CAC Holdings?
And I'm going to make an objection. Any communication from Mr. Gammon to this witness in anticipation of the preparation of the affidavit, I think is properly covered by attorney work product. There hasn't been an explanation as to why that privilege has been waived. And I think the questions, insofar as they're going in that direction, I object.
Can I address it?
Yes.
He's
turn to you.
yeah. He's testifying that there was dishonesty here, and they're buckling up and asserting a privilege on the facts which would lead him to conclude or not conclude there was dishonesty. And he's testifying that the loans were unfair, and then buckling up and saying it's a privilege. I don't have to tell you what this man's reasons might have been for doing a loan of this sort. And so these are inconsistent things. And then I would move for him to be excluded if he's not going to tell me the bases upon which he is establishing these opinions.
Why don't you ask that
Then,
question?
thank
Ask
you.
that question
I have no
instead
objection.
of probing into areas that I do find are protected by work product. There may be other witnesses who could waive it. It's not this witness to waive that, as he has flagged for you already. But you've got a great question. Ask it.
I think I
Don't
have a
triangulate.
better way to ask it.
Okay.
Okay. Were you aware before you executed your affidavit that Mr. Philhart lived frugally, didn't need much money for expenses, and wanted to have a little bit of money coming in every month and saving for a bigger pot after he died? Did you know that Mr. Philhart had those wishes before he executed the loan documents with CAC Holdings?
Don't answer quite yet. Yes.
Wanting to afford everyone the benefit of asking questions in good faith, I don't think that's a fair characterization of the record or the testimony in the case. Asking the witness what he knew about, or assume for the purpose of my question, would that change your opinion? I think those are fair questions. I don't think that's a fair characterization of the question if it's posed in the way, were you aware, as opposed to assume for the purpose of my question.
May I establish my good faith basis for asking this question then in response to her objection?
I think it was fine at the end. You embellished a little bit from, I think, what we've heard, but I think the gist of it, it was a repackaging of questions that were getting you into work product. Why don't you try again as best you can recall how you asked it, and I'll let the witness answer.
Were you aware that Mr. Philhart didn't need the money he loaned at all and just took money that Chris Coomer, that CAC Holdings borrowed and paid each month, and he didn't have to draw any out for his living expenses, which were very little, and then if he had any left, he would just bank it? Before you executed your affidavit, were you aware of that?
So what I knew before I executed the affidavit was what appears in the 8 attachments to Miss Lane's email of 3/3/2020 at 1:42 PM. And what Wright Gammon told me. So again, I want a clear ruling that I can talk about what Wright Gammon told me, or I can't. That's not my call.
Don't talk about what Wright Gammon told you.
Was what Wright Gammon told you, regardless of what it was, part of the bases for your opinions that you gave in that case?
No,
It was just the documents.
yes.
What document do you?
Let me make an exception for that. There may not have been a document that gave Mr. Philhart's age.
Can you point me to a document in the record where Christian Coomer told Mr. Philhart something that was untrue?
Yeah, well, we've been through that. We were actually not doing untrue. We were talking about dishonesty.
Right.
And what I talked about in response to that in that colloquy is that I thought that the enhanced duty of candor that lawyers have to clients, I didn't see anything in the documents that I reviewed that met that enhanced duty of candor, particularly with reference to the promissory notes, to make sure that Mr. Philhart knew how few rights he had to recover that money if things went bad.
Did you understand one way or another whether at the time you executed your affidavit and a lawsuit was filed against Christian Coomer by Jim Philhart, whether Jim Philhart was suffering from diminished capacity?
Other than what Mr. Gammon told you.
I don't think, is your ruling that anything Mr. Gammon told him is privileged? I thought that just covered where Mr. Gammon's expressing communications or relaying to him communications between attorney and client.
So you retain an expert, you represent someone, you retain an expert to assist in your representation of your client. How are your communications with that expert to help that expert do her job on behalf of your client, not part of the work product that you are generating for your client?
This is McKinnon versus Smock. And what McKinnon versus Smock says is that when I'm telling him my opinions of things, that is protected work product. When I'm relaying to him facts, I don't think that's protected work product. That is, it goes to the basis of his opinion. And I don't think McKinnon versus Smock protects that.
Ms. Cross, anything about opinion versus facts?
I was actually thinking of Newman versus State, and that when an expert is retained by an attorney in preparation for litigation and an assistance for pursuing litigation, discussing strategy, things like that, that's generally protected by attorney work product. There's an umbrella there. In this case, the expert was disclosed and there was an affidavit, and I think that's certainly fair game, and that's why we haven't objected to any of that. Any of the information that the witness had when he developed his opinions in the case, that he used to develop his opinions in the case and were expressed, I think is fair, and we don't, that's not what I'm objecting to.
Okay. Then I think you are more aligned. So if you're limiting your questions to facts, not opinions, that Mr. Gammon, like age, let's just take the age example. It's not in the documents. It may well be that there was an exchange between Mr. Lundberg and Mr. Gammon. How old is your client? He's X. I don't think that's work product. I agree with you. McKinnon versus Smock.
Or an assessment of whether a client has diminished capacity. That's
Well,
not a statement by a client.
Sounds like an opinion.
I'm asking him whether he has an opinion with respect to whether or is informed by anyone at the time he executed his affidavit, at the time the lawsuit was filed against Christian Coomer, whether Mr. Philhart was suffering from diminished capacity.
Okay. Meaning, did Mr. Gammon have the opinion that that was the situation?
Whether he was informed from any source whatsoever.
Other than Mr. Gammon's opinion?
We can exclude Mr. Gammon's opinion as to whether he had diminished capacity.
There's
I
your
have
question.
no objection.
Were you informed, other than Mr. Gammon's opinion, as to whether Jim Philhart had diminished capacity at the time the lawsuit was filed against Christian Coomer in March of 2020 by James Philhart?
The only references to potential diminished capacity were those contained in Mr. Coomer's emails to Mr. Philhart, suggesting to Mr. Philhart that he had some mental incapacities. Other than that, I don't recall anything other than that.
Is it your opinion? Do you have any opinions with respect to Rule 1.14, which pertains to dealing with clients that have diminished capacity?
1.14?
Yes, sir.
I alluded to 1.14 in my affidavit. And I did not make an independent assessment of Mr. Philhart's mental capacity. I took, if you will, at face value that Mr. Coomer himself had reservations about Mr. Philhart's capacity.
That's not what you said in your affidavit. I'm asking you what you're saying here. Are you contending that there was any violation of Rule 1.14 by Christian Coomer? If you are, then I have to explore it. If you're not, then we can move on.
No, I'm not saying that here today. I didn't say it on direct, and I'm not saying it on cross.
Did you ever read any of the news clippings in this case where this notion of Jim Philhart having diminished capacity was floated in the press?
No.
Is it permissible under Rule 1.14 to enter into a contingency fee agreement with a client who has diminished capacity, or whom you reasonably believe have had diminished capacity?
Is that a hypothetical? I didn't think contingency fee agreements were a part of this.
Neither. What's the relevance of that?
Well, the fact is, if there was an allegation made against Chris Coomer, and that was one of the big sellers in the press, that he took advantage of a
How about
client.
the allegations here? I'm not aware of there being any contingency fee agreement. We're not up against the media here.
No, the point is, and your point is well taken, but as of 2020, Mr. Philhart is executing a contingency fee agreement with Wright Gammon for this very lawsuit that he's brought on to handle and to be an expert on. And nobody in the world would ever enter into a fee agreement with somebody who thought had diminished capacity. Yet the allegation is made in that lawsuit that he had diminished capacity when dealing with Christian Coomer. And this gentleman's affidavit says the same stuff, where he's accusing Chris Coomer of engaging with a client who supposedly was reasonably suspected or was suspected of having diminished capacity.
Okay, I understand now why you're exploring this. Ms. Cross, anything?
I think the witness has already testified that where the information that the source of any information he had, he's already identified as an email from Mr. Coomer at that time. He doesn't have opinions about Rule 1.14 and is not expressing them today, nor had he in the past. So I don't see the relevance of this line of questioning with this witness. He just doesn't have a basis to opine.
He gave testimony that this was a vulnerable client.
Vulnerable is not the same as diminished mental capacity. I think he can speak for himself as to why he said vulnerable. You can ask him that.
Do you believe Christian Coomer needed to treat Jim Philhart as a client with diminished capacity under Rule 1.14 when he dealt with him? Or do you have any opinion on that?
Because Mr. Coomer himself expressed concerns about Mr. Philhart's mental capacity, I think that Mr. Coomer should have dealt with Mr. Philhart consistent with the guidance given by Rule 1.14.
So now I have to go into Rule 1.14.
All right.
Were you asking about 1.14?
We are going to break for the day. You can come back in the morning and ask about Rule 1.14. Ms. Cross, I noticed you gave Mr. Lefko stack of documents. Would those be the 8, I think it was 8 attachments to the email that Ms. Lane sent to Mr. Lundberg?
That is correct, Your Honor.
Okay. How many other documents are we dealing with that Mr. Lundberg brought here that you want the panel to review?
Those in my hand. This stack is related to the draft affidavits and the correspondence related to, so I've got that. The other is the witness's own notes based on conversations with Mr. Gammon, so I have that in a separate file.
Okay, the witnesses meaning Mr. Lundberg's notes.
That's correct.
Okay, great. And in terms of tomorrow, you've got, what did we hear from Mr. Philhart?
He's good to go.
Okay,
And Jet, on that, from a scheduling matter, I know Mr. Lundberg has to be back at his desk at like 2:30 tomorrow. So I think in the morning, we have about an hour window for Mr. Lundberg, just whatever it is. And if we have to get him out of here, then I guess we may have to Zoom the rest of it, but we've made accommodations to make sure we get him out of here in time to be back at his desk by 2:30.
Okay.
With given the way this is going and with a couple of other witnesses, it may be that we don't even get to Mr. Philhart until Friday morning. My thought is we can fill up the rest of the day tomorrow with other witnesses. And if we need to call Mr. Philhart first thing Friday, so he doesn't come up and sit all day. And I don't think that would be good for anybody.
okay.
But we'll know better, I think, tomorrow afternoon. And we're going to discuss it.
Is Mr. Philhart the next witness after Mr. Lundberg?
No,
You want to put a bunch of witnesses on before Mr. Philhart?
we do.
Okay. Well, that,
So the plan would be to have Mr. Philhart be first Friday morning.
Yes.
Okay.
may I inquire as to this witness regarding his schedule, or may the panel inquire why he's limited to an hour tomorrow, except for that they want him to be limited to an hour?
Go ahead and ask him.
Why is it you have to be back at your desk at 2:30, sir?
I have a call on a telephonic meeting, if you will. People don't meet in person anymore, with a client about a time-sensitive matter.
I mean, telephones exist here in Georgia. Can you
Yeah,
not do that phone conference here in
they-
Georgia? Yes, ma'am.
Yeah, so I'll have you stop talking to this witness in that way. Why don't you take a seat and I'll deal with Mr. Kingma for the rest of the day. It sounds like we have an hour of Mr. Lumsden in the morning, and we'll use that wisely. If we can't finish, no one's required to finish by then. If they are unable to do so, we'll figure out another way to get him to connect with us. And we'll handle it that way.
Could I just comment on my schedule a little further, just so you're fully aware of it?
We respect your schedule. Some of us do. And if you need to leave, you need to leave. And we will figure out a way, Mr. Lundberg, to get the rest of your testimony if we can't fit it into tomorrow. Are you able to start at 8:45 tomorrow? We're going to start at 8:45 tomorrow. So if Mr. Lundberg could be here a little before that, we'll get him on the stand at 8:45 just to build in a little more time. But when he needs to leave, I trust that Investigator Alford or someone will signal and he'll get out of the room and be on his way. And if he hasn't finished his testimony, like I said, we will finish it. We're clearly not finishing this hearing this week. So folks shouldn't act like doors are being closed that can't be reopened. Anything else from the director's side?
Just to provide the panel with the document.
Okay, thank you. Mr. Kingma, anything from Judge Coomer's side?
You anticipated my question, obviously. Chuck, is Mr. Philhart going to be the last witness for the?
It depends on how long tomorrow goes. I would anticipate he will be the last or next to last witness. I would, depending on how it goes, I just want to give him a full day. If we still have I would prefer if it's Friday, we got 2 witnesses left, I would put Mr. Philhart up first, because I would want to have that scheduled to where he can get here at a set time and leave at a set time. And if we can squeeze that other witness in tomorrow afternoon too, great. But I guess we'll have to see how it goes.
TBD, but it is important to keep Judge Coomer's team posted as to when you're going to rest. So they're not surprised, though they have a built-in witness sitting at the table. That might require you to take things out of order. But Sometimes we got to do that if but I'm asking the director's team to keep you posted as it looks like we're going to wrap.
One issue for us is we've got a witness who's coming in from out of town, and we know we can get that witness in after lunch, for example. What's your level of confidence on that, Chuck?
You mean after lunch tomorrow or after lunch Friday? Okay.
It would depend if Mr. Philhart is up. My level of confidence depends on the level of cross-examination, I guess. So.
Based on how things are going, we'd be pleasantly surprised up here if Mr. Philhart was done in half a day. So you're going to have to gauge based on performance. Past performance is an indicator of future outcomes in this proceeding. So you can factor that in, and we'll see how it goes. But 8:45, Ms. Johnston, will you be with us tomorrow again? Okay. Okay. Are you able to let her know that we'd love to get started at 8:45? Fantastic. Thank you so much. Anything else?
Nothing further.
I'll keep Mr. King advised as we track along tomorrow where we're headed.
Okay, great. And good news about Mr. Philhart. Thank you.
Thank you.
Judge, I apologize for,
You apologize to the right person.
Yeah.
I saw it. It's all good.
I did need a good lunch, I will tell you that much. So
Well, address that tomorrow.
apologize. I did.
I can tell you Marietta pizza was good. That's
Yeah.
what it is. Very good.
I would say, let's talk for 15 minutes. You can work hard.